Besides this is obviously going to be, if you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or I
don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant, Matthew L. Moore, not guilty of murder, as he stands charged in count 1 of the indictment.
Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Hey, chat. How are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. El Chatty, don't be afraid to have an opinion in this chat. The minute you let the trolls under your skin, the mods will come in and make it better. Hey, Kimmy, go fuck yourself. You're not welcome in El Chatty. El Chatty will make you go fuck yourself. Don't come in here and troll Sean El Hefe. Hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, ladies, spread out your legs and put them well in the air. Judge White wants to spread them nice and wide for his pleasure, the dirty old man. Hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, chat, let's go, El Chatty, let's do it. Yo, yo, yo. How are we, beautiful people? Hope you're all well out there. Nice to see you nice. Good morning, good afternoon, good evening, whatever it is with all of you there. Bit of a different intro today. I just recorded it before going live. I couldn't listen to it. I could not listen to it again. A little bit cringe. But there we are. Christine, how are you doing, my darling? Followed you back on Twitter. How are you, Vivian? Hello, Vivian. Nice to see you, my darling. Sassy, as always, Sassy. Nice to see you, my darling. Deb, how are you, Deb? Hope you're well there in Rhode Island. SRA, good morning, all. And an extra special greeting to Ashley's hair ponytail today. I don't know. Will it be ponytail? Will it not? I don't know. It's a good question. I do wonder how she will do it. Good question, Sassy. Kelly, good morning, my darling. How are you? Hope you all had a good weekend. I did. Hope you did as well, Kelly. I think she's going to do the 2 braids today. Ooh, 2 braids. I like the braids, if I'm being honest. TJ, welcome back, TJ. How are we doing? Hope you move all right. Toots, hello, my darling. How are you? Linda, hello to you. Let's go. Chrissy, sorry to hear about your dog, by the way. Yeah, your daughter's dog. RIP to your daughter's dog, Chrissy. Hope you're okay. I know you're a crap Friday, but yeah, sorry, Vanish Friday. No need to apologize at all. Had quite the crisis. Well, I mean, yeah, you lost your daughter's dog. I'll be listening and behind, but think I'll catch up. There's not much to catch up on, if I'm being honest, Chrissy. There's not much to catch up on. You'll be done in like 10 minutes. But it's fine. Crime Junkie from Tennessee. How we doing, my darling? Good morning to you. Hope you're well. Good day, Shayla. How are we, Kirsty? Good day, mate. How are we? Putting the shrimp in the barbie. 10 o'clock at night. Woo! It's a late one for you. It's a late night in Australia, mate. Good day, Bruce. Good day, Shayla. Good day, Kirsty. Good day, mate. Hello to you. How are you doing, Kirsty? Hope you're well. Katie, hello to you. Katie Santos, good morning to you, my darling. Hi, beautiful chat. Let's all slap that like button. I see you. Has everyone done it? No, there's about 7 or 8 people who haven't done it yet. So please slap that like button. Good morning, Bev's crying now. How are you? Hope you're well. Bev's crying now. Hopefully you're all is well now. Just awesome opening. That was at the start. You didn't see the rest of it, so I'm not sure how awesome that is. But Baxi Jura, hello to you. Rain, go away. Come back another day. Not today. Another day. Chrissy, Bev, my daughter dog passed while watching on Friday, and I was trying to revive her with. Oh no, you had to try and revive her. Fuck, sorry, Chrissy. I didn't know you were trying to revive her as well. Shit. As I say, R.I.P. Yaya Trucker, good morning to you. Wishing you a wonderful day. Hope you had a great week. I did. Thank you, Yaya Trucker. Hope you did as well. No problems at all, Christine Fortunato. It's all good. Hello. It's going to be stuck in my head. Press the like, please. Press the like and subscribe. It would mean the world to me. If you liked and subscribe. Like and subscribe, motherfuckers. Patty Murphy, hello Patty, how are you? You already liked and subscribed. Happy day. Let's go, Patty. Toots is loving it. There we go. Your singing always cheers me up. Happy day, Sassy. Wicked Psyched, hello to you. Wicked Psyched, good morning. Not seen you for a while. I hope you're well, my darling. Thanks for popping in. Good morning, Fairy Land Acres. Good morning, Dylan and the crew. Happy Monday. Happy Monday to you, Fairy. Go fuck yourself, Kimmy. Good morning to you, Susie. How are you doing, my darling? Hope you're well. There you go. I think this is where you got my singing. Go fuck yourself, Kimmy. Happy days. Hey, Jessica. How are you doing, my darling? Hope you're well. Hello. Hey, Zach. How are you doing, fella? Nice to see you, buddy. There you go. Hey, Barbara. Good morning. Let's fucking go. The Dancing Queen's out. Good morning to you, Disney Queen. Carol Draper. How are you, my darling? Blessed Monday. Yes. Great intro. Thank you, Kirsty. Love it. Gary's back. Guess who's back? Gary's back. Good afternoon, Dylan. Hey, El Chatty. I know I haven't been in as I've been on holiday, but I'm back now. Yes, guess who's back? Gary's back from holiday. How did it go, fella? How was the holiday? I hope you enjoyed it. Lou, good morning to you, my darling. How are you? And baby Archie, hope you're doing well. So sorry, Chrissy, about your daughter's dog. I know. Well, so we had Lou losing the dog last week. Christy, daughter losing a dog this week. Let's hope no one else loses any more dogs soon. Gary, thank you so much, sir, for renewing your membership. I appreciate you, my friend. Thank you. Nikki, good morning to you, Nikki. Bobby, how we doing? I thought I said Booby for a second, but Bobby, how are you? So sorry, Chrissy. Goof. Hello, Elsie. I agree with everything you wrote the other day as well. Thank you, my darling. Backstreet Jura, so sorry, Chrissy. Here you go. There you go, sending so much love. Good morning to you, Karen. Stesney. Ooh, what a name. Look at the dogs. I love the dogs in the profile pictures. I can imagine. I pick up her ashes tomorrow. Oh, no. Poor Murphy. Oh, no. Oh, no. Coffee. I'm got my coffee as well. So sorry. Hello, Lisa. How you doing, my darling? There you go. Thanks, I'm well. I can't get into the trial just yet. Too emotionally drained after. I needed a trial, we could say. I needed a trial to get into because I was lagging for 2 weeks. I was on the floor. I just couldn't pick myself up at all for 2 weeks. I needed something, and I think this trial's been good. If I'm being honest, I think it's been good to get focus on something. Actually, I hope everyone's enjoying this trial. I think most of you are enjoying it, as in it's different. So and to see a different judge and stuff like that. So yeah, I got you. We could say I 100% got you. I could get you. But honestly, this has really helped me focus and give me like foundation to do something. So it's worked out well, I think. Good morning. Good morning. Hey, Dennis, how we doing? Hope you're well, my friend. Yes, I'm very well. Everything's well with me, sir. Hope you're well as well, my friend. Send my love to Brenda as always. Hope she's okay. Chopper, hey, you missed the intro, Erin. You missed the intro. Thank you for that as well, Erin. I'll pin that now. You missed my song. It went brilliant, and the weather was gorgeous every day. Happy days, Gary. I'm glad you had a good holiday. Thank you. I was writing a lot. I hope the judge lets the professional in. If he doesn't let, he will. I think he'll let the professional in, but with limited scope. I think he's going to limit it. Hey, Dawn. How we doing, my darling? Hope you're well. Finally get a reprieve from heat and humidity, not complaining. I can imagine it's nowhere near hot here, but still sweating. There you go. Good point. I missed too much if I listen. Have I missed? Yeah, the state of rested. There's probably another day and a half of defense. I think if I'm being honest, I think you've missed too much. If I'm being honest, because in my opinion, the state did not prove their case, and I think you need to watch that bit. We're on day 5, you know. Yeah, I do generally think you probably missed too much, Wicked. If I'm being honest, it could be hard for you to objectively catch up to it, because you need to watch the state. Because I genuinely don't believe the state have done a very good job of it. I would suggest that you look at Ashley Benefield's, the defendant, how she performed on as a witness, because I've never seen a prosecutor treat a DV witness, let alone a witness, the way she treated her. I thought it was disgusting. That's something to watch. But yeah, that's just my opinion. I don't think you can get into the trial objectively from that, you know. So no boring nonsense bullshit. Nope. I think so, Fairy. I haven't watched all this trial. I didn't have the time myself so too much, but the little bits I have watched, it seems good. Yeah, I've enjoyed it. I'll go back. I'll be back. Yeah, I like my intro. I'll play it again, so don't worry. Yes, enjoy Ty. I'll play it again. It's all good. It's all good, SRA. I'll play it again, Carol. Believe it, my it's chilly today. It's raining now. Autocorrect hates me. I know. My keyboard hates me. Space won't work. It was crazy to see other shows over the weekend. It feels just like kind of retrial. People are pretty mixed about her being guilty or not guilty. I'm only like I'm not even looking at the TV element of it like other people are and saying she's acting and stuff like that. I think that you can't tell that. I have to base it on purely have the state proven their case, and I would say no, they haven't. In my opinion. So forget about the whole TV stuff. I just don't think they've done it. So I've seen some really bad comments on Twitter actually about her. And I just don't. I don't know why I cringe at it, to be quite honest with you, because I don't feel like I can judge somebody and tell, oh, she's acting. I I I, I can't. I just don't feel comfortable doing that. I'll go by what the evidence shows me, and before she even testified, I thought they hadn't proven their case. That's where I sit with it anyway. But yeah, um I get mixed opinions on it, but I don't. I just yeah, I don't. It doesn't sit comfortably with me to judge somebody, and say that they're faking it. You know, I understand some people might be able to tell that. I just can't. Not in that environment. And maybe just I'm a big softie. I don't know. I agree with you on that she treated that girl terribly and didn't seem to care about she's a DV victim. Yeah. Well, she's making out she's not a DV victim, wasn't she? You know. I just, yeah, I thought, and I'm glad a lot of people thought it was this because I think whether you think she's guilty or not guilty, I still think that you should find that quite disgusting. You know, I don't mind if people think she's guilty. You think she's guilty. That's fine, but the way she was treated, I wouldn't want anybody treated that way. Disgusting the way they treated Ashley on the statement. I hope no one on the jury was triggered. It was disgrace. I agree. Stays not case and treatment to Ashley has been disgusting. Yeah, I agree. Baxi Jura. Hi, John. How are you doing, fella? Hope you're well. Nice to see you, man. Not guilty, LC says. I'm well. I always start every trial not guilty. So it just they've not changed my mind. You know, to a guilty vote. They still got rebuttal left, people. So you know, I might change it again, but for now, it's not guilty. Thank you, Chrissy. Thank you for dialing. I have seen enough to know what is happening and I'm up to speed on stuff. I agree with the state haven't proven the case. There you go, Gary. Oh my goodness, a song like and subscribe all weekend. I love it, Carol. I love the new song. Well, I made it up this afternoon. Literally, I sat down and I was like, you know, well, let's make a quick song. I can't listen back to it. I cringe. But uh, but yeah, I just want to make something quickly. Never thought I would have decided so early on, but I went with this with a clean slate. I didn't pay attention to the mainstream media. I think it's important because mainstream media was saying stuff like she shot him in the back. I came into this trial thinking that she shot him in the back, but she never did. You know, and I thought, how are they going to get over that? But she never did. So, and I've learned from Karen Reid, right, and other trials, but especially Karen Reid, do not believe everything you hear in the media. So I think I see a lot of people now saying like you know about Brian Kohlberger how he's guilty as fuck. Like I can't do that. I've learned my lesson that I can't go into a trial thinking that I know everything yet. I want to see all the evidence as it comes in. Um, so it makes me think like even though you do a deep dive, we don't have all the information. So yeah, I just don't feel comfortable doing deep dives anymore, to be quite honest with you, because we don't get all the information, and I think that can skew your view on it as well. So I don't know what I'm going to do moving forward with trials. I like a clean slate. I like to think like a juror, so I might just do that from now on. I'm not sure. Lady Lawyer was unprofessional. Yes. Do you not like it? My heart broke for her. My heart broke for her. You know, because I don't really want to misspeak here, but um, I know that it's difficult now for people. There's a stigma now that you know with DV victims after like people like Amber Heard and stuff like that. Some people question whether someone's DV or not, a victim or not. Um, I would always want to give people the benefit of the doubt. I'm not walking in their shoes, so I don't know. So I don't really want to judge people. So I find it quite tough. That's why I keep quiet about it a little bit, because I find it quite tough. I listen to you guys, your stories. It's a lot. It's a lot. Hey there, Lord Chaperoni. That song is hilarious. Happy days. Oh, don't worry, it's fine. Josie does not like caps, people. Just so you know, Josie does not like caps. She will delete your messages, so do not put caps on. But you'll be fine there, Elsie. It's all good. I don't even think going into this case, interesting that cousin Tommy, pervert Tommy, and Paul's family lawyer are repeat guests. Again, it's just the media pushing a narrative. I've seen a lot of streamers pushing the narrative as well. People going into this trial, and I'm ashamed to say lots of streamers have pushed the agenda. She's guilty. I'll be honest with you, this is why sometimes my streams aren't popular, because I'm always on the side of the defendant. Doesn't mean I will find the defendant guilty by the end, but I genuinely believe every defendant has a right to be found, to be tried as innocent unless proven guilty. And that's hard for some people, because they'll know some stuff from the media and then instantly go, well, I know this happened, that happened. Just take it all with a pinch of salt, people. I think we've learned that enough now. Okay, she's arrived in court. Oh, right, hang on, let me put her up. The stream, that is, nothing else. Nothing rude, don't worry. Put that there. Right, Gary, I never listen to the news and media stuff anymore, so I don't trust any of them. No, even deep dives, I don't. Thanks, Dylan. Thank you, Crime Joke. What are you thanking me for? To say hello to you. Hello. Beautiful inappropriate. Hello to you. Hey, good luck today. You got, I think, are you not having a wisdom tooth taken out today? And some more injections today? If you are, good luck to you, beautiful inappropriate. Hope it's gone well, or hope it's going well. Good hippie chick. Hello to you, my darling. Hope you're well as well. Let me unmute that. The lawyer of oh fuck, I'm way behind. Right, okay. Lawyer of Doug was a snake. Oh, I did not like her. Did not like her. Do we think something was going on there? I don't know, but I did not like her. I'm torn too. I think the time dancer is sus as F, and I don't trust her. But the state has not convinced me 100%, so I have to say not guilty. The DA Hot Mess Express team is gross. I agree. Again, I got no judgment on the TV stuff. It's just I don't think they proved it. I like the deep dive after. Yeah, because I think it's been dangerous. I mean, I know I am guilty with myself. I look at Annie Elise and all that, but just remember, all these people they sway one way or the other. And I like Annie Elise, don't get me wrong, and I do watch her all the time, but no, she doesn't have all the facts. So I always tell people, take everything with a pinch of salt. Hello, grilled cheese, Mayor Greg. How are you doing, Greg? Hey, Dilly, you sexy beast. How are you doing, fella? Hope you're well. ALC, I agree totally. Hey, Jem, how we doing, my darling? I can't wait to meet your husband, Jem. Tell him that you think that he looks like that paralegal. I felt so hard. I was in tears with her at the end. She couldn't even continue. I know. I felt bad. I was gobsmacked. I lost for words. There you go. Carol agrees there. I'm going to check out the defendant's testimony. What day of trial? It was yesterday. Day 4. Basically, I think if you go to my channel, day 4, it'll say only Ashley Benefield testifies. It'll give you the chapter. You can start from there. It's something they should. It's for a couple of hours. It is, but it's intriguing. So it's bookmarked essentially. If you go to my day 4. Yes, I think so many people go in with a guilty until proven innocent. A lot of streamers, most streamers, right? You'd be surprised how many of them are guilty unless proven innocent. I don't, and they're the popular ones. A lot of them are popular ones. I can't work like that. I can't. I think it's backwards. And a lot of reasons people do that. I'm not trying to bash other streamers, but it's because I'd guess about 95% of people of trials they end up guilty. So everyone's like, "Oh yeah, I told you he's guilty." Well, I mean, Friday she took the stand. Yeah, so day 4, it was Friday Wicked. Screw them. Yeah, it's just the truth today, and I'm nervous as fuck. Wisdom tooth. Do you know what? I had a wisdom tooth out, beautiful and appropriate. and I was scared shitless, but it's fine. I found it fine. What I did was I took 2 ibuprofens straight away after I left it. I sank 2 ibuprofens, and then um, 2 hours later I put 2 paracetamols, and 2 hours later I put two Nurophens in. Didn't feel any pain. That worked for me anyway. I was fine on it. Yeah. Hippie chick, do you live in Maine? There you go. Here, like that's a gift from God. Even listen to the dark hair DA. I might have to mute when she talks today. Good morning, shop ma'am. Hello to you. No worries. Thank you for being here, shop ma'am. Different hippie chick. I agree, Erin. See you later, Wicked Psyched. Let us know what you think. There you go. Afternoon, Script Wayne. How we doing? Hope you're well, fella. There you go. Right. Let me play the song again then. Oop. Straw after the Wizard Twitter removal. Oh, yes, you're right. Yeah, you're right. Told her. Arrogant that she is. Oh, yeah, I agree. I'm going to be sedated. Oh, okay. Oh, okay, you be fine. You be fine. Both of the and the nasty. Yes, I agree. Rebecca, hello, my darling. West Virginia, Mountain Mama. Hugs. Right, let me play this then for those that are just new coming in. Here we go. This is a new song for El Chatty song. Hey, chat. How are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. El Chatty, don't be afraid to have an opinion in this chat. The minute you let the trolls under your skin, the mods will come in and make it better. Hey, Kimmy, go fuck yourself. You're not welcome in El Chatty. El Chatty will make you go fuck yourself. Don't come in here and troll Sean El Hefe. Hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, ladies, spread out your legs and put them well in the air. Judge White wants to spread them nice and wide for his pleasure, the dirty old man. Hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, chat, let's go, El Chatty, let's do it. Hey, how was that? Similar Express, Similar Exp. Hello to you, Jim, isn't it? I think your name's Jim. Hello to you, Similar. There you go. I hope you all. What's that? I hope you all liked it. I like that. There you go, John. Hey, Kimmy, go fuck yourself. No, not Kimmy. I hope. Sorry, new people. Is it too much? Is it too much, Aaron? Do you think I should not play it? Unless, and it's one of those like might have some explaining to do. Maybe I don't know. Thank you, Jessica. Hey, and hello to Logan and Carter, by the way, as well. Love it. Thank you, hippie chick. Regular schedule will resume shortly. Definitely going to be had to be there. Phrase. Oh, I might not be able to play it then. So we'll be proud or horrified, not sure. Leslie Ann, love it and the effort, and definitely Kimby, go fuck yourself. Is Perky Tom in there, mate? I'm not sure if Cousin Tom's in there. A little bit. The spread your legs is a wait. What more? Okay, I won't play it after this trial. Then I won't play it anymore. But everyone here knows, surely. But after this, I won't play it. If you know, you know. It's too fucking long. Jesus, SRA. They said hi, hey Logan, hello Carter. I meant Perry, Tom, Pervy, Donna. Where was Granny? Granny. Oh yeah, forgot about Granny. I only just did it before I went live, about an hour before I went live, so I didn't actually prepare anything for it. So, but yeah, forgot about Granny. I don't want to overshare. Been having a hard time lately, in this chat makes life so much more bearable and joyful. And you're singing in the chair on top. Thank you, Carol. Thank you, my darling. Thank you, my darling. Appreciate that. I need glasses, Wayne. We need to go F yourself, Kimmy t-shirts. Play it in a member's life. Oh, by the way, as well, just so people know, the shop, I've kept it open for 1 more month. I wasn't supposed to, but I forgot. I've prepaid it, so the shop is open for 1 more month. 1 month only. 1 month only. So shout out to the Moz. The Shopify one's open for 1 more month. Then we revert back to the other one. Play it in a members live. Yeah, I should. That's where I should play it from now on. Intro towards a members live. I love the song. Yeah, it's just people get offended by it, you know. So, which is fine if you know, you know. But I just can't be asked with the problems from it. Spread your legs. I wonder if Judge knows. Yeah, I don't think he does. You watched what Granny did. Someone tell me, please. She just told me that she didn't like my thoughts on this trial, and that she would be leaving this stream the next day and finding another streamer that aligned with her thoughts of view, basically. So yeah, she did not like my view. I don't remember what my view was. Generally don't remember, but she did not like it. That's for sure. Working hard to change my name back for emails. Remember, thank this time. What? Working had to change my name back for emails. I remember that. I remember thank this time. DNS disposal. What the hell? What? Who's DNS disposal? What's your other name? Because I don't know the name for that. Good morning, Goof morning, Dylan was in chat. Hello, Stormcar. How are you, my darling? I was just replying to you saying, oh, okay, yeah, I'm a little bit lost in chat. So thank you, my darling. Lou, hello, Lou Hillier, and thank you for the hearts for Carol Draper. We all love Carol Draper here, Disney Queen. Carol's a big supporter of this channel months and months ago, way before Karen Reed and all that. There's Pervy Tommy. You can see him. Oh, he's gone now. Everyone here knows it's all good, chappy. Keep it for this trial. Then after this trial, change that verse. Yeah, I want to know it'll be gone. I won't play it anymore then. Look exactly what Granny Pan said. Go fuck yourself, Timmy, t-shirts and coats, and add an El Chatty. And people want Carmy tits as well, so grab a Granny.
All right, good morning, everybody. We're back on the record and state. This is actually Benefield 2020 CF 3014. Thank you for your patience as we've gotten started this morning. First thing, we had early this morning, a juror call in that there was some car trouble. Juror was running late. My understanding is all the jurors are here and they've been brought up. And then obviously I've had computer problems this morning. So we'll just get going. Anything you need to bring up before we resume with the defendant's case in chief.
Judge, the clerk notified me on Friday that we had not actually entered states 103 and 104. So I would like to go ahead and enter those. I don't know if the defense has an objection. We can do it in our case in rebuttal if we need to, but we did talk about them during testimony. I just didn't say the magic words.
I just don't know what 103 and 104 is.
I don't either.
Modeling picture and the mugshot.
Oh, actually, yes, we do have something to say about that.
All right, so you're just going to save that until your rebuttal? Okay.
Yes, and then just to put on the course.
There's a discovery issue with respect to those two photographs. We were never provided them.
Well, the mugshot.
All right. So I'm making a note that we have to have a Richardson hearing on that issue then.
And also just to, for scheduling purposes, at some point, hopefully before, right at lunch, I would like to have a discussion about whether the court would allow the state to introduce evidence from Dr. Broder that we had previously talked about before. I just wanted to get a ruling from the court so I know whether to get him here or not.
Okay. I don't know what evidence it is, so I'll just wait for you to bring it up.
Okay.
Defense, any issues before we resume?
No, sir.
All right.
Ready.
State, you ready?
Yes.
All right. You said ready.
Yes, sir.
All right, just want to make sure. Are you feeling all right?
Yeah, picked up a little cold, but I'm good.
Same here. So I understand. Okay.
So they never said what was ruled. No, she's not on the stand. So she forgot to enter. Yeah, they can't enter evidence for rebuttal. She forgot to officially enter the two photos, but they can introduce in rebuttal. So they didn't tell us about this witness, whether he's allowed to testify for everything or what. So I'm not really sure what's going on here. The attorneys probably know, but for those of you who don't know, this is an expert who had to do a proffer on Friday. So I'm not really sure what's going on with this witness. I think they forgot because it's the last item to put in, and they must have forgotten, whatever. But yeah, they'll put it into a rebuttal now. A rebuttal is like another case. They can bring people in. Yeah, this is why I'm not sure Baxley Drewer and Hippie Chick. I don't know. Hey, Heather.
Good morning. I don't know who had car trouble, but I hope everything worked out and you've had time to kind of calm down from that. So we're going to get started. As when we left on Friday, the state was presenting the defense was presenting its case. I do need to ask you, though, before we get started, because we just had a couple of days off, did anybody discuss the case amongst yourselves in any way? Did anybody discuss the case with anyone outside of this jury? Did anyone do any research or watch any coverage at all about the people, places, things, or legal topics we've heard anything about?
No, sir.
All right, everybody says no. Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Bruce Ferris.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case. Just have a seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need. And you just speak directly, the loud, clear voice into the microphone. It should pick up everything.
I will. Good morning.
Good morning.
Will you tell us your full name, spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of trainings, seminars, and certifications, and various conferences. In my curriculum vitae, I'll call it a CV, my resume. There's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general. And I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida for 20 years. I graduated the police academy in 1993, got sworn in 94, and I retired in 2013. The last 10 years of that career, I was a detective, uniquely running. I was the lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time, when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
Mr. Ferris, give us an idea of your professional credentials. Lightly.
Sure. I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. In case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel. And it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also, I was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of Johns Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll stop there.
And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Just a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Varnes Award for Outstanding Achievement in Prevention of Domestic Violence Against Women. I had recognition for valuable contributions in what's called Crisis Intervention Team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation. I'll stop there. There's a few more.
Have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60 some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batter's intervention, effects of DV on children.
All right. And when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense. And a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know it's battery, ag battery, assault, ag assault, false imprisonment, sexual abuse, et cetera, person crimes involving a family or household member against each other. And that has another definition, that's spouses or family members living together, or it could be a couple that had a child together and have never lived together. It doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now, they'll use the criminal things, hitting, et cetera, all those things. But in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the BIP class. I'd like to explain the Power and Control Wheel, if that's okay.
In fact, with the court's permission, we could perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay. Judge, may I stand here and pay attention to the mic as I talk?
Any objection?
Okay. So as I mentioned, there's the criminal definition.
Was there a question? Objection. Was there a question?
Go ahead with the question.
Yes. What is it that's on the
Right.
screen?
So what
Mr. Ferris?
Okay,
Mr.
so-
Ferris,
yes,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, making shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do the legal things.
I have a couple of questions I'd like to ask you about that wheel that you demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the power and control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Batteries and Prevention Program class I talked about, and it's taught quite readily all across America and by use by domestic violence shelters, et cetera.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions upon the Duluth Power Wheel?
Yeah, the DCF accepted the power and control wheel for the curriculum for the VIP class.
That's the Florida Department of Children's and Families.
They were the ones who were controlling the VIP class when it started up. Also, a lot of federal money, domestic, against women act, things like that have always promoted the power and control wheel bill, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at the least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men. And
are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 1 to 25% male victims. And I just got a male victim this past week.
Okay, so look.
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3. Is that correct?
At least 2/3. There's some statistics to make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Cheller. Can I make one closing statement about the Duluth wheel?
Sure.
Power and control. So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those the battery, or they use emotional abuse or intimidation, or use different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get into a compliance, I call it equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply. They get this compliance mode, and they can certainly appear to society that nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right, so this wheel then is the product, if you will, of the science of domestic violence over the past 30 years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I've arrested, I see this repetitively to be true.
All right. Now, would you please tell us?
Oh, I do. Thank you.
I need you to make sure you keep your voice up so that
Yes, sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so
object to non-responsive.
Okay. Can I explain why they abuse pets?
Yes.
So if a pet belong to the female or their partner, the victim.
I'm going to object.
Can you approach, please?
Oh. He just goes on too much. It's because what you want to be careful of is that you don't want to lose a jury either. He's got important stuff to say, so just go straight into what you need to say. It doesn't need to be a long witness. Hey, Paul, nice to see you, my friend. Linda, boy, is he putting out there? Yes. Aaron Haag is related to you. Hackster. He feels he's got to dump it all out there. Where it's like we don't need to hear all the narrative. And it's not to say it's not important. It's just you're going to lose the jury. The jury just going to be like, oh my days. And when he comes to the important parts, it's going to be like, oh, ole, 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 ole. Erin Haag, ole. Erin Haag, ole. Donna, hello, my darling. This guy could talk a dog off a meat truck. I do. The alternate corner at hotmail.com. That's the alternate corner at hotmail.com. As patient, is he an expert in TV? He's an expert in TV. He's based everything from the findings, which will probably come out now. But he met with Ashley for about 15 to 20 hours. But his conclusion in this case is not based on that. It's just based on the evidence that he's received. Leslie, there you go. I knew we'd make you dance. Hey. Thank you, Erin. Too much information can be bad, as you won't remember it. The jury may be bored of him quickly. Yeah, they get to write stuff down, but come on. Yeah, you will be doodling. That's all you'll be doing, Gary. He's worthy. Yeah, he's very experienced. He's very educated, but.
Mr. Ferris, would you describe for us what the term coercive control means in a domestic violence relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
all right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And
what is the victim trying to accomplish by engaging in the appeasement behavior?
Not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
I have the same objection as at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern? Excuse me. Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
And I can say a very high percentage, well, I don't know, over 90% I'd estimate of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone. It's one of the 8 categories is minimizing, denying, and blaming. And it's all a technique that she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes. Very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there, there's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions.
Certainly.
Involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
Why are you objecting to hypotheticals? He told them what the hypotheticals would be on Friday. He told the judge, these are my hypotheticals. So why is she objecting now? Unless, I don't know, we'll see. Those are people that might be new here. Hello to you all. Hope you're all well here. Most people are very friendly here. 99.99% of people are. But yeah, welcome. Please say hello in chat if you're able to say hello in chat. We love getting to know people here. We got 70 odd people here, but not 70 odd people have said hello. So feel free or don't. It's fine. I know it can be quite daunting as well to say hello. And I know some people are working and not able to chat, which is absolutely fine as well. Good morning, Lorraine. How we doing, my darling? Nice to see you. To see you, nice. How we doing? Lorraine KD. What's the KD stand for? I meant to ask you that before. They agreed to hypos. Well, he mentioned to the judge what the hypotheticals were, but we obviously don't know what the judge has allowed since then. But yeah, they know what they are. Hello, Mary. Mary, quite contrary. Lovely to see you, Mary. How are you doing, my darling? As always, lovely to see you. Sidebar, getting as bad as Bev. Look at Dennis Sweeney in the house. Hey, I hope you sent my love to Brenda as well, Dennis. I love you, Dennis, but obviously we love Brenda more. Joking, Dennis. Can you check your email? I will in a second. I can't do it right now, but I will do it in a second now, Wayne. The fact the prosecution is so scared of this domestic violence expert, yet they don't think she's part in this. The prosecution should want to know the truth, not convict because they want a win. We've had so many discussions about this. Prosecutions do not give a shit. They just want to win. They don't care that she may be innocent. It's terrible. I hate it. Mama Ames, hello, my darling. I found myself singing your press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me. If you'd like to subscribe. Like and subscribe, motherfuckers. Over and over while running the vacuum cleaner this weekend. Happy days. Happy days. I'm a new song. Hopefully you like my new song, which I'll only play during this trial because it's quite offensive about ladies putting their legs up and stuff like that. So yeah, that's a little bit offensive maybe if you don't know. I don't want people to come in and go, why are they telling me to put my legs up in the air, shake it around like you just don't care? Hey, Dennis from Terry. Lorraine is my middle name. KD. Oh, okay. KD's my first name. Dominic is my last. Okay, KD can indicate the pronunciation of my first name. KD, fine. I got you, KD. I won't remember that, but fine. Because to me, you're Lorraine. Cheapers, Lorraine. The problem with the prosecution has with the hypotheticals in his testimony is that it's devastating to their theory of motive. I agree, Leslie Ann. I agree. Alison Miles. Hello, Alison. Good afternoon, Dylan. Love your shows. Thank you, Alison. Thank you so much for your contribution. Thank you, my darling. Thank you. Thank you, Dan.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking, throwing the loaded gun at the victim, cruelty to pets, punching a dog in the face hard enough to knock the dog unconscious, throwing a cat down the steps, placing a tracker on the victim's car, an illegal tracker, throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control wheel and right off my experience. They're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing, would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So, yes.
Lastly, one other factor I neglected to mention, would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
Ooh.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question, as it relates in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about
Sustained.
Yeah, just
so yes, definitely they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Ferris.
State, Cross.
Thank you, Judge. Good morning, Mr. Ferris.
Good morning.
Mr.
Okay. Oh.
I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame.
Yes.
Okay. Making excuses for him.
Definitely.
Or her, I guess, but not reporting the abuse.
Right.
Dropping charges if they were filed.
Yep.
Not standing up for themselves.
Yes.
And not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each.
Sure.
Okay. Sorry, Judge. While she's fixing it, and I know you're familiar, and do you have a copy in front
I
of
do.
you?
I
do too.
I want
do
right
too.
in front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody This says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse.
Mm-hmm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the question?
So if in this wheel,
Right.
hypothetically, we're not talking just about using economic abuse.
Right.
Would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mm-hmm.
No financial dependence on
Mm-hmm.
the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
Okay. And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think. Living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children,
Mhm.
if the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it. I'm just asking hypothetical
Okay.
questions. How about the using a male privilege?
Mhm.
If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles. And when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man. I purchase things. I control things for you. I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mine. I think it kind of goes with the economic abuse. And what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else? And he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What, you said that was present in 90% of the cases.
Quite a bit, yes.
Right.
Mhm.
I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things. Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that.
Okay.
Because it could be that part of the strategy of minimizing could be that, I'm sorry, I didn't do it. That could just be minimizing.
I'm sorry, no, not I didn't do it. I'm sorry I did it.
Right.
That's part of
That's still-
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I guess
facts.
I need an explanation on if somebody takes responsibility for accusations against them, how
Right.
that is minimizing. Just to say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
If that person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right, certainly it doesn't deny that it happened, that's for sure.
Right,
Okay.
and no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel.
Right.
And whether or not, if somebody, under my hypothetical, admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in the scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry, I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no,
Yeah,
it may not.
yeah, I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. If there was
I
a
know, I'm
scenario.
not, you are.
Would you take into account, based on, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay,
She tells him that she does not want to be with him,
okay.
and she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence, but that's it. She's not appeasing, she's not put an emotion, the whole power and control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy. That's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
yes,
with no allegations of emotional abuse in years,
no.
It's your opinion that not good enough. They're still on this power control.
Well, all I can speak from my critical learning and studying this, and also my practice. And I have custody issue couples where they're domestic violence, and 10 years later there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank you for all your help.
Well, he was good. He was better today than he was Friday. And he held his own. He was taking no shit from the prosecutor.
All right, Mr. Taylor, call your next witness.
Gina Torchia, Your Honor.
Judge, I think we're going to have to approach whoever comes in first. Thank you.
Okay, they're approaching now about this witness. I don't know what's wrong with this witness, but they want to approach the prosecution too. Daffy Dill, hello to you. Welcome to you. Where are you from, Daffy Dill? Because that's a pretty Welsh name, that is. Whereabouts are you from? That cross was not helpful. They started dating, I think, 2018. No, 2016, sorry. And he died in 2020. So they were married after 13 days and then obviously on and off wherever. They are calling quite a few witnesses. Yes. They're going to put a lot on. He said about 2.5 days total. We've had one. Well, we didn't really have one day because it's about half a day we've had. So probably resting, I would imagine, Tuesday. And then the the prosecution want to put on a rebuttal case, which I don't know how long that's going to be either. Unfortunately, Rebecca, what's going to happen is they're going to put other charges on, I imagine. They're going to put in like a manslaughter charge, which I hate. I hate that if they put manslaughter in, because that is the like happy medium where we're like, oh, okay, I can't find a guilty for murder too, but you know what? I can find a guilty for manslaughter, involuntary manslaughter. I hate that. The prosecution doesn't want any of the defense witnesses on the stand. Well, no, it doesn't seem like it, but most of them are their witnesses, I think. They're recalling a lot of witnesses. Michigan, oh, there you go. It sounds very Welsh. Daffy is like daffodil in Wales, and Dill, the Dillis. Did she hire these attorneys? Yeah. It's only one attorney. It's an attorney and a paralegal. So, yes, she did private hire them, Jodie. He could rest his case today and the state will lose. Do you know what? I don't disagree with, but then we don't know what the jury are thinking. Do you know what I mean? We don't know we've learned from Karen Reid. I think do it. Just put everyone on there. Just put them all on there. Quash any doubt people have. I think just put them all on. Even though I think we agree, Deb, I don't trust juries anymore, and it's not their fault. It's just it's hard. We need to make sure they get it. They absolutely get it. Because a lot of jurors don't know what reasonable doubt is. Were you a member of an old chat board called Hippie Chick? Let there be vines like 20 years ago. Sorry for non-trial posts. That's fine, John. It's fine. Married after 13 days. Yes. Yes, that was some serious love bombing. I'm guessing by him. Yeah. I'm guessing she hired them. Yes. I have always been nosy during trials. I like watching the family's reaction to witnesses. Was Eva in there for that? She was in for some of it, and then she stormed out on some already. She came in late in this one. She came in late. They will throw in any charge they think they could get. Yeah, and I hate that. I hate if I would wish there was a rule to say if you're going to change the charge, if you want to add additional ones in, then you've got to take the higher ones out. Like you've got to take murder out then. There shouldn't be a murder and then just put extra ones in just in case. I hate that. I also can't remember watching a case with a rebuttal phase, usually just closing argument. Yeah, no, yeah, so this one's normally self-defense, you normally get a few. And depends with these guys how many they got, I don't know. But you're right, that normally there's not many rebuttal cases, you're right. Married after 30 days because he was already at play. I married 3 months after meeting him. There you go. Defense might rest today. We were left for defense. I don't know. We haven't got. Hey, hi, Raoul, by the way. Nice to see you. We don't have a list, you see. So, no idea. Didn't even tell his daughter that she was moving in. That was emotional abuse towards his daughter. She didn't tell her daughter they would get married. I'm wondering if something from Eva will have some suppressed memories pop up from her mother. I feel for Eva. I do. I just wish there's a few things she's doing in a minute. Keep off TikTok, Eva. She's on TikTok all the time, and she's coming in and out of the court. It's like, you need to decide whether it should be a rule if you're not there for a witness that he can't come in. She keeps coming in and out all the time, and I know I'm sympathetic, but this is also a trial for because the jury keeps seeing it. It's not good.
Defense calls Gina Torchia.
Oh, nice.
You solemnly swear
Nice,
affirm the
Duffy.
testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
I do.
Bobblehead.
Actually, as she's sitting down, attorneys come back one more time.
Oh, attorney's back in. Linda says it doesn't do what has been done. I feel bad for Eva. She's been through a lot, but she's also acting immature. She probably doesn't have any guidance from any family. No, I agree. Like, I've got no hate for it. Just, I've also, this goes back to the Karen Reid stuff as well, or another trials. it's just remember it's the defendant that's important now, because Peggy is obviously crying and all that, laughing and stuff. It's like it's not appropriate, because everyone wants justice for Eva, or Ava, however you say it, but we got to be careful. You did need to take the whole top off, love.
Hello, ma'am.
Good morning, Your Honor. How are you?
Good. Go ahead and have a seat. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. You want to be about 12 to 15 inches from that microphone. You can adjust it up, down, left, right, however you need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Hey, Spicy.
Good morning.
Good morning.
Would you tell us your full
Lisa.
name, spell your last name, please?
Gina Torchia, Torchia.
Ms. Torchia, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torchia, what I've marked as Defendant's Exhibit number 25, and ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Oh,
All right, now,
Defendant Exhibit 25 will be received.
Ms. Torchia, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torchia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Can you slow down just a little bit?
Oh, I'm so
Thank
sorry. I'm a fast reader.
Okay. Well,
Sorry about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay.
6 months of the date of the hearing.
Which was May, November, which was May, November 3rd.
Ms. Torchia,
Yes.
I'm sorry. Would you start over, please?
Yes, sir. Gina, I noticed something that you both need to be aware of. Unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So lastly, Ms. Torchia, this is Detective Gillum telling you that the order was in effect, the stay away order,
Objection.
as of November 3rd. 2017, correct?
Objection.
Sustained.
This is Detective Gillum explaining to you.
Objection asked and answered. She read the email.
Sustained.
Just a moment, Your Honor. This is for sending. Ms. Torchia, let me pass you what I've marked as Defendant's Exhibit 26.
Can I see it, please? Can I see it? Can we approach this?
Oh, sorry, I missed that. My niece has been here. My sister's car alarm kept going off, and they're now going. So I'm back. What's going on? I can't believe what Lisa's saying about that, but yeah, interesting. Anyway, so here we go. Sean, how we doing, fella? Paul, how we doing, fella? Hope you're both well. Oh, the bloody alarm's going off again. Thank you, Jen. Sidebar again. Yeah, I don't know if this witness is any good. How are we rating this witness? Let's look at the bottom of the back.
So, Mr. Torchia, let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gillum.
Yes, sir. Yes, this is the order.
Yeah, without referring to it, my question is only, did you, in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gillum?
Yes, sir.
And then he responds to you a couple hours later with the email.
Yes, and there's also
no further questions, Your Honor. Thank you, Mr. Torchia.
Any cross?
Can you finish your answer, please?
Yes. There's also a predicament where Detective Gillum, there was no order entered in to the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to disregard, Your Honor.
Members of the jury, testimony regarding an opinion's witness about violation of criminal law is inappropriate, and you should disregard those last comments. Anything else?
That's sufficient. Thank you, Judge.
Redirect?
No.
Can the witness be released?
Yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Mr. Taylor.
Your Honor, I wonder if we could publish the exhibit that we have.
No.
Thank you, Sean. Appreciate that. Thank you for the super chat, Paul. Thank you. Yeah, anyone who wants the merch store, whilst we wait for the next witness, it's available for another month. Then I'm going back to the other one then. I forgot to cancel it. But if you do want to buy anything for the merch, so make sure you buy from the correct country. If you're from America, buy the American merch. And the UK, buy the UK merch. Thank you, everyone. Thank you, mate. Hope to see you soon, Sean. See you soon. Water. Pretty hair. Good day, Steph. Good day, Sheila. I have sung Erin Haag once today. I got a new song as well, which I'll play next break. Good day, Steph. Right. Ole, 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 ole. Ole, 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 ole. Erin Haag, Haag, Haag. Erin Haag, Haag, Haag. Ole. What's going on? Quality of his apparel is beautiful. Ooh. New song for you. Oh, Sheila. Just because I like how you say Sheila. Oh, Sheila. Good day, Sheila. I spoke with a chap from Wales on my CBSSB radio. Oh, CB radio. A couple months back, he was in Peacock. I'm outside Boston. That's cool. Look at that, Sean. I need to get Dennis Sweeney a CB as well. He'd be great at the CB as well. Dennis Sweeney, Sean, yourself, Berth, Sergeant Murphy.
I think we're gonna have to approach.
Okay, well.
Shut up, Paxter. Approach again. Let me play the song then. Let me play the song. This is my brand new song whilst we're waiting. Hey, chat. How are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. El Chatty, don't be afraid to have an opinion in this chat. The minute you let the trolls under your skin, the mods will come in and make it better. Hey, Kimmy, go fuck yourself. You're not welcome in El Chatty. El Chatty will make you go fuck yourself. Don't come in here and troll Sean El Hefe. Hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, ladies, spread out your legs and put them well in the air. Judge White wants to spread them nice and wide for his pleasure, the dirty old man. Hey,
all right, members of the jury, I think it's a great time for our mid-morning break. So I'm going to sit you out.
I'm pleased.
About 10 minutes or so. Feel free to use the facilities. You can use your phones if you need to send or receive text
Remember
messages, emails,
that you're all
phone
called
calls,
El
anything like that. Please don't begin
Even
any sort of
Heather,
deliberations or
who
discussions amongst yourselves
is
about the
El
case. Discuss the case with anybody outside the
Chatty.
jury.
Hey,
But
Chat,
don't
let's
do any
go, El
research on
Chatty.
the
Let's
people,
do it.
places, things, or legal topics we've heard anything
They're
about.
going to break, they
And
have. They're
10
going to
minutes,
break.
15 minutes, because
They're just going to break there.
as well. So, see you back in a few minutes.
Hey, thank you, Paul. Thank you for the super chat. Stand up tomorrow, Mass State House, 3 till 6, free can read. Yes, there is. All right, what are people saying about the... What do you think of the song? Is it okay? Or...
Y'all can have a seat. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Miss Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. With
You had it right so far, good.
All right, so this isn't marked. Is it, did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Miss Benefield went to the telephone reporting unit on December 6, 2019.
Phone call.
That Miss Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. That she has observed him driving behind her on multiple occasions, which concerns her. And she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed. All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information. But anything contained in this report is hearsay other than that Ms. Benefield physically appeared at TRU on December 6, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay, in the state's opinion, Judge, because it's self-serving hearsay at this point. It's actually hearsay within hearsay, I think. That if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in. And I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about it. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was who was the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott
Lindsay.
It's on the top of the report.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling it for, so.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So why don't you guys take 10 minutes?
Thank you, Judge.
Court will be at recess for 10 minutes.
I'm on mute. Where are we? Oh, let me take these off for a second. Get my ears. It's hot. It's getting hot, hot, hot. It's absolutely blue skies here in Wales. It's just, no air conditioning, no fans, no nothing. It is a little bit hot. Oh, yeah. So what's happening? What's going on? Let's look at the poll then. We've got a poll up. Question is, where do you currently stand if deciding on a verdict now? Guilty or not guilty? And if you are undecided, that means it's not guilty. So 73 people have voted. 8% are currently guilty. 92% are not guilty. Okay, so that's a lot more not guilties than we're used to. I remember when I did this last week, it was like 60, 40, 60 not guilty. Now it's 92 not guilty. It's really hot here. Oh, yeah, Blackpool. How is Blackpool? It's boiling here in Wales. It's nice though. I agree, Daffodil. He's a great example of a fair judge. I do like him. Don't agree with everything he does, but I do like him. And what I like about him is if he goes to appellate, he puts his decisions down. There's no Bev, like not wanting anything on the record type thing. So I adore Steph, Sheila. Oh my god, I adore the Hey Jude, Hey Chatty, El Chatty edition. They did. Oh my god, stepping up or what? Yeah, I after I did it, Hackster did point out though that it's okay for now, but can you imagine if we did a trial in 2 weeks and people were like, you're a new person walking into this stream, and especially if you're a lady, and I'm saying, put your legs up in the air, spread them out. Not very, not very nice. So I won't play it after this trial. Will not play it after this trial. But I think it's funny. I only made it up today. I mean, I could probably do better, but it is what it is. It is what it is. But thank you. Yes, he is. Be right back. Go get some ice cream, Vic. I'm jealous of the seaside view. Gary, yeah, Blackpool. The Las Vegas, or it used to be the Las Vegas of the UK, not anymore, but it is. That's what they used to call it, Las Vegas of the UK, Blackpool. It's gone downhill a lot since then, though. But the land is hot and humid in Missouri, typical for summer, but we have AC and fans. Get yourself a cheap fan. It's not that bad here. Do you know what I mean? It's worse outside, obviously. I got windows open and stuff like that. It's okay. I'm sweating a little bit because of the heat, but it's fine. My son does Bob Dylan. Yay! Genty with Keithy. Keithy, he is sleeping. Wake up, Keith. Wake up, Keith. Haxa says, no, 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 there's no limit. No, 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 Aaron, no, no, Huckster, no, no limit. Ain't no huckster to reach for the skies. No mountain too deep, no valleys, no mountain too, no valleys too deep, no mountains too high. Aaron Haag, 4 for 1. Da, 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 da. 4 for 1. I love it. I love it. If you do you and play as much as you want. No, you're the boss, not me. I know from time to time a granny prude stops by. That's all. I know. This is why I got mods. To put me in my place. Erin is the fun police. People, she's she's not. She's looking out for me. I do understand that somebody, if you're new when you walk in and I'm singing about spreading your legs up in the air, it's not very good look, is it? So yeah, I mean the joke's a joke. Like the whole Kimmy thing, I'm keeping that in because it's funny. I know Blackpool isn't it anymore, unfortunately. Yeah, I used to love Blackpool. I still like Blackpool. It's raining cool here, but going to be 90s later this week. We go. I need something too hot for me being to the dungeon. Madame Tussauds got a tattoo. Did you? Okay. If I'm gone to the circus, I'm not going. My legs and feet hurt too much. Oh no. Maybe at the end of the year, do a song with all the funny sayings or bleeps done over the trial we have watched. Yeah, I'll do something. It's all good. I'll do something. Hot is relative. My son's team got back last night from a basketball tournament in Las Vegas. Oh yeah, it was 118 to 125 whole time they were there. Vegas this time of year, I know. I've been to Vegas this time of year before. It's boiling. Hackster. Toots. We're supposed to get rain later today in the 70s, Daffy, Michigan. They're on Lake Erie. I called him twice and text all morning. He's out, lol. I'm gonna try and get him up. I kept him up late. Smiley face. Oh, Jen! Poor Keith. Poor Keith. I'm sure he's enjoying himself. Leslie, yes, also subjective depending where thermostats are placed. Well, to be fair, Kimmy should go fuck herself, so you kind of have to leave that one in. Yeah. Oops. Just change it to spread your arms up in the air. Newbies will think you mean an air hug. They'll know the truth. Yeah, that's true. That's true. I could do that, Leslie. I didn't even think about it, to be quite honest with you, because it's something funny that happened here. But you're right. Somebody will take offense to it, so I will change it. So based on the poll, Ashley taking a stand was beneficial for her case. I think so, Raoul. We were probably, I think, before she took the stand, about 55, 45 towards not guilty. And now look at it. So I think so. Kimmy is Lady Di. Kimmy is a user, troll, that used to come into the streams when Karen Reid trial was on, and she would abuse El Jefe. She'd say not very nice things about El Jefe, Sean. So Sean went on a rant one day and told Kimmy to go fuck herself. Because I don't remember what she said, but it was not nice things she said about him. And Sean wasn't happy. And I was like, what's going on? He goes, I'm sorry. I gotta tell Kimmy, go fuck yourself, Kimmy. So we've kept it in ever since then. So Kimmy, go fuck yourself. So that's where the Kimmy originates from. It's hard to keep track of everything. I need to change the emojis now away from some of these things. Oh, she said he had dementia, yeah. So she said that Sean had dementia. That's what it was. That's not very nice to say to somebody, so thank you, Jen. Okay, thank you, Dylan. They have nothing better to do. Sucks for them to live that kind of life. Absolutely. You probably got 20 different accounts jumping from one to another. It's probably Julie Carpenter because she's got no life. I was in the shower. Did the defense rest its case? No, Sassy, no. They're just on break. Ashley was believable on the stand. Real emotion, ebbs and flows like it did for her on the stand. Things that are painful and recall will trigger. Not everything's painful to recall. True, Leslie Ann, true. Sassy on break, definitely. So I would say, what again, we go back to the whole thing. I said this throughout Karen's trial as well. We don't know what the jury is.
All right, welcome back, everybody.
What we think.
We are back on the record.
Would you ever imagine that 9 people would find or would vote guilty for Karen for manslaughter? So never second guess a jury.
All right, Mr. Taylor, do you have your next witness?
Defense calls Vincent Vizzaccraro.
You ready?
Yes.
Okay. Yeah, let's go ahead and bring him in. Please make sure you have him spell that for the court reporter.
It's just like it sounds.
Do you need the,
Please.
but we'll wait to turn the lights down until you give us the high sign and the clerk will turn them down.
All right.
Yeah. Yes, different persons. So the one they were going to do, they're arguing about is no longer testifying because there's no need for him. The judge wouldn't let that in. So, yeah. So this one, I don't know who he is. Vincenzo or something. We'll see.
All right, y'all can have a seat. Welcome back, everybody. Hope you got to stretch a little bit. Maybe run and jog in place, warm up a little. So we've got the defense going to call their next witness, but before we do that, I did want to ask that anybody begin deliberations amongst yourself, speak with anybody outside of the jury about the case, or do any research on those topics we've talked about. Everybody says no. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzaccraro.
Can you tell us where the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Hello, sir. As Debbie said, just make yourself comfortable in that chair. My name is Judge White. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away. Speak in a loud, clear voice. It'll pick up everything.
Sounds good.
Good morning.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzaccraro, Vizzaccaro.
All right, Mr. Vizzaccaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
I want to ask you whether or not back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
You're saying.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzaccaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzaccaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach, Jen?
Yes.
Oh, here we go again. Sidebar. This is, again, the prosecution. They're going to do this for every witness, I think. Again, prosecution, if you don't have a case, just say, we want to dismiss this case. Let's not go through this rigmarole. Well, yeah, rigmarole? Let's not go through this rigmarole. Rigmarole? Is it rigmarole? I don't know why you say it. Rigmarole? I don't know. But you know what I mean. I hope. It's just like, come on, people. Rigmarole, no. Rigmarole, no. Rigmarole. 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 No. Rigmarole. 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 You're all saying it fucking differently. Figuramole. I don't know how to say it, Carol. Sidebar this way. Rig my hole. I can't. Don't pronounce the H. Okay, so hang on. Rigmarole. 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 Know your role. She dislikes us so much she'd give a voice box and crook away to. Yes. Just stop it if you don't want it to continue. Yes, I grow. Zach's to my rescue. Rigmarole. Rigmarole. All this rigmarole. Let's stop all this rigmarole. I got it. Rigmarole. Rigmarole. Oh, fucking hell. Now I'm confused again. Rigmarole. Rose and Zach say the same. I gotta go with that. Leslie and Jed. Rigmarole. Rigmarole. There we go. Rigmarole. No, it's 5 Stormcat. I had anyway. Rigmarole. This whole rigmarole.
All right, members of the jury, I do need a few minutes to resolve a legal issue. That's my responsibility. So if you could, close up your notes and leave them there on your chair. And I'm going to excuse you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't begin deliberations. Don't talk with anybody outside the jury. And no research on any of the issues. Thank you.
Rigmarole. There we go, Rebecca.
All right, you all can have a seat. Mr. Vizzaccraro, what I'm going to do is at this moment, I need to do some research and speak with the attorneys.
Okay.
So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties.
Mm-hmm.
And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or what testimony they gave while hearing court, or do any research on the case, watch it, or anything else.
Understood.
All right, we'll call you back as soon as we can.
Okay, thank you.
Thank you. All right, I'm just going to ask before I start doing my research, do you have any cases that you want me to know about right now?
No, Your Honor.
All right, so let's, I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803(6).
Understood. All right, so I'm thinking it's going to, I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find a case that gives me some direction.
Okay, yes, sir. Thank you.
Of course, that means you can too. When we go back on the record.
Yes.
Boulder Dash and Poppycock. Well, CT, we have a little bit of Boston, New York accent, so we drop a lot of letters like Saiba, Usta. It's Rigmarole. Rigmarole. There you go. Would just be like, yeah, there's something case law he needs to look at now about this witness. I don't fucking know. I don't know anymore. Judge earning his pay on this case. Yes. Just ordered an alternate corner t-shirt. Oh, thank you so much. Thank you so much, Lisa. Where did you get it from? Did you get it on Shopify or the other one? Let me stop that. Yes, Leslie, Judge looking up something. See, he's looking up case law because he's looking up case law for this issue, whatever the issue is. We just don't know what it is. Daffy, I thought my fiance and I were the only ones that used Boulder Dash. We drop a lot of letters to in West Virginia. Golden Mama, West Virginia, Mountain Hunter, lots of R's. Oh yeah, there's no R's. It's like bah. Nice. Thank you. I like high five of them. They drive me crazy. Stop stalling prosecution. Yes, I agree. We saw cool. No, I got 2 stalls, you see. I forgot to cancel one of them. So that's why I was asking. It's all good, Lisa. It's all good, my darling. Thank you so much for your support. I appreciate you. Thank you. It's to do with him buying the house from him, using his business. I think that's the problem. Bullpucky. What the fuck's that? Bullpucky? Bullpucky, bullpucky, bull. Right, do you know what time it is now? Because there's a few more people in here, but not. Hang on, where's it gone? I'll need a 2-second break. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Atlanta now, Leslie. Whoa. Hey, Joe, by the way, nice to see you, my darling. Dislikes the state lawyers, but all these extra hearings within trial are on defense and them not turning over specifics in discovery. Yes. I can't wait to get it. Thank you again, Lisa. You know a lot of American tunes. I don't know. I love America. I love America. 45 minutes west of West Virginia, Mount Atlanta. Atlanta's busy there. Atlanta's super busy for traffic. John Denver. There you go. Spring by Amazon. There's that. Yeah, I got 2. So I got Shopify and I got Spring. Spring I've been using. So Spring doesn't cost me anything to do, and I always put it on there. But Shopify sometimes cheaper, so I have to pay for that. So I just did it on Shopify as well. But same difference. I think Erin Haag has got everything from Spring. I hopefully the same price. I hope. I think Shopify might be slightly cheaper, but not by much. So that's my bad. It was always supposed to be Spring, but I forgot to cancel it. So they're making me pay for another month, so I'm keeping it up. Shopify. So yeah, no, but it doesn't matter. It's same concept. Thank you so much. Miss what? Miss Kwame Cut. It's so nice, Leslie. What the fuck's that? Deb. Totally different. I am in Virginia. So we have beaches to go to OBX every year for vacation, North Carolina. Good morning. Hope you had a great weekend. I did, Joe. I hope you did as well. The hell is that? What with traffic? I live in North Atlanta. It can take me an hour just to go across town. Bullshit. Cow potty horse. What? We call it a hot Atlanta. The traffic is madness and I avoid it at all costs. And hopefully the same shirts. I think the spring ones are nicer. Yeah, I think you're all right. It'll be the same. It's the same. So if that's where you got it from, so Lisa, you sorted. That's where Huxter's got hers from. So you sorted. I really regret not taking the opportunity to move to USA when I was younger, job related. Oh yeah, I wish I was in the USA. I love USA. I love America. I love the food. I love the women. I love everything about America. I don't know why, but I just do. I love America. I'd love to live in America. The Atlanta airport is psycho, lol. I've heard that. I heard Atlanta's the worst. Leslie, bad traffic in an hour plus, lol. Hate driving through Atlanta. Well, in Montana, the crazy. Oops. Cowboys would play with bullpucky with mallet and buffalo pucks of poop. The fuck? Just like polo, but with poop. What the fuck? I don't know. I was wondering the same thing. That I'm even lost here now. I'm completely lost here now. After my pop used to call horse poo horse apples in the road. Court TV post says, Terry said 57% guilty after Ashley testified. A lot of comments about no tears. Wonder if he will change. Well, I think Court TV is normally, Terry, correct me if I'm wrong, like 95% guilty at this point. They're always guilty in Court TV. So, I don't know. That's pretty good for Court TV. I can't avoid it. I live in the city. Move, bitch, get out of my way. Move, bitch, get out of the way. Get out of the way, bitch. On loop on my playlist. We love you here too. Oh, thank you, Deb. Thank you, Lady Di. Thank you very much. Thank you, Leslie. I love Lou. That I can't say that word. Carol, we love you too. Then thank you, Sassy. Elsie, Horse Apples. We've been stuck in London traffic for 3 hours before. People were standing. Oh, jeepers. You might like Austin. I love Texas. I love everything about Texas. I talk about Texas. Where the hell's Sarah P? I've not Sarah P for ages. I need to message her, see if she's okay. Texas seems to be nice weather, but everything's bigger in Texas, it's ain't it? Everything's bigger in Texas, y'all. That's where Donna's from, Texas, isn't it? Donna Graves. But she's not here today. Vicky, well, cowboys are strange. I want to get a cowboy hat, cowboy belt, and I want to dress like a cowboy. But proper cowboy, boots and everything. I want to get out there and do that. That's what she said. I love it. It's sport for me. I drove in New York City traffic for years before I moved here. Sharks are playing. You will learn to sink or swim long. I've always called horse poop road apples. They're about the same size as you, aren't they? Leslie, but I can't imagine here. The traffic is horrendous. I go a different way to work. That takes 10 minutes longer to avoid 95 traffic in the morning. Jeepers. It's Court TV blows anyway. Yes, they all blow. I live in the Amish. Oh, Amish. That's what she said. Oi, oi! Lady Di knows the score. I used to live in Texas. Loved it. Yeah. I can't do busy traffic. Oh, I hate it. I live in a rural area, which is nice. No traffic. Or not that much traffic then. I want to dress up as a cowboy. I want to be America. I want to go to an American store and I want to buy a proper cowboy hat. Like you need a box for it, proper cowboy hat, proper cowboy gear, the belt, the boots. These boots were made for walking, and that's what I will do. One of those. Maybe I can do that in the UK. I don't know. Does that guy behind Taylor wear his mask to bed? I still see old people in the car window closed on their own with a foxy useless masks on. This needs to stop. Wait. Erin, stop it. I'd love to hear you say, "Yee-haw!" Let's go. Yee-haw, y'all. Yee-haw, y'all. Live music in Austin, Delan could become a musical performer. Jeepers, no. Nashville as well. I want to go to Nashville, Tennessee. Nashville, Tennessee. Yee-haw, everybody. Y'all. You should go to Montana. Montana, is that next to Colorado or something? I've heard of Montana before. We love cowboys in Missouri. Spicy Paralegal loves it. There you go. I have to dress up then as a cowboy. I got a Stetson from Red Adair along with other bits and bobs. Damn, I must have missed that one. Oh, I believe you, Chappie. Hence the oh no. I love in the country. You live in the country or love. Ain't no love, love, love. Da, da. Oh, here she is, Donna. Hello, my darling. I didn't know you were here. Yes, sir, Dylan. I was born and bred here, then have lived all over military brat. Oh, happy days. You see, do you think I'd look good in a cowboy suit? All dressed as a cowboy. Yee-haw, everybody, y'all. Yee-haw, y'all. So when are beautiful on yourself coming over the yeah, well, I said probably next year, early on next year, I think. Early on next year, I think. I need to I said to come over for the next trial, but I probably have to stream it. But yeah, I do need to probably next year. I need to save some money first for everything. But definitely coming over, Vic. Definitely coming over to Boston, Ferris City, where the girls are so pretty. Cotton Eye Joe. Cotton Eye Chappie. Now I got what you're saying. How about chaps then? Chaps? What's chaps? What are chaps? What's that? Stetson. What's a Stetson? Hat. Is a hat a Stetson? You know that you'll have to wear those butt hugger Wrangler jeans. Wrangler jeans? I've not wear Wrangler jeans. I don't know what jeans I wear actually. I've not worn jeans for years. Proud military brat here too. There you go. Needs the chappiest of chaps. There you go. I need to look up to see if I can buy anything in the UK. But I looked at a hat. It was like thousands. I was like, fuck that. Stevensville Cowboy. Stevensville Cowboy Capital. Okay. 4 major highway convenience in DT Atlanta. That's the problem. Jesus, dangerous highway in America, especially the North Loop. When you say proper. Someone shipped a cowboy hat and lasso to get the full effect next time. What's a lasso? Is that like the that thingy? Yeehaw! Mom? Is that what they say? Good day, Mom? No, they don't say good day. Good morning, Mom. They tip the hat, Mom, Sir. We still have ones wearing masks on streets and cars and stores, even when they're by themselves. We still have a few. Famous oil field firefighter. Oh, okay. The best life ever, in my opinion. You get to go around everywhere, don't you? Rolling in the river, rolling. We'll see you with a bull riding the bardle and your cowboy gear. Yeah, let's go, y'all. Go bull. I'll come straight off. I'll be flying off. You have to go to be a real Western store. They will fix you right up. I have sort of looked at it before, but it was so expensive. But I mean, we do need to look at that. Arsenal's chaps. What's fucking Arsenal's chaps? Is that trousers? My daughter has a sparkly red, white, and blue cowboy hat. It would be perfect. There you go. I'm supposed to be working, but chatting with everyone because you're all hilarious. Thank you, Lady Di. Open ass pants, that chaps. Oh, bloody hell. Cheese and rice. Cheese and rice, Harry Hack. Cowboy hat. I do like a cowboy hat. I want a cowboy hat, a nice one. Lush in the Cotswolds, mate. Very, very rural. More horses here than people. Well, we got horses here. My father, he's part owner in a farm, and we got horses. we actually got horses for years, like breeded horses. I don't breed them. My uncle breeds them. So yeah, I don't ride them, but ride them, cowboy! Yeehaw!
All right, you guys
You're
ready to go
back.
back on the record?
Yes.
Yeah.
Printing something.
Carpenters are online.
All right, the objection is hearsay.
No,
Any other objections?
I
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth in this email about a specific property, there's no relevance to it.
All right, proponent, go ahead, sir.
Well, I think it's admissible, one, as a business record, which we've already qualified. Business records traditionally contain hearsay. And under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind, that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
All right, anything else, sir?
No, sir.
State?
Judge, I found a case I would like to put on the record, Thomas v. State, 993 Southern 2nd, 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but it was an email that was sent to an apartment complex manager of some sort, and it appears as though it was not qualifying as a business record, and additionally, the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
Did you review Thomas v. State? Mr. Taylor?
Yes, sir.
All right, do you want to make any argument on it?
No, sir.
So Thomas v. State is helpful. So 993 Southern 2nd 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, and it seemed to, I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzaccraro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Vincent v. State, Vincant, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is state of mind. It clearly shows Mr. Benefield. Let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield, Judge White, negotiating with the realtor to buy the house directly behind the home where Ashley Benefield lives. And he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice. That corroborates the sentence.
Do you want to be heard on 90.8033, than existing mental, emotional, or physical condition?
Judge, his mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
All right, as I said before, are you going to establish the location of the home through Vizzaccraro,
Yes, sir.
where it was
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during closing? I would assume.
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just.
witness-wise.
This is an isolated act of DV. Yes.
All right.
Judge, if she didn't actually know about this, then I don't know that it's relevant.
Well, and that's what I was thinking because, hold on, it's not an act of violence though.
Right.
Or threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803(6) for the realtor's portion and 98.03(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you bring the witness back in, Mr. Vizzaccraro? All right, welcome back, sir. Just take your spot back there in that chair. We're going to get the jury back in and we'll give your testimony.
Sounds good. Thank you.
We'll bring them in.
to come in this way.
It's up to you. All right, y'all can have a seat. Welcome back, everybody. You ready to begin deliberations? Talk with anybody outside the jury about the case or do any research? Everybody say no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Vizzaccraro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizzaccraro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's exhibit 27 will be received.
Now, Mr. Vizzaccraro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it, we have the pointer. Okay, so this will give you
the beam. Okay.
Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay. Do you know, Mr. Vizzaccraro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Okay. Should I delete you? Mr. my oversight. I'm going to pass to you what I've marked as defendant's exhibit number 28. I ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport News Circle.
On
Excuse me.
behalf of Ms. Benefield, you want to move to introduce that as defendant exhibit 28.
No objection.
Received.
That's all. Thank you very much, Mr. Vizzaccraro.
You can
Gotcha.
cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just grab it real quick. And for the record, this is State's Exhibit 27. And it appears as though you're speaking with Mr. Benefield about potentially this house coming up, or the price being lowered on this house, correct?
That's correct. Yes.
All right. So you were contacting Mr. Benefield about it?
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation. Yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top. So you might be able to.
That's why.
For the record, defense exhibit.
I'm sorry, Defense Exhibit 27. Does he say there that he needs to speak with Ashley first?
It appears that way. Yes.
Okay.
Yeah.
Thank you. No further questions.
Can you redirect?
Nope.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state defense? Can you approach real quick?
You're going to see if they, oh, I hope they don't break for lunch now. Don't break for lunch right now, Judge. Please don't. The jury just had like two long breaks already. Mr. Taylor is the defense attorney.
All right, call your next witness.
Good. Yeah, he
Defense
is the
will
lawyer.
call, Your Honor, Dr. Jason Quintal. Yeah.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
Yes.
This guy's back again.
Welcome back.
Hi there. Thank you.
As you may recall, my name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
Good afternoon, Dr. Quintal.
Hi there.
Welcome back.
Thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
No. You go ahead and approach.
This is the problem, you see. This is the problem now. It does my head in when this happens. It's a state witness, and all of a sudden he's been called back. I don't know why he couldn't ask this question earlier on, I don't know, but and now they're objecting to everything. It's like, come on, this is just so bad. Come on. I just find it a little bit frustrating now, especially he's back. It's the same witness. It's your witness state, you know? So this is the witness, if you remember, that smiled and Mr. Taylor got in trouble. Well, he said something like, "Oh, I'm confused, sorry." He goes, "Oh, don't worry," or whatever. Do you remember the judge then gave him a little bit of a talking down to? Hey, I've been looking at Carvender's online, right? Cowboy hats. Sizes 6 3/4, 6 7/8, 7, 7 1/8, 7 1/4, 7 3/8, 7 1/4, 7 5/8. What's that? As in, that won't fit me because I think I'm a slightly like an 8. I think I am. I'm an 8, I think. But they don't do an 8. I think the 7 and 7/8, it's a little bit tight, I think. I think my head's an 8. So I don't think I get a hat off them. And the boots, they only get 10.5. Umberger, hello to you, Umberger. Saw you sneak in. Yeah, I think I'm an 8. So with the New Era hat, I'm an 8. Or maybe 7, 7/8 is a little bit tight. But I think I'm an 8. I wish it was an 8 for everything. That'd be quite nice, wouldn't it? Bloody hell. Yeah, but for a hat, I think I'm an 8. West Virginia. Safe size as a bowling ball. Hamburger, you stop it. Stop with your changing profile pictures. I never noticed you anymore. Spicy paralegal. It's a comfort. Yeah, I think I'm an 8. Hang on. I got some hats. I got some hats here, right? This is 7 5/8. No, too tight. That's what she said. This is 7 7/8. Oh, that fits. That's okay. That's okay. So this is 7 3/4. A little bit tight. That's what she said. And this is an 8. This is too big, if I'm being honest. I think 7 7/8 is. But then this is. I feel comfortable in this. Do you know what I mean? I feel nice and comfortable in this. The 7 7/8 one. Do you know what I mean? That fits, but it's not like. I think the 8 suits better. I think it's a little bit tight. So I don't wear hats, by the way, but this is too big. The 8 is slightly too big. 8 is slightly too big. I've never said that before. They run different, Bev says. This is New Era. So, yeah, I'd have to go in store and get it. Oops. Men always seem to brag about sizes, don't they? Hey, I never brag. I've never said I've got an 8. Nowhere near. So I never brag. Never. Because you can you imagine disappointment then if you're bragging, "Oh, I got an 8 inch." No, you don't. Fucking that tiny thing. Um, right. They could put extra lining into. Yeah, I think I have to be in America to do it though. I can't do it from here. Do you know what I mean? I'd have to take the hat as a carry on then, don't I? Cowboy hats don't go as low as a so the cowboy hat was. I'll pick a random one. It's from 6 3/4 up to 7 3/4. This hat is to give you an example. 6 3/4 to 7 3/4. That's why I'm like, okay, I can't risk it. It's like $400 or 300 something dollars. There you go. No, David, stop it. 121. Oh, sorry, 12 and a half. Yes. We were at the air station, Carol Draper, but he was a camp Eugene for a while. He passed. Oh, no, sorry to hear that, Daffodil. Um, yeah, Spicy Paprika. He's from Missouri. Is that right? It's Missouri you're from, yeah? I don't remember. I think you said that. Ba-da-ba-ba, ba-da-ba-ba. They say everything is big in the States, so maybe they're 8 inches. Hey, maybe they got some extensions. Maybe I don't know. Set foot in Texas and say, y'all, Texas, y'all, everything's bigger in Texas. Think every mil counts, half inch less. My name was going to be Jennifer instead of Anthony. Fricassee. Fricassee is a good cowboy word. Fricassee, I don't know how that is. Erin Hack, Hack, Hack. Look up Stetson. Okay, Stetson cowboy hats. They show you Stetson cowboy hats. Same with the shoes. The shoes don't fit. They don't. Sizes are different, right? Oh, these are nice. Hang on then. Hat sizing assistance. Okay. 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 Tape measure. Okay. That's fine. I can do that. It tells you how to do it. Okay. Missouri, that's it. I was scratching my head. I wasn't sure. I'm sure somebody from Missouri has messaged me on Facebook. I wasn't sure if it was you or someone else. Oh, was it Missouri? Oh, it's one of the M's. Oh, Montana, maybe. I don't remember. Who measured the 12-foot John and was found from the street? Oh, shit.
Their backgrounds. This is okay, Dr. Quintal, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection. Qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both Ashley and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes. Both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
Oh, approach already. I mean, it seems a long-winded way. Just get it in. I don't really understand why. Oh, Ashley's writing stuff down. Okay. It's okay, Vicky. Vicky's just on Twitter posting pictures of herself in Blackpool. Hey, hey, Jew. Ba-da-ba. Dun-dun. Okay. Okay. We'll.
A brief deviation, Dr. Quintal. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
And since you've been in private practice, Dr. Quintal, can you give us an idea of the number of patients that you've seen and counseled?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay. And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally, the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. Mm-hmm. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Okay. Now,
so more instead of a suggestion, it's more of kind of a mutual outcome.
All right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
Your Honor, I would tender Dr. Quintal as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people. I look at people because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar? I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay. Thank you for this question.
You may resume your question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintal as an expert.
And I would object.
Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintal, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together, and Yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintal, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Oh,
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see if
Please.
it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Quintal, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintal, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
sustained.
Did you reach any conclusions, Dr. Quintal, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child. And I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
Okay. And I believe, correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield. Over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. Here you go.
Hi, Ruka.
Can we publish the couple of exhibits that we put in through Mr. Vizzaccraro? That's the wrong one. And then I think we'll watch a break for lunch. 27. I don't think that's.
Oh, that's not. Yeah. Oh, you have 27?
27.
One photograph was already in.
One.
And then one we added together with the.
Yes, so members of the jury, we're going to pass these out and publish them. I'm not rushing you, but I'm going to talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
Exhibits 26 and 27.
Those 27 and 28, and they'll be marked on them. There's a little sticker on each. Which should say 27, 28, and I think the other one is Defense Exhibit 1.
See you there, Gary. Catch you there, bud. he's allowed them. Any exhibits that have been entered, they're allowed to look at them before they go in the back, just to give them a refresh. I've not really seen that before, but in Florida they seem to do it that way. So. Course all low. Barbara, they're not televised. We do have course, but they're not televised. They run similar ways, but they're not televised. We never see them. That's why we cover the US ones. So, hey Bungalow, hello my darling, how are you? Jeepers, come on. Just a reminder, there's 6 jurors, 3 alternates. The 6 jurors are made up of 5 women, 1 male, and the alternates are made of 2 women, 1 man. I hate the court noise. Here seems like it's an US thing. Yeah, it is an US thing. Yeah. Hello, Shari D. You got your pink sweatshirt. Happy days, Shari. Thanks again for your support, my darling. Thank you so much, and hope you like it. Hey, Patty. Oh, come on. Send them away. Oh, no. In Canada.
All right, so it's 12:15. If I could have you back down in the jury assembly room where you began everything this morning and last week at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30. We'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments, don't talk amongst yourselves with anyone outside of the jury. We'll do any research on the people, places, things, the legal topics we've heard anything about. Thank you. All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
right? And certainly a list of witnesses that are expected to be called.
Yes.
I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
So
I don't need to know the order, but just who?
We have Jason Alexander, Michael Haag, Haag, Dr.
Hold
Emma
on one
Lew,
second. I'm sorry. I got it. My list is, okay. Michael Haag,
Michael Haag, Dr. Emma Lew,
all right.
and Warren Justin.
Warren.
Justin, the lead homicide detective.
All right. When we, none of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before, before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather have the objection made, let's talk about it, and then let's call the jury in so it's a little bit smoother.
With Detective Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so.
Okay. You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonable good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haag, who's our ballistics expert.
Mike.
We needed
Mike
Haag.
Haag. Yes.
Haag.
Okay.
We need the HDMI cable to run to the witness stand so he can plug his laptop.
To where? Here? I don't understand.
Yes.
Projected.
Yeah. So it'll be up on the projector.
So he's going to use his laptop to project here.
His testimony, yes, sir.
I know this is the one we used. I don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need that a witness this afternoon is going to have to run to that?
Yes, sir.
Thank you so much. And then that'll take care of both, because my goblins, just, you know how it goes.
Okay.
All right.
Thank you, Judge.
I guess the only other questions they would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state for the most part.
We don't know what they're presenting in rebuttal.
Okay.
Oh, the prosecution are bitches. Okay. That's interesting. So they might rest today. That was not on my bingo card, people, resting today. What was the hot mic? Something about being bitchy. They were being bitchy. Do you know what I mean? But yeah, we'll see. So it could be 4 more witnesses could be done today. Okay. Then tomorrow might be a rebuttal. What are they doing now? So if tomorrow's rebuttal, charge, closing, So tomorrow afternoon, I'll go back now. Hang on, let me go back then, Hackster. Just for the Hackster.
So can you tell them that we?
Hang on, let me go back a second, and then let me do this for the Hackster.
Are there witnesses? Are those witnesses being released? Because they're asking the state for the most part.
We don't know what they're presenting in rebuttal.
Hang on, I just messed that up. Hang on.
Okay.
They're just being nasty. Let's go back a second again then.
Okay.
And let's go back a second again then. I need to put my volume up.
Okay.
One of them says they're waiting for rebuttal, as in, like, you know, they're waiting for rebuttal. And then the other one says they're just being nasty. So they put the volume down then. There we are. Right, ladies, you know what's going to happen now. Vicky, you're going to need a shower. She said about rebuttal, as in they're waiting for rebuttal, and then the other one said, "Oh, they're doing it to be nasty." All right. See, I'm in the weeds more than Aaron Hack. Right, and ladies, I know you're ready for him. You're not going to get all of him today because there's only so much they can. It's too much of him. It's an hour 36, so you won't be able to watch it all. But you can watch a large chunk of it. I got you. I got you. I know what you ladies like. I got you. The what's it called? I popped it before, but feeling new love. Thank you, Daffodil. I knew I haven't seen you before, so thanks for being here. Right, let me jump off and put this on. Here we go. Enjoy.
He never came at you with a knife.
No.
Or a club.
No.
Or a baseball bat.
No.
So there are 30 years.
Right off the jump, right? We get what their theory is. This force was not enough for you to be in fear for your life or serious bodily harm. Okay. Now, first problem with that is, legally speaking, that's not the standard. What she is describing, the standard is you do have to be in fear of serious bodily harm or death. But the standard is not it has to be done with a weapon, or he doesn't have to choke you or punch you or do anything specific. There's no line where it's like, okay, everybody agrees that if somebody does this, if they obviously point a firearm in your direction, then you're in fear. So number one, the number one issue I see there is she's creating a standard that doesn't actually exist legally. And number two, as I'm sure many people are going to say in the chat, those are not the only ways that you can be in legitimate fear of serious bodily harm or death. And that's exactly how she starts it out. And that's exactly what she goes with kind of as her theme throughout the entire cross-examination. Now, I think there's a way to do that. And there's a way to downplay kind of what happened and how she may have overreacted. But stating only the worst of the worst, I mean, we can go back just to Florida trials we have covered together to see that that's not what's necessary. Throwing a cell phone has been enough. Somebody getting shoved has been enough. Somebody getting backed into a corner has been enough.
There's difference between you and Doug, correct?
Yes.
And you got married after 13 days.
Yes.
And you spoke with him about, or organized with him about starting this ballet. Yes. Okay. And all of the money for the ballet came from him or investors, right?
My mom also funded part of the ballet.
You didn't put anything into it. Money.
Not from my account, no.
Okay. In fact, during this time in South Carolina, you never worked, did you?
He wouldn't let me work.
Okay. When you said in the very beginning he flew you to South Carolina to visit before you were married, he paid for that, correct?
Yes.
Okay. And the cruise you talked about going on, he paid for that?
No.
He didn't?
He did not pay for the cruise. No.
Okay.
Yeah, he paid for my friend to go, but I had already paid for my mom and I to go. So.
Okay. So he paid for your friend to go?
Yes.
And he did not go with you?
Oh, no. Mm-mm.
So again, you can tell the beginning of cross, these are the points she thinks are the strongest, and these are the points that you should know the answers to. This should not be a surprise. You should come with your strongest stuff where you know she's not going to wiggle out of them. Yet he paid for the ballet studio. But then she's like, no, he and investors and your mom. Okay. Maybe I'm missing the like strength of the ballet studio and that investment as being a motive for this crime. The ballet studio failed. The money had dried up. Why is that a motive for this crime? Why would this help her financially? I don't get that. If they would have said you got an insurance policy because you guys were still married, like people are asking, what more would you need? What more would you need? Well, we've seen it in other cases where she ups the insurance policy or she knew she's a beneficiary in the insurance policy. So something like this happens where she would get a windfall of the insurance. No, we didn't have any evidence of that in this case. So I don't get where the financial motive comes in, except for people saying, I guess that's why she wanted to marry him, which is okay. But I just don't get that financial motive. Jen, hi, PT. Do you think this could be another mistrial? I always guess no on mistrials because 95% of the time it doesn't end in a mistrial. I don't think this one will. The strategy of prosecutors, let's undo 50 years of progress and DV victim outreach programs. I mean, I got to be honest. The only way I can explain this prosecutor's theme and manner of cross-examination is she fully does not believe that Ashley Benefield is a victim of domestic violence. She thinks she's lying and manipulating, and that's basically all there is to it. Because if she believed it, or if she believed it even could be true, boy, did she step on everything that, we should care about as Americans and fighting for people who can't fight for themselves.
I want to ask you about the text messages that the defense talked to you about. It's going to be Defense Exhibit 3. I'm going to hand it to you. But I have the entirety of it on a spreadsheet that I'm going to put up, which is State Exhibit 99. If we could dim the lights, please. And Judge, based on the rule of completeness, they would enter into evidence States 99.
Did you want to give it in addition to what was said earlier?
I haven't actually seen the specific message.
On the screen. I would like to orient you to what we're looking at. So on the top line, it gives whether the messages are outgoing or incoming. That would be the third, fourth column that we're looking at. And what I would like you to do is read the body of these as we go through. I'm going to expand it so you can see it. And if you could just read these for the jury.
Okay. One part is just looking at Renee.
Who is that from you or from Doug?
It's from Doug to me.
Okay. So from Doug, one part is just looking at Renee. Okay, go ahead.
I'll tell that part to start. The day I met her, I felt her before I saw her. So, my ex-husband lived to argue. Renee and I maybe argued 5 times in 15 years, and even then ended up laughing. Smiley face. I'm a clown at heart and love people being happy. That seems like a hard act to follow. Baby. Like, always being armed. Yes, my love.
And the outgoing messages are you or Doug?
It looks like outgoing is Doug. Yeah, outgoing would be from Doug.
Judge, can we see the date for reference of the messages?
It's up on the screen.
you doing things that are dangerous?
And you're gonna have to speak up just a little bit.
I'm sorry.
Here.
Are you doing things that are dangerous? To think of all the time that you were not with me and understanding them and how to conduct warfare in them for the kingdom.
Where was he when he was sending you these messages? While you were on the cruise?
This is when we're getting into, I think she confirmed, I may have skipped it because of all the back and forth about the dates and stuff. She confirmed that she was a little jealous of his relationship with his first wife and the mother of his children. So that, was part of, I think, something the state got out across because they made some points, definitely. Now they're going to get into his kind of aggressive, violent talk that the state's trying to argue the defense took him out of context. So the state's trying to provide context for some of those texts for us to figure out, why was he saying this stuff? Why did he feel this way? Was it legitimate, or was it just off the wall that would make you scared of somebody like that?
I believe he would have been in Charleston.
Okay. He wasn't on a business trip.
I don't believe so.
Okay. Continue reading. All the other people.
All the other people. In a rectangle. It makes me so sad. And then another rectangle. If I dwelled on it, I would go into rage to remove them from the earth.
And your response to that?
Yes, baby, I hate it. It hurts. He said I could defend myself. And you were easy prey for predators. You're sweet and want to please people, and they used that.
And you said, I'm sorry, and then he said,
I desire to exterminate them, and holding back is a challenge. They are rats that should be removed.
And you said,
oh, baby, my love. Yes. Like that night, like last night, just the jerks arguing near you about put me in a sheer murderous mood, but I was stuck and I couldn't defend you. I said, thank you, baby, but I was okay. He said, but could have been a fight, etc. Only you being with me will over time remove images in my head. It is same. And knowing you were taken advantage of in my mind makes me explode with anger to take them out. God made you for me. And I said, yes, baby. He said to enjoy the beauty he did craft on earth. I see Renee as Eva's mom, not my wife. It is strange, but...
Can you pull that back up?
He said, it is strange, but there is no emotional connection. I said, well, I'm glad. I just wish I could see it that way.
And you said, I'm glad. I wish I could see it that way. Were you talking about being jealous of his relationship with Renee?
I guess you could put it that way.
Okay. You can continue.
I also think that Ashley Benefield did not really argue a lot with the prosecutor. She didn't push back a lot. If something logically kind of sounded like that, like she was a little jealous of his first wife, which again, if you say you're not, and she's the mother of his children, they were married for so long and she died tragically, and it was probably very sad for him. To act like there's no feeling there of jealousy, I think people could have been like, come on, she's trying to stretch, but she didn't. She was like, yeah, I guess you could say that. I guess you could put it that way. She didn't argue with her, which I think is the right way to prepare a client as a lawyer to deal with some things that are going to come up. These text messages are not a surprise to Ashley Benefield or to the defense. They've seen them. They know they exist. Falvo said, Peter, have the use of steroids been mentioned? This behavior mirrors someone I used to know with spouts of anger and scattered hormones. Not sure about her innocence, but I would definitely be afraid of him. So no, I don't think they have. There's been like mention of Viagra and stuff like that, but no steroid mention. What I will say though, and as a lawyer that we put exhibits in and we put pictures in, sometimes we think similarly to this, but if we can't prove that there was steroid use, or we don't have an expert to prove that steroid use equates to this, there's common sense. And we know that the defense put in that picture of, Doug flexing and being like, these are my big muscles or whatever. And that's why the state had somebody testify he's 5'9", 160 pounds. He's a little guy. And the defense puts in this picture and is like, oh, little guy, look at these muscles. Because we know that if we think as a normal person that maybe there's steroids involved, and I'll tell you, this does not look like steroid use to me. If I was going to look at a guy's body with steroids, I would say no, except for the fact that he's 54, 55, years old, then maybe more likely some enhancement is involved, but the jury may think that. And you, Falvo, are not the only person that has written me a comment about steroid use since the defense put in that picture. Nona, good morning, Peter. Nona duties called this morning. I will be part of the rewatch crew. Thank you for all you do. Thank you for mediating us, the chat, and recognizing different perspectives. I appreciate the grace you exude. Thank you so much. Thank you, Nona. And my kids call my mom Nona. So that's great. Enjoy Nona duties. They are the best. Fletch said, possible poll for later. Did you change your opinion on credibility between direct and cross? We will do a poll of some sort on how cross affected it. Kelsey, remind me if I forget. Yeah, we will do a poll on that for sure. Morning, bro. Is battered wife syndrome her defense in this case? Yes. Texts are bad for the state. He's loco cross 101 equals questions you already know the answer to. Oh, cross 101. Yeah. Yeah, I agree. I think that, you know, you have to know the answers and they have to be good and they have to be quick. And they, like, she wanted that to be a, he didn't do this. He didn't do this. He didn't do this. He didn't do this. And you wanted this and you did this. That's what it needs to be like. And there was too many. No, he wasn't the only person that paid. My mom paid some too. And no, he didn't buy the cruise tickets. I bought mine and my mom's. He paid for my friends. You know, it just wasn't as strong as I think of a start that she wanted. Battered wife syndrome is the defense and mixed in with the self-defense here. And that's why the old text messages become relevant and are so important in this case. Why would the prosecution feel these texts are helpful to their case? Makes him look utterly insane. So Barclay, I thought when they brought him up, and I thought I actually think it might have worked out better for them if they would have just left it alone, like you're kind of intimating here. Because when I read those texts, or when I heard those texts on the defense's direct, I was like, that seems out of context. Warfare for the kingdom. It brought me back to kind of some, you know, Daybell Vallow stuff where it's like, maybe they were talking about, you know, praying or, you know, fighting the good fight or whatever. But no, he was talking about people he was annoyed because they were joking around near her while she was on the phone. That's not, you know, the baseline you want, I think, for your husband. Jut, if the prosecution does not believe her, was this still the best strategy with the jury, even the faces she makes? So this is where we start to get into the strategy, and we haven't even gotten into kind of the bulk of the cross-examination yet. But this is what I would say. If I really don't believe her, I would try to determine why. And then I would try to make the jury see it the same way I see it with my cross-examination. But I always keep in the back of my head, maybe they just didn't believe her on direct. And I also don't want to blow it with cross. So there are lines I don't want to cross. And a lot of times I'll just tell you, and I'll be honest with you, because there's this strategy in here, and I hope nobody takes this as, you know, sexist or things like that, because this is what happens in trial. And we talk about it with female lawyers, with male lawyers, whatever it may be, old, young, all of it comes into play, where maybe there's a difference because she thinks female on female cross is different than, like, if I was crossing her. If I was crossing her, I'll tell you it would have been completely different. I would have, and I've actually seen, I had a buddy, we watched a trial one time, and he went hard cross-examining somebody with a battered spouse defense. He was a prosecutor, and it went horribly for him, and he lost the case. And, you know, a lot of people thought it may have been because of that, because he just went too hard. And you make anybody on the jury that may be thinking that she is a victim and thinking you're re-victimizing her as a man, like her husband victimized her, you can lose a case just off that, even if they think she's guilty. So I don't know if maybe she felt like she had a little more rope because it was a female-female situation. And we talked about it in Johnny Depp's case, how Camille Vasquez cross-examined Amber Heard dealing with this stuff. A lot of times that's the strategy that's used by lawyers in these cases. So maybe that's why she pushed it a little bit harder. But I mean, if there's anybody on that jury that was feeling bad for Ashley Benefield, this cross did nothing but make them dig in. But if they don't believe her and they think she was lying, or this has happened to them or their son or their brother or husband or dad or whatever, and they're like, I hate people that do this, maybe she was thinking she's going to bring them into their team. But my first thought would have been, as a prosecutor, they're already with me. So why take a swing like this? If they're already with me, just bring them along with me and don't piss off people that might be on the fence. And that's something that I think is an overarching theme of this cross-examination. Can people be sensitive to DV survivors in the chat? Believe her or not, insults are totally gross. This is why victims stay silent. And I do think that there is some discussion around how we handle people that talk, and balancing, though. I mean, I do think there has to be balance where people that lie about stuff, which we have seen very publicly, celebrities and others that we have felt or juries have felt, they lie about certain claims they make, and punishing that and making sure that doesn't come out to hurt real survivors versus trying to silence real survivors. And I got to be honest with this case, I'm not seeing the people that think she has zero leg to stand on that he was dangerous. I'm not seeing that. I just don't. I get it if you think that maybe she manipulated or maybe she took it too far or she overreacted. We can have that discussion. But there are things this guy did and said in texts and prior relationships and with animals that I don't think you can say, oh, there was no reason for her to even ever feel afraid. All right, let's get back to it.
Continue to read.
I know we both have a battle to fight in our minds. He was sitting on the mantle in the background. I'm crazy, I know. But it just killed my heart. I know I see you in my mind with a bad person with your legs spread and a shitty person choking you out. That haunts me. I love you and I never want to hurt you. I'm sorry. Rectangle. Now all I see is some douchebag on top of you, fucking you with your legs spread and him choking you out and fucking you more. Right now, I literally want to kill him or them. I said, baby, don't even think like that. He said, you haven't seen the warrior side and you never want to. I said, no one will ever touch me. I am yours. I don't. You are right. I want to see you only as my sweet and loving husband who is gentle to me and kind. He said, we went from joy and passion.
So I mean, there are people in the chat yesterday that were talking about how they think she starts like fake crying at those points. Man, I mean, maybe you guys are more perceptive than me, but it would be really hard for me to differentiate that choke up as being real or fake for somebody who did love this guy and married him and had a kid with him, right? Like she didn't hate him from day one. This wasn't like somebody she never cared for. So I don't know how we get there.
And now I'm in a testosterone rage inside. And who is always there and safe? That's what I said. And I said, let's not ruin the day. He said, but kill the bad people. Okay. And I said, tell me that you love me.
So this conversation was about things that you had told him that people had done to you, correct? When he's talking about, I'm imagining this, I'm imagining people choke you, he's talking about a conversation that you had with him explaining that this had happened.
I think he was referring to on the cruise one night I was talking to him on the phone and I was sitting out in the hallway up at the top deck and I was just trying to get somewhere where it'd be quiet so I could talk to him. And it was near, there was some like a bar or something up there, I think, I'm not sure, but people were coming in and out, like maybe a restaurant. And while we were talking, he heard.
Is the answer yes or no?
Just allow her to finish her answer, John.
So this is also a misstep here on Cross. It definitely sounds like he was talking about something that she had told him prior that had happened to her, some kind of abuse, and it was making him angry, which I think that's legit to make him angry. But she's like, no, right now we're talking about the cruise thing, which is like, whoa, that set him off. And the prosecutor did not do a good job kind of hammering it out and making it enter into that point where we got the fact that she was riling him up. I think that's what the prosecutor was trying to get at. You told him this stuff. You're riling him up, talking to him about this stuff, making him angry, with the manipulation, but that's not how it ended up coming out in evidence with this testimony.
He had heard a couple of guys that were talking loudly and he got upset because he thought.
So I would just say, I don't feel like Camille Vasquez was aggressive at all with Amber Heard. I felt like she responded with strength and was like, I'm not going to be pushed around. You're not going to push me around, Miss Heard. Basically, I don't think she came out swinging at Miss Heard like this prosecutor did. She didn't come out, with a bat. I think she came out strong, stern, and wasn't going to get pushed around. And then at times it felt a little forceful, and I agree with you. I definitely think it was different. And I kind of agree with your comment of how you think it went as well. But I would not have categorized it as overly aggressive myself, watching it as a lawyer.
These guys were going to hurt me. And so he talked about then that he imagined that, I was out in the world without him and that people were going to take advantage of me and that he didn't know what was going to happen to me.
And he was afraid for your safety.
Yeah.
I mean, that answer was that he was afraid of something that wasn't real. Like I was out here in the world without him on a cruise and that people were going to take advantage of me and hurt me. That kind of can show that his mind goes to anger and violence kind of in a way that may not be reasonable. But again, if it really was like them talking about something and recounting something she told him in the past that hurt her and it made him angry, to me, that's, again, not great, not normal, I don't want to say, but more reasonable. And that it may just be me, but that exchange, I don't think went as the prosecutor expected it to.
And he was saying that if anybody hurts you or he thinks about anybody hurting you, it sends him to a rage.
Yes.
And that scared you.
I'm sorry.
And that scared you.
Well, as I said earlier, at the time, I kind of, played it off in my head that he was just my new husband who was trying to be protective and like show that he loved me by kind of being, manly.
So I want to talk about you having a baby. So Doug had a vasectomy removal in April of 2017, right?
Yes.
And you paid for that?
Part of it went on my debit card or my credit card.
So her paying for it again is another mix of like how money worked in this. It's like, that's weird, but I guess she's saying this is something she wanted, so she paid for it. But the ballet studio was something she wanted, but she didn't pay for that. So I don't really understand that. If she was marrying him for money, why would she have to pay for the vasectomy? Are they trying to say she forced him into getting the vasectomy? I don't understand that. There's so much about this relationship I don't understand. But a good point the state makes, and the prior answer that she just said that, no, I wasn't necessarily scared of him. I just thought it was my new husband trying to be tough and manly for me. But the reason that's a good answer is because the state is going to follow up with a good point, which is that you were so scared of him. Some of these text messages, some of these things were happening, but you still wanted to have a baby with him. You still wanted to continue to be married to him, even though you knew all this stuff in the past. Now you're saying all that stuff made you so scared. That was a good point. And I hope it didn't get lost in here for the people that, are trying to follow the state's case, because that's something the state's trying to prove here.
And your intention was to get pregnant?
Yes, we had talked about that, yeah.
And this was how many months after you were married?
We got married in September, so October, November, December, January, February, March, April, 7.
And was this, during this time, you said he had started criticizing you, right? Mm-hmm. About the way you looked, your clothes, the way you acted. He was, according to you, he flipped a table, tried to flip a table, threw a chair, right?
Yes.
He would scream at you.
Yes.
He would call you slut and whore.
Yes.
And you want a baby.
I mean, yeah, we were married. We wanted a family.
Okay.
I just don't like the way she asks it, right? He called you this, he did this, and you want a baby. It's like, just be like, so let's just go through it again. You're claiming this abuse. You're claiming this scared you. You're claiming he did this. You're claiming he said that, right? So now you're looking back and you're saying like, this is a dangerous guy. I'm afraid of this guy, right? So what made you want to bring a baby into the world with him then? That's a better just line of questioning. It's a little softer. It still makes the point. I think the jury's listening. When you go a little too fast but you want a baby, I think loses some of the effect. You guys let me know though. I'm just telling you strategically kind of like how I would ask the questions differently that are the same points, but just massaged a little differently.
So the vasectomy reversal happens. And I believe you said that this baby was a surprise. Is that what you said?
Well, we weren't like planning on it right then. Yeah.
Were you having unprotected sex?
I suppose so.
Okay. So you knew that unprotected sex would result potentially in a pregnancy.
The doctor had told us that it probably wouldn't work for a while. So it wasn't something that we thought would happen that fast.
Okay. But
very weird for her to say on direct, and I agree with this impeachment, that the pregnancy was a surprise. It's like you wanted a baby. Everybody knew you wanted a baby. Vasectomy reversal, you get pregnant after that. So that was good impeachment. Again, I would not have exactly said it in a sarcastic way that she did necessarily. You could have said, okay, let's take the timeline. Let's just confirm you said the pregnancy was a surprise, okay? When you got married, you wanted children. Doug knew you wanted children. One of the things you did to try to have children was you get the vasectomy reversed. Then the other thing you try to have children is intimate relations with your husband. So you did all of those things, and the outcome was you got pregnant, right? So it wasn't a surprise, was it? Just line it up a little softer as opposed to like these punches that I feel like are a little too quick and sometimes miss the landing. But she's right. How is this a surprise? Why are you saying this is a surprise? Are you saying it's a surprise because you actually knew he wasn't dangerous? Is that why you said it was a surprise? Because you knew he wasn't dangerous. But now you have to act like he was dangerous, right? Those are appropriate impeachment and cross-examination questions, I think. And again, still with respect for that she may be in fear and maybe she was in fear in the past. Maybe she was in fear here. Maybe she overreacted. I believe she wanted to end his life and it was planned. And that's what I believe as the prosecutor. I'm not saying I believe that. I'm saying if I'm cross-examining her as the prosecutor, that's how I would have taken it. That's how I would have attacked it.
It did.
Yes.
How quickly? When did you get pregnant?
I guess July.
And right around this time is when you say the incident happened where Doug threw a gun at a...
So maximum lover, Peter, you can be surprised by pregnancy because you were told it would not happen right away. That's just not a surprise pregnancy. Come on. I am with her. Okay. I think that she was in reasonable fear, and I don't think the state has proven the depraved heart that she had at the moment, and they definitely haven't disproven the self-defense. Now, they have a rebuttal case, so we have to wait. We can't make our decision until we hear the state's rebuttal case. But I am also allowed to logically believe, because we never had a surprise pregnancy, but my family members, my friends, a lot of surprise pregnancies, and this is not how they go. Maybe it happened sooner than you think. Maybe it was earlier or later, or you didn't think it was going to happen and then it did. And it's that kind of a surprise, but it's very different than like, I was afraid, I was planning on leaving him, but then I got pregnant, so I had to stay. That's kind of what I think it sounded like they were trying to do with the defense story. That's just my take on it. And I think that was a good impeachment by the state myself.
Wall.
He threw it at me.
Shot a gun at the ceiling. I think you made several allegations, correct?
Yeah, he admitted to it, but yes.
What were you arguing about?
I think Eva was part of it. I don't specifically remember.
And wasn't it true that you had a problem with Eva and you thought she was disrespecting you at that time?
I wouldn't say I had a problem with Eva. There was a lot of tension in the house, but yeah, there's a lot of things going on that were not ideal.
You knew she was 15.
Yeah.
And you knew she had just lost her mother tragically to death.
Yeah.
And you were how much older than her?
10 years, 9 years, 10 years.
And
obviously there's going to be tension there, right? Your dad marries somebody your age. You would expect them not to like, you would expect Eva not to like her. I don't think there's any surprise there. I think the state went on a little weirdly long about this shadow box thing to talk about this, but I think what they're trying to make it seem like is Ashley's manipulative and mean to Eva, and that created problems between her and Doug. But if that's the state's theory and that created problems between her and Doug, how does that help the state if Doug was mad at her about this and angry and getting violent with her about this? Like, I don't know how that helps, but it definitely, I guess, makes Ashley Benefield look unsympathetic to Ava. I guess that's what they were trying to do, but there was a lot on this, I thought.
Tension surprised you?
No. I mean, at first he had told me that she was really going to love me and that she was ready to have a woman in her life and that he wanted me to move in quickly because she needed a mom. So he made it sound like she also felt that way.
And you had no feelings of your own?
I was excited to get to be her stepmom.
And you gave her a shadow box right around this time, correct?
For Christmas, so it would have been in December.
All right. And what was the shadow box?
You want me to describe it?
Yes.
It was like a small picture. It had like deep sides and like the glass was at the front of it. And there was a sand dollar that I had painted and decorated. And I put it on like a black cardstock. And I wrote.
So Eva walked out. Okay. And I didn't hear the judge say anything or do anything about this, but it's hard because I feel horrible for Eva. I do feel horrible for her. And I think her rights should absolutely be protected. But I think that's extra judicial stuff happening. That's not evidence. That's not how a jury is not supposed to take things like that into account. And they obviously see her walk out in the middle of Ashley Benefield explaining this. And we're also finding out right now, this interaction, this exchange, I believe, because we know the prosecutor wants to call Ava on rebuttal, that this is what they're going to call her to talk about. So that I felt was something the camera this exchange with the shadow box. But what I'll say, because I'm trying to focus on what the charges are, what the trial is, what happened that night. If this shadow box discussion and argument made him wave a firearm around and blow a hole through the ceiling and say he's going to use it on himself, then I believe, I'm sorry, but then makes her story more credible, that she's telling him to leave. She's telling him they're not moving in together. He's saying he doesn't have to leave. She's trying to run away. That would be enough to make him also react in some kind of aggressive or wild manner that's going to make her in fear. That's what this story is setting the stage for me, that I see as parallels, that the state is setting up. And the state is saying that's what made him so angry. This shadow box and you saying his teenage daughter is disrespectful, that is what made him so angry to have this firearm incident when he shot a hole in the ceiling.
Correct?
He's still yelling at me. Yes.
And you're not yelling at all. And the fact that he had a gun with him when you continued to argue in the house was because he grabbed the gun from inside the car to bring his items from the car into the house, correct?
I'm not sure why he had it, I guess.
Okay. And it was in a holster.
I believe so.
And you both used to carry guns.
Mm-hmm.
You carried guns on a regular basis.
Yes,
you have had at the time more than one gun.
Yes, ma'am.
And you actually bragged, as well as Doug, about having guns, correct?
Yes.
And you would go shoot them on a regular basis.
I haven't.
The answer is yes. That she bragged about having guns. Like, I mean, she's not really trying to quibble about a lot of these questions. And RJ said, I found her more believable on cross than direct. That's never what you want to hear as the lawyer that's cross-examining the witness. Leslie said, do we know the timing between her getting pregnant and her finding text messages of his previous wife? Again, I don't know, because I don't feel like the state did the timeline, but they did say, you knew he did this. You knew he said this to you. He did this before getting pregnant. So they did definitely say she knew about this. But again, I'm not sure which exact instances happened before and after. Maybe the state will line that up in a closing argument timeline. I hope they do, because I do think that would be a good visual for the jury. I feel like sometimes the DA is mocking at times as if the D cannot be happy or take a happy pick after being abused. That's the cycle: abuse, apologize, and sprinkle love on top. Yeah, again, that's why when I deal with any of these cases or dealt with them in the past, I would always give somebody the benefit of the doubt, right? Even if I didn't believe them, I wasn't going to mock them. I wasn't going to try to make them feel it again or show me exactly what happened or, things like that. There are ways to win cases. There are ways to make points. There are ways to prove facts not like that. But then I see a lot of prosecutors doing this to defendants in all sorts of cases. Let's make the jury hate them. Even in injury cases, when I represent a plaintiff, the defense attorneys try to say, let's make the jury hate that person. And sometimes it works, right? Sometimes it works. It's not usually my strategy. Peter, what would the jury instructions be to find her guilty that she had a depraved heart and she wanted to hurt him or end his life at the time, and that she was not in reasonable fear and defending herself because she was in reasonable fear of serious bodily harm or death? And we'll talk about that more as we get to the jury instructions.
Into the range since before the presidential election.
Okay. But during the time that you met Doug at a political event, you had one of the guns in your bra.
Yes, that's where I can still carry.
Okay. So having a firearm in a car or in the house is not that unusual to you.
No, ma'am.
All right. So after you get back inside, there's this argument that continues on and on and on and on. And you're still asking Doug to discipline Eva.
I don't recall that.
And you say he was waving a gun around and threw a gun at you. Is that what you said?
Yes, ma'am.
So he has a gun in his hand, could point it at you.
He did point
but
it
he
at me.
throws a gun at the wall.
No, he threw it at me. He missed me.
Okay. And it hit the wall.
Yes, ma'am.
Okay. When was this? What was the date of this argument?
I believe it was the end of June.
2017.
Yes, ma'am.
When was your wedding reception?
It was shortly after that, maybe like a week or two later. I don't remember specifically.
Okay. So even though you've been married before, you were now having a wedding reception.
Yes, when we got married, it was just the two of us.
And at this wedding reception, you had a lot of guests come.
I'd say maybe a dozen, like my friends and family came.
And they're dressed up.
Yes.
You're in your wedding dress.
Yes.
Okay. And I'm going to show you State's Exhibit 10. I want you to tell me what this is. I'm sorry, it's 100. I want you to tell me what this is.
So this is the state trying to prove that all that horrible stuff happened and he did that horrible stuff and she was so scared, yet she had a reception and everybody was happy and everything was good and everything was fine. Which again, two ways to look at that. If you're the jury, you can be like, oh, see, she wasn't that scared. She still wanted to move forward with him. I know they were already married and the reception was later, but still. Or if you're the defense, or if you believe the defense, you would say, these are the abusive cycles that happen. It's not like every day he's abusive. It's not like every day he has to be abusive in order for this to be a legitimate fear. So it just depends on how the jury sees it.
It's going to come up behind you. What is this a picture of?
That's a picture of Kevin, Christy, me, and then Doug.
Okay. And is that a picture from the wedding reception that we just talked about?
Yes, ma'am.
I'm going to show you State's Exhibit 101. What is that?
That's a picture of me and my friend Christy.
And is that at the same wedding reception?
Yes.
And State's Exhibit 102. What is that?
That's a picture of my friend Laura and me, and then my friend Christy.
And this is also at the same reception?
Yes, ma'am.
Okay. State will move into evidence States 100 through 102.
Any objection? I'm sorry. Any objection to States 100, 101, 102? No. Proceed.
Thank you. And in States 100. Are you scared here of Doug?
No, I would not say no.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Were you living the nightmare here?
Oh, no, not at that moment, no. That was a very nice day.
How about at this moment?
Oh, it was a good day.
And States 102 at this moment?
Same. It was a good day.
So you get pregnant and you decide to move in with your mother. So when do you decide to move in with your mother in Florida?
It was the end of August, I believe. I was really sick, and he brought me down to my mom's house and dropped me off.
Okay, but going to your mom's house was your choice, right?
We decided together. He said he couldn't take care of me. He was too busy, and that my mom could take care of me better. So I was happy to go.
You needed someone to take care of you while you were pregnant.
I was really sick, yes.
Okay. So you moved down with your mother, maybe August of 2017, you said?
The end of August, I believe.
Okay.
I don't know if she was trying to throw shade that she needed to be taken care of while she was pregnant, but like most husbands like taking care of their wife when they're pregnant, right? I mean, like it's a joyous time. It's a difficult time. It's a time that I personally don't think I can handle myself. So I'm happy to take care of the person who's doing the hard work in pregnancy, right? So I don't know why there would be any shade with that.
But there's still this issue of the injunction in South Carolina while this is going on, this South Carolina Florida thing, correct?
I'm not sure I understand the
Well,
question.
you said you applied for the South Carolina injunction, or you received the South Carolina injunction right around that time in 2017. Actually, I think you said November 2017.
Yes, a few months later.
So shortly after you moved in with your mother, a couple months, you filed for an injunction in South Carolina.
Yes, ma'am.
And we talked about the fact that, or you talked with defense about the fact that it was a mutual injunction.
Yes, ma'am.
So both parties agreed to stay away from each other, correct?
Yeah, I believe that it was for both parties to stay away.
No evidence was presented at this hearing.
I don't believe so.
None of your complaints were heard at this hearing.
There was like a written, like a filing.
But the judge, other than that, did not hear any evidence at the hearing.
That's correct.
All of that was forestalled because the two of you agreed, okay, fine, we will have this voluntary stay away order.
It was decided through the attorneys, but I believe that was, yes.
Okay.
Yes, ma'am.
So the judge never found that Doug Benefield was dangerous and ordered this injunction.
I'm not sure what the judge found. I don't know what you mean by that.
There was never a court finding giving you an injunction, other than you stipulated to it.
The judge ordered it, yes, ma'am.
Okay.
Like the judge never made a finding that there was an injunction. She's like, I don't know what you mean. She's like, but you guys stipulated to it. Okay. Usually on a stipulation, the court also finds it. It's like, okay, I'm finding that the parties have stipulated, so that's what I'm ordering. That didn't go well for the prosecutor because at the end of the day, they agreed to it. Judge ordered it. So there it was, the no contact. But she's setting up kind of, again, this is a story I have felt, if I'm being honest, the whole time. This is the strangest story. I don't understand exactly how it worked with the, tea stuff and the poison. Like this has always been something in my head, like seems weird, but I got to be honest. People going through relationship problems often, and sometimes they're right, but often everything seems like the partner or the ex is trying to do something bad to them. So I can understand how she kind of got there, but it does seem a little bit strange.
And this injunction, actually, part of it says that neither party shall harass or threaten or do those types of things to each other.
Yes,
right?
Blaney, I don't think it was staged. I hope it wasn't staged. It would be inappropriate for the prosecutor to stage that. But obviously I don't know the answer.
So then after you're in Florida, you get a package that you say was in violation of this injunction. And it's a birthday present, right?
Yes.
It's a tea set.
Among other things, yes, ma'am.
And you like tea?
I like drinking tea, yes, ma'am.
You drank tea all the time with Doug?
Yes.
Okay. And you opened this tea and you claim that it smelled so strongly that you automatically rushed it to the sheriff's office.
I didn't specifically sniff the tea. It was when I opened the box. The whole contents had a very strong chemical smell.
So you immediately rushed it over to the sheriff's office?
No, ma'am. I immediately sealed it up and I left it in my garage.
For how long?
I don't remember specifically. It was maybe a day or two. I don't remember.
It was a little bit longer than a day or two, was it not?
I don't remember.
So after this time goes by, you take it to the sheriff's office and you claim that this was a violation of injunction.
Right? It was, yes, ma'am.
And you also claim that this was all part of Doug's poisoning scheme to poison you and your unborn child.
Has not informed me that there was toxic.
I don't want to hear what someone else told you. I want to hear what you claimed, that this was part of his poisoning of you. Planned poisoning.
Well, based off of what I was told, that was
yes or no, ma'am? Yes or no? What, according to the way you felt, this gift was a part of his plan to poison you.
It concerned me, yes, ma'am.
So no charges were filed for that, correct?
Correct.
So you filed for an injunction based on the same allegations, right?
When my injunction in South Carolina was getting ready to expire, yes, I filed for one in Florida.
Okay. So when you filed in Florida, about what time was this? What date?
I could give you a ballpark. It was in the spring. I don't remember exactly.
Spring of 2018?
Yes, ma'am.
Okay. So you had left Doug in South Carolina August of 2017.
Yes, ma'am.
And you filed for an injunction in the spring of 2018.
That sounds right.
But you hadn't been living with him, correct?
Correct.
You hadn't even had any contact with him for a very long time when you filed for that injunction, right?
Other than him sending the box and, yeah.
So what violence were you trying to prohibit by filing this injunction? Everything that happened in South Carolina.
Well, I was just hoping that wouldn't happen again.
Okay. And at the same...
So how does this prove that she intended to harm him by filing for this injunction? If you remember back to the Adelson case, again, they used a lot of the family law stuff there to prove what was going on in animosity. But I feel like this is what somebody that was in fear of somebody else would do, right? Injunctions, no contact orders, stay away from me, leave the state. But then there are other things, obviously, that you would say, again, and this is something that's prototypical of domestic violence victims, but why would you want to co-parent? Why would you move to the same state as him? Why would you ask him to help you pack? Why would you continue to even have a relationship? But then she's Googling how to co-parent with an abuser. I mean, to me, again, her story lines up enough to me with how little the prosecutors proved beyond a reasonable doubt in their case. Maybe they're saving a lot for rebuttal. I have seen cases where the prosecutors do that. We'll see if this is one of those cases.
Time you did this motion for an injunction, you also did a motion to terminate Doug's parental rights, right?
Yes, ma'am.
Okay. So during this time that you haven't been with him in almost a year, at least half a year, there hasn't been any violence other than you say that he said. You're filing for an injunction all at the same time that you're trying to terminate his parental rights. This is all correct, right?
Sounds correct.
And you hadn't even had a baby yet.
As of when?
As of the time that you were trying to terminate his parental rights.
I don't remember what the date was, but it would have all been around that time.
And then there's the hearing that goes on for this injunction, right? And this is in front of Judge Moreland, correct?
Yes, ma'am.
Okay. And you had a 2-day hearing on this?
Yes, ma'am.
Partially, it was a motion for your injunction based on these issues, and it was also Doug's motion to be able to see his child, right?
I believe at some point things are consolidated, but I don't recall specifically.
So at this point, Doug had not seen his daughter?
Correct.
And your daughter was how old?
As of the date, like the last court date?
Yes.
About 6 months old.
And had there been any violence towards you between the time that you filed for this and the time when you had the hearing and she was 6 months old?
He had showed up at night in my driveway, but I mean, there's no physical contact if that's what you're asking.
Okay. And was this a time when the baby had been born?
I don't remember the date of when he was in the driveway.
How about, since we're talking about this, let's talk about the incident you talked about where the neighbor said that Doug was there. Tell me about that.
Yes, ma'am. He was outside standing in the yard at night, I guess trying to look in the windows of my house.
And where's this neighbor's house?
She's directly across the street.
Okay. And isn't it true, in fact, that this was very dark? It was very dark out.
Yes, ma'am, it was at night.
Okay. And your neighbor told you that she saw someone in her backyard walking, correct?
I think she said that when she confronted him, he kind of ran away.
Okay. She never told you he was at your window.
Right. And guys, we're all trying to do this together on each side. So like, this is a legitimate question by Sandy. Just like explain why, right? I don't want it to be like fake tears or whatever, but like what evidence has come out for those of us that did not follow anything else? Because I know there were reports and people are telling me, oh, you don't know the half of it. She lied about this. She lied about that. But like from what's come in at trial, where are the inconsistencies? Where are the big lies that they're catching her in? Because I'm trying to be respectful and see both sides and call out when I'm saying, yeah, I don't think it was a surprise pregnancy, or yes, maybe it's inconsistent of her to do this or that. But what else do you guys see that don't find her credible? And in a nice way, I don't really want to hammer her because I do think she went through a lot, regardless of if that night she was in legitimate fear of her life.
What she said was that he was trying to look in the windows.
In her yard?
The way the houses are situated, where he was standing, he was looking across into the windows of our house, yes, ma'am.
She couldn't see who this person was?
Object.
She told you?
She's asking Ms. Benefield about what the neighbor knew.
She told you she could not identify this person?
She said by just looking as dark as it was, she had a hard time identifying him by his face, but she identified his voice.
That's interesting. So let's talk about that. So when she tells you that there's somebody in her backyard, you go to her house, right? You end up together with her?
Yes. Right. Not at her house, but yes.
And you play a recording that you recorded like a voicemail from Doug for her, right?
She believed it was Doug, and she said that she could probably identify his voice because he had a unique voice. And so I played a voicemail I had from him, and she identified him.
She didn't tell you she thought it was Doug. You just asked her if it was Doug.
I believe she contacted us and said that there was a strange man looking across into our windows, and she was freaked out and she wasn't sure if it was him.
Okay.
I also don't see how the prosecutor scored any points with this story. Like, so we're supposed to believe that she forced this neighbor to say it was Doug, or did she play the voicemail and the neighbor's like, yep, that was him? Again, a jury would really have to be with the prosecutor to dismiss all of this.
I remember specifically. I'm sorry.
I don't see the need to bring this story up again on cross. I'll just put it that way.
This was a long time ago.
And you play a recording of Doug's voice for her?
Yes, ma'am.
And she goes, oh, that's him.
Yes,
that's the one that was there.
Yes, ma'am.
So that is the ID that Doug was in her backyard.
I believe she also described his body type, his stature. She said he was wearing a baseball cap, which he often did. So I think that was probably part of it.
People wear baseball caps?
She needs to go out.
I'm sure.
Before she cuts you off.
I've been able to follow along, so I'll rule at this point.
There's a lot of people that are 5'9", right?
Oh, yes, ma'am.
A lot of people that weigh 160 pounds.
I think that is like the average male height is 5'9", right around there.
Yes, ma'am.
A lot of people that wear baseball hats.
Yes, ma'am.
And isn't it true that this person in the backyard said to her, I live around here, I live here?
Mm-hmm. Okay. I believe so. I wasn't there for that part, but that's what I believe she told me.
Thank you. Now I want to move forward to 2019.
You made the point that the neighbor did not say it was Doug. Again, if that's how you take it, and again, if you think, and a lot of times at this point, the jury is starting to, go a certain way and starting to listen to the evidence. So, Bella Boo's like, yeah, she made the point, it wasn't Doug. It's like, okay. Or she said, I don't know who it was because I didn't know the person, but he's about 5'9" and wearing a baseball hat. And I heard his voice. Is this what his voice sounded like? Yes. So an unbiased neighbor, she didn't say the neighbor's your best friend or the neighbor's always helped you out or anything like that. She didn't create any bias for the neighbor. Said it was Doug's voice. I mean, how else are you supposed to get some? If this was the cops and they were like, hey, did you hear this voice? And you identified the voice and it was his voice, we'd all be like, oh, okay, good. That's an identification. But because it was her, the people that I think don't believe her say the prosecutor just proved the neighbor didn't say it was done. Which I think is just psychologically, it's an interesting way to see how people think. And I appreciate that, Bella Boo, for you letting me know that. Because again, I'm learning how jurors think the more we talk about this stuff.
Around this time, Judge Moreland had already ruled that you could not have your injunction, right?
She denied it, yes, ma'am.
And that Doug could have immediate visitation with his daughter.
She ordered time sharing, yes.
Did you start visitation with Doug and Emerson very shortly after that hearing?
Yes, according to the court order, yes, ma'am.
And you decided you were going to go with him on this visitation?
I offered and he said he would be glad for me to come, so yes, I went.
This person that you lived in a nightmare with, you decided to go with him on this visitation?
Yes.
Now, the Judge Moreland hearing, when she ruled, she made it very clear that she did not see your side.
Sustained.
You had no faith that Judge
Moreland made it clear she did not see your side. So that's what the prosecutor was trying to get in. Inappropriate, defense objected, judge sustained, but the jury got to hear it. So will it matter? We'll see.
was going to help you from that day forward.
Ooh.
You had no faith that Judge Moreland was going to help you from that day forward.
I don't know, say I thought she would never help me, but I mean, she denied the injunction, yes.
So you go for this visitation with Doug, along with him and Emerson, and that began sort of a, I think,
so that right there. So the next witness they call is that ASA, that the assistant state attorney that believed Ashley Benefield and would have moved forward, but she was transferred out of the office. That, in my opinion, if I was the defense, I would say that opened the door, Judge. The state said she didn't want to help you. The state has argued nobody believed you. Nobody on law enforcement, judge, or state attorney side was ever going to help you. And that's not true. There was somebody that believed her. Usually it's not appropriate. Usually this type of stuff does not come out. The judge didn't believe you or the judge wasn't going to help you. That stuff usually doesn't come out in these kinds of cases. You lost, you didn't get the injunction, fine. But if they're going to argue nobody believed her and somebody did on that side, I think that that's fair game for the defense to be able to do it.
Murphy called it like a honeymoon period or a happy period piece. Would you agree with that?
Yes, ma'am.
Okay. So during this time, you spent a lot of time with Doug.
Yes.
And a lot of time with Emerson.
Yes.
And you weren't scared of Doug at that time.
He was being very kind.
Okay. So you weren't scared of him at that time?
No. I mean, I had things at the back of my mind, but he was being very kind.
So then around summer of 2019, you actually make arrangements with Doug. He's going to move into your mom's house.
He wanted to move in, yes.
You actually agreed to that?
Not specifically. He didn't really ask my opinion. He told me.
Okay. And then the date that he was supposed to move in, you made plans with him, correct?
Sir, who's sprinkling the paper? Is that Mr. O'Key? Sir, please stop. Thank you. Go ahead.
So during this time, you're speaking with Doug.
Yes.
Right?
Yes.
And you're talking with him about moving into your home.
He was insistent that we needed to move in
Answer is
together.
yes or no, please. You were talking with him.
She interrupted the answer. If the question calls for yes or no, the questioner has the right to expect a yes or no, or I don't know, or I don't recall.
So
you to a narrative.
You were speaking with Doug about him moving into the house.
Yes. That people just, like, literally anybody that thinks that people just act like victims all the time in their life, publicly around all their friends and at work, and it's just not how it works. That's just not how it works. I agree, Charlie.
And about his things being moved and when they were going to be moved.
Yes, I'm sure.
And at any time during this, did you say to Doug, no, you're not moving in?
Yes.
You said no.
I'm sorry.
You told him, no, he cannot move in?
Yes, that's why he ultimately didn't move in. Is I said, I can't do this.
Isn't it true that, in fact, you didn't tell him no, you just weren't available the day he was supposed to move in?
No, that's not correct.
Okay. So you're saying the day he was supposed to move in, he knew he wasn't supposed to move in? Is that what you're saying?
We had a conversation that day and I told him that I didn't want him moving in.
Okay. And then you did not take his phone calls. You would not speak with him. I think the word was ghosting. You ghosted him.
I don't know whose word that is, but that's fine. Yes, ma'am.
Okay. But visitation continued.
Yes, ma'am.
Right. And you continued to exchange custody of Emerson where? The sheriff's office or?
I believe at the time we were doing the sheriff's office.
And sometime around this time, you show up to this visitation with an engagement ring on, right?
No, ma'am.
Okay. Who is Dennis Beatty?
Dennis Beatty?
Beatty. Who is that?
He was a gentleman I dated at one point.
And it was during this time you were dating him, right?
After I told him not to move in, and then we started just doing time sharing with Emerson. Yes, after that, there was a period of time where we dated. Yes, ma'am.
And isn't it a fact that Doug filed for a divorce after one of these visitations?
I'm not sure when he filed for divorce specifically.
He filed for divorce after he knew that you were dating this other man, right?
I'm not sure when he filed.
How did you find out? Did you tell him you were dating him?
No, ma'am.
How did you find out?
I think he was stalking me.
It wasn't the ring on your finger?
It was not an engagement ring.
Well, it was a ring. Did you see the ring on your finger?
I'm not sure, but I wear rings all the time.
So Doug filed for
I don't love that line at all.
divorce. And all of a sudden you file for, well, you started a bunch of complaints, correct? about his treatment of Emerson? What you said, his bad treatment of Emerson?
Well, she started coming home hurt.
It's a yes or no question. Did you file complaints about his treatment of Emerson?
Yes.
Okay. And you eventually filed.
So, Jackie, the question would be a reasonable person in her position, especially with the battered spouse syndrome, knowing what she knew in the past of past abuse with that context, and not just a reasonable person like me against Doug, but her and what she was feeling and thinking at that time, subjectively to her. That's the standard. That's what we're trying to determine. And again, maybe you don't believe that she was hit in the head. If you do believe she was hit in the head, how would you feel then? Would that change your mind? Because she's claiming she was hit and, her eye was swollen or whatever on her face.
Filed for another petition to get an injunction based on those incidences that you claim happened with Emerson.
Yes, ma'am.
Okay. And you complained about the first time and nothing was done. Is that correct? With the police, no charges were filed, nothing was done?
I'm not sure specifically what you're referring to.
The first complaint that was made
about
Emerson and Doug. You agree that you made allegations?
Yes.
Doug was abusing Emerson. Did you speak to the sheriff's office?
Yes, ma'am.
On numerous occasions?
I would say so, yes.
At least 5?
Probably yes, ma'am.
And during those conversations, you were making allegations that Doug was abusing Emerson, right?
I was explaining the injury she'd come home with, and I wasn't there. I don't know what happened.
Okay, but you were alleging that Doug was abusing the child.
I was concerned after her pediatrician called CPS and said that she thought she was being abused.
Are you aware that pediatricians are required to call CPS when a mother alleges that?
I didn't allege anything. I brought a video to show her at the appointment, and she called CPS. Well, after showing her a video of some behavior, she called CPS and she informed me that I was also a mandatory reporter and that it would be negligent if I didn't also call and make a report.
You brought Emerson to the pediatrician specifically for this reason, correct?
No, ma'am, she had her checkup.
But you brought this up to the pediatrician.
At the end, she asked if either of us had any questions.
And that's when you bring up, oh, she must be being abused.
No, I described to her the behavior that I was seeing, and I showed her a video when she came to her own conclusions.
Okay. So you spoke.
So again, I think we already know that she made all these claims about Doug. We already know that. Okay. That's already come out. It's clear the prosecutor thinks she's lying about those claims. I already knew that. Chris Mack said that sounds sketchy on Ashley's part. Okay, so maybe I'm wrong. Maybe we're seeing these differently. I don't understand how now we know the pediatrician called CPS. I don't care if you're a mandatory reporter or not. Pediatrician called CPS, and Ashley says after seeing a video and looking at Emerson, I don't know how that's better than you made all these claims against Doug. None of them were founded. No charges. Nobody believed you. We already have that evidence in. But maybe you guys see it differently, which is why they did it, right? And why there are different perspectives coming from a jury. And maybe she's convincing some jurors with this.
To the sheriff's office about that investigation and other investigations, and you about the investigations that Doug was abusing Emerson.
A sheriff usually comes out with the CPI from Child Protection.
And you spoke to them.
I mean, they were there when I was talking, I guess, yes.
And you were talking, making allegations against Doug, assuming that he caused injuries to Emerson.
I'm not sure of my exact words. I was trying to describe to them what I was seeing and my understanding of the situation at the time.
You filed a petition for an injunction based on those things, correct?
At the advice of my attorney, yes, ma'am.
Okay. Whether your attorney advised it or not, you chose to do that, correct?
Yes, I followed the advice of my attorney.
And you were aware.
That's a little too soft for her, in my opinion. I would say if I thought he was abusing my child, yes, of course I filed it. I don't care if people believe me or not. I'm going to keep fighting to protect my child, whatever it may be. Something like that. That could be used against her, maybe saying, yeah, it's right. You don't care. You were going to do whatever it takes, and you did do whatever it took.
If you went forward on this injunction, that it was going to be in front of Judge Moreland.
Yes, ma'am.
And this injunction hearing was supposed to take place on September 30th of 2020. Yes, 2020.
Yeah, it got moved several times, but that was a date.
Okay. So it was supposed to take place on that day.
Yes, ma'am.
And there were other things pending. Do you know what the other pending items were?
Not specifically.
Okay.
I'm not sure what you're asking.
One of them was Doug's request for a divorce, correct?
Yes, he filed for divorce at that point. Yes.
So Mr. Benefield filed for divorce. You file an injunction petition. Then you file for divorce.
I filed for divorce first.
Okay. And then you're scheduled to have this hearing on 9/30.
I mean, I filed for divorce first, and the state just saying okay to that, they lose again. I know because, trial practice and, law school and classes and what they tell us and how important it is. You don't say something in opening statement that's going to turn out wrong. I hammered Lally for it on the Reed case. If you're going to say something, if you're going to say a time like 12:45, don't be wrong. If you're going to say Doug filed for divorce first, which to me was like, whoa, that's a big deal if Doug filed for divorce first. And I remember that fact from opening, but then you just agreed she actually filed for divorce first. So then you start to lose credibility with me as the state.
Yes, the hearing is scheduled for 9:30. Yes.
And you're speaking with Doug during this time, right? I mean, we just heard 200 and whatever text messages between you and Doug.
Yes, ma'am.
So do you at any time in that say to him, I'm going to go forward with this injunction on Wednesday, on the 30th?
No, ma'am.
In fact, based on those text messages, you were dropping the petition for an injunction.
Yes, we talked about dropping everything. Yes.
So this is, them getting into kind of the motive of September 30th. She's talking about that petition for injunction. Let's see if and how she works in the report that Ashley was scared of. Karen said, whoa, 2.2K likes already. Let's shock Karen. Let's shock Karen Lodge here. Let's get it to 5,000 likes. Hit that like button if you guys haven't already. Yeah, Karen. Whoops. You're right, Karen. Let's get it to 6. Let's get it to 6,000 likes.
You talked about it, but you said you were going to.
Yes, ma'am.
And that is what the result of the mediation was. That there was not going to be any mediation, really, because you were reconciling.
Yeah, we agreed, I guess, in order to move to Maryland. My understanding, the attorneys were advising us to, if we close things down, that it would make it easier, like legal-wise, for us to relocate.
So you were telling Doug that's what you were going to do.
Yes, we were trying to work things out so we could go to Maryland, yes.
And drop the injunction.
That was one of the things.
And you wanted him to drop everything, right? The motion to release the report, the dissolution of marriage, you wanted him to drop everything.
No, we filed a joint stipulation, so we did get the report.
But then you asked him to drop that, didn't you?
Possibly. I know we kind of went back and forth with so many things.
Okay. You never had any intention of not going forward on your injunction.
Honestly, it was kind of one of those things that some days I thought that maybe I should, and some days I thought that I shouldn't.
So during this 1 week before you shot Doug, you're talking and you're saying to him things like, oh, we're packing boxes, we're getting everything together. This whole time, you knew you weren't going to stop that injunction hearing.
I hadn't decided yet.
Okay. Your attorney testified that you were going forward on an injunction hearing.
She was advising me to keep it.
Okay. So during this time, when you're telling Doug to bring different boxes, bring tape, you asked him to go to Selby Gardens, right?
Yes, we all went. I think we got lunch. We got Emerson so she could play.
Okay. And you are having conflicted emotions about whether to go forward on an injunction?
Yes, ma'am.
While you're out having these types of experiences with Doug?
Yeah, sometimes things are really good and other times they weren't.
Okay. And so how about, let's see.
So Dirty Dog and Kim R with kind of similar concepts here. And I definitely think it's true, Kim R. People would have been like, why didn't you complain if you thought he was abusive? Why didn't you file for an injunction? Why didn't you do this? Why didn't you do that? And that's what I'm saying. That's my point is you can't force a judge to agree with you. You can't force a cop to arrest somebody. You can't force people to do what you want them to do. All you can do is ask. All you can do is file the paperwork if you think it's legitimate. Do people use that as leverage in family law cases? All the time. It's horrible. It's despicable. But if you think abuse is going on and do nothing, that will be used against you. Just like going back with him is being used against her. Both sides are being used against her. But the way I look at it, the credible evidence, the timing of it, the corroborating evidence to what she's saying, it's hard for me to just say you're a liar. I think you're lying because I have a gut feeling about it myself. So I look at the other stuff and nobody's really disproving a lot of what she's saying. In fact, they're ratifying it and agreeing that he did all these wild things in the past.
I don't know the exact date.
When what? I mean, in your mind, it was very close to the time, correct?
Yeah, I'm sure it was right around there. I don't remember when it was.
And during this time that you were having these text messages with Doug and you're planning to move to Maryland, there's no violence going on.
No.
No.
I guess not.
He's not hitting you.
No, ma'am.
He's not choking you.
No, ma'am.
He's not shoving you around.
No, ma'am.
So this entire time, there is no violence going on.
Well, I don't know specifically what time frame you're talking about. I'm sorry.
But during this, let's say from 2018 to 2019, when you're not living with him.
I mean, if you classify violence as him like
I'm asking
punching me or choking me.
Violence during this time.
He could be rough sometimes.
Okay.
Yeah.
Did he ever punch you?
Not during that time, no.
Did he ever hit you?
No, ma'am.
Did he ever use a weapon against you during that time?
Not during that time, no.
So in between the time of 2019 to 2020, where you shot him, was there any physical violence?
I said sometimes he'd feel a little rough, you know.
But other than that, he never was physically violent.
He didn't like punch holes in the walls or anything.
Other than that, it's like other than the stuff we already know, he wasn't physically violent. Karen said it's probably 6 in one, half dozen in the other. I do think she manipulated, but his behavior is not good either. Listen, unfortunately, in our court system, again, family law court, almost always both sides are manipulating in some way, using certain things some way. So I'm not saying there was no manipulation. Don't get me wrong. I'm not saying that none of this stuff wasn't done to try to get custody or win the family law case. I'm not saying that. Who is the woman in the gallery wearing lavender? A bunch of people are asking me that. I have no idea. L, is there a nice way for a lawyer to call out someone they think is lying about DV? In my opinion, people are letting bias taint their view of the prosecutor. So yeah, I mean, I've given some examples of how I would ask it differently. You can't let it fly. I mean, when defense attorneys have to cross-examine victims that the prosecutor brings forward, it's really hard, and we've seen it be done delicately. It's not great. It's not perfect. There's no great way to do it. There's no perfect way to do it, but there are better ways, in my opinion, than this has come off.
Like that, no.
So when I asked you, has he been violent? You said, well, he didn't punch holes in the walls. Is that what you just said?
That's what I just said just now.
So punching a hole in a wall to you is a definition. When I asked, was he violent? Your definition of that is punching a hole in a wall.
I think that is violent.
Okay.
I'm not sure what you're asking.
You know any non-violent people that have punched holes in walls? I mean, they don't punch holes in walls for fun. They got angry. Doesn't mean they're always violent. Just because you punch a hole in a wall doesn't mean you're an abuser. But I mean, you do have to get to a certain anger level to punch a hole in the wall, I think.
So just a second. Right?
Yes, ma'am.
And you're moving on, or you have a hearing on Wednesday.
I believe that's correct.
And you're moving right after.
I think the actual day of move was kind of in flux. It seemed like it changed 1,000 times.
You're all getting in the car together, not together, but you're driving cars together to go to Maryland.
So Ken, I may have missed this. I'm not sure what the intelligence insulting lie about the leg shot, like that he slipped and his legs went up or fell backwards and his leg went up. What's a plausible explanation for how the bullet entered his leg from below? She was laying on the ground. Does that make it more scary for her if she's laying on? I don't know. I'm not sure what to believe with that stuff, honestly, with the leg entry and exit wound.
Yeah, I believe he was going to be driving the U-Haul and pulling his truck. And I think that my mom was driving her car and I was driving mine.
And you were telling him during that time that you were going to move to Maryland and attempt to reconcile?
No, ma'am.
You weren't telling him that?
No, not in those words, no.
Did you hear Dr. Broder testify about that? That he said that when you were with Doug, so you're denying that you ever told Doug that you were wanting to reconcile with him?
I said I wanted to find a way that we could do things together as a family for Emerson's sake, and that's why we started doing things differently. He wanted to move back in, together, and I told him that I didn't want to do that. I didn't feel comfortable with that.
Did you say that?
We're back, people. Hello, Casey. How are you doing, my darling? Hope you're well. Right, court's back, so we're going live. I don't want to miss anything in court. Mofos, they've just gone back to the thing. Oh no, they're not. Yeah, they have. They are definitely back because I could see Ashley sit down. They've gone back to that, but they're definitely back. But so we'll stop that there. We're back. Guess who's back? We are back, people. We love it. I don't care. We love it. Have you all done it? Have you all done the press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. There you go. Bit of a sing-song. Oh, well, literally, in case you think I'm lying, not that anyone thinks I'm lying, but that's them back in court.
Calls their next witness. Oh, I'm so sorry. I was looking right over top.
Welcome back, Amy. Nice to see you, darling.
Oh, it's a good point. We can check and see if this thing's working again.
It should be.
Because the Amy is from California. Wow. Da 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 da. California. Da 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 da. In the city of Para. In the city of Para. Da 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 da.
All right, looks like my real-time viewer is working again.
Hello, Diamond Dave. Hello.
All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 3014. Is there anything we need to talk about before the defense calls its next witness?
No.
All right. As soon as the jury comes up, let me know and we'll bring them on in.
Hey, Amy. I got a new song now.
Yeah.
I'll say, hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. El Chatty, don't be afraid to have an opinion in this chat. The minute you let the trolls under your skin, the mods will come in and make it better. Hey, Kimmy, go fuck yourself. You're not welcome in El Chatty. El Chatty will make you go fuck yourself. Don't come in here and Troll, Shawnell, Hefe. Hey, chat. How are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, ladies, spread out your legs and put them well in the air. Judge White wants to spread them nice and wide for his pleasure, the dirty old man. Hey, chat, how are you? I'm pleased to see you all today. Remember that you're all called El Chatty, even Heather, who is El Potty. Hey, Chat, let's go, El Chatty, let's do it.
Up, down, left, right, however you need. Loud, clear voice, and we'll hear everything.
Yes, sir.
Your Honor, with the court's permission, permission to treat as adverse.
Go ahead and approach.
Already, Judge is pissed. Because, like, oh, yeah, this guy was in the, in another hearing. He was just, like, being a dick, this witness. So I'm only playing that song for, during this trial because people won't understand the judge's reference to have your legs up in the air. So I just want to make sure that people knew it. And people that don't know who Kimmy is a troll that called Sean out for having dementia. So fuck Kimmy. But yeah, we will change the legs up in the air one. Da, 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 da. I don't know what that face is, hippie chick. What's that? Is that an embarrassment one? Yeah, this is the legs up in the air was because the judge said, jury, spread your legs. I think he's pissed about this one because he made sure before lunch to say no, you know. Oh, anyway, it doesn't matter.
Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the lead on this case, were you not?
Yes, sir.
Will you tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information in the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right. Does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Do you recall being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair?
Yes, sir.
With conclusions supported by evidence.
Absolutely. Yes, sir.
Yeah. Not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pre-trial ruling.
Just asking the question.
Ruled at this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that?
Objection. Pre-trial ruling.
Sustained.
Did you describe?
Objection. Pre-trial ruling.
Go ahead and ask a question.
Let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield, that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from the front.
Hearsay.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front?
That's not the way that it appeared when we did our preliminary investigation with the medical examiner and then later on.
And it's your position today as you sit here that?
Objection, Judge. Can we approach this?
This is now ridiculous. The judge needs to stop this. Either he's not allowed to ask these questions, which is fine if he's not allowed to, that he's given a bollocking. Otherwise, the prosecution needs to shut the fuck up. Because all these, we need to approach, and all this, it's just too much. It's just too much. Also, yeah, I got what everyone's saying. Yeah, I think I might just take it out. The legs up in the air one, even though I like it. I think that the medical examiner said from the front, the side to the front of it, and that's why I think he's latching on to the front element of it. Because obviously, what came out in the media before trial was I was from the back. So even though it's technically to the side, it's still the front to the side, which is what I'm grasping is why he's saying it. And waving around like you just don't care. Put your legs up in the air. Wave them around like you just don't care. No, I thing is, it's fine if you know what it means, but I don't want someone walking in here and be like, "What the fuck? This dirty bastard is like telling me to put my legs up in the air and open them wide." Like, that's not someone I want to be watching. So I do get it. I do get it. So it's fine. I'll leave Kimmy in though. I like the Kimmy one in. It's funny if you know, yeah, but can you imagine if you don't know? People think I'm a pervert. Do you know what I mean? Hey, ladies, spread your legs, ladies. Emmy said front. Yeah, he did say front. I know it's technically side, but they emphasized the front as well. Hence why they're latched onto it, really. He shouldn't have really said the front, but who's the dirty Englishman? Shut the F off. F you. Please tell me what it means. If the judge said last week that the jury can get up and spread their legs instead of saying, whatever the saying is. So as soon as he said go there, instead of saying stretch your legs, he said go out and spread your legs. So that's why we did the whole spread your legs, ladies. So essentially. Front does not in the back, yes, but turn to the side. Yeah, I think it's because Emmy said it was in the front, and he's just latched onto that then going, it's in the front, which technically it is. So,
All right, members of the jury, I'm going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes, step back in the jury room. We'll get you back in as soon as we can. Remember, don't begin deliberations.
I know, that's the problem.
Talk to anybody about the case or do any research on the people, places, things, or legal topics you've heard anything about. Yes. Thank you.
That's on you. That's on you, Bev. DNS.
All right, sir. We're going to need to address some legal matters about your testimony, so I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss questions asked of you or your testimony with anyone. You're not to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
All right, the witness is out. So as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the longstanding doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pre-trial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the number one first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, That is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition. I don't see why that is not a fair game, respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield. And he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
What report is that?
That is a report that he authored, a supplemental on November 16th of 2020. And referring to Ashley Benefield as it relates to the victim, Douglas Benefield, he wrote or check the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will. And
on that form?
No, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form. It says bias motivation. He types in none, no bias. The next block says bias target. It's blank. And the box after that says bias circumstances. That too is left blank. Like me to show you.
First, I don't think he filled that out.
Even if he did, I don't know those points.
No, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
Thank you. The line of questioning that you seem to be starting with was the line of questioning at the stand your ground hearing where a narrative was established And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness, hit Ms. Benefield with a box? And I want to ask him if he knew who that witness was. And he's going to tell me it was Doug Benefield. And I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that rather than put a witness.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you can make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before, that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides are murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings. Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least two deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there has been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness. And the law is very clear. And I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, And I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge, can I ask?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people are killer murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said, I'm not going to seek a search warrant because I think Ashley Benefield was abused and I think her actions were justified? That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
State, anything else?
No, sir.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner. before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show them the DNA report and have them read the section that's applicable. We gave them business records notice.
Well,
hold on.
Okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to that.
I think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
the DNA
report.
Yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah, plus it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that the court may recall a crime scene swab, both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Ms. Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around, and blocked the door so she couldn't get out.
Yeah, but it's okay. Go ahead.
My objection are not to the business record certification, Judge. My objection is the contents of the report there has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There's not a witness that said, I'm speaking. There's not a witness who says that those swabs were taken from Ashley Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashley Benefield is hearsay. There is not a person at DNA labs that can say where those swabs came from. They only know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands, arms, and forearms for DNA evidence. And I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I've seen plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, Judge, I already said all those things, but it's just frustrating because they're all the steps to get that reported under certified business records have been skipped. And so although I don't object to that portion of it, it's the contents being hearsay and improper.
As a proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
That's not
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence. I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant. And you can ask him, I think, if that's his supplemental report. I think it's close, but I'll let you ask him, here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about and aren't solely to impeach. So, all right, let's.
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's meeting this witness and speaking what's on the report before the witness even says he wrote it or anything. So
right.
I would
So
prefer that he
establish if it's his report. Establish that down on right here. There's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So let's bring it back in.
The significance of the DNA is the fact that she's got scratches on her. So he might have skin cells of her under his nails and stuff like that. So the scratches could be, obviously, well, the scratches were of him scratching her. So would be under his nails. So that's just goes to prove that he did scratch her or he did, punch her and stuff like that. That's why the DNA is slightly significant.
You talk with other witnesses about their testimony or the questions asked of them?
No, sir.
You any research on the case, watch it at all?
No, sir.
All right, let's go and bring the jury in.
The timestamps are all over the place. I need to be better.
All right, y'all can have a seat. Welcome back, everybody. Did you begin deliberating amongst yourselves? Talk to anybody outside the jury about the case? Or do any research on people, places, things, or leave the topic? No. Everybody says no. You may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
Yeah, you documented in your report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify? Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
okay,
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
This section that says bias, isn't this for hate crimes?
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box.
Okay.
But
so this box is for those kind of statistics, not for any kind of bias that may be going on in this case.
Correct.
Thank you.
Redirect.
Do you think it odd that you were the lead detective in this case and
Objection
you weren't called
beyond
by
the
the
scope.
state?
Sustained.
Well, for nothing further.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
Do I need to stay in the building or can I leave?
No, sir, you can go, but you
Okay.
need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Call your next witness.
Try to come back to it. We call Dr. We call Michael Haag.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thanks, sir.
No, sir.
Appreciate it.
My name is Judge Ryan, presiding. Make yourself comfortable in that chair. Get about 12 to 15 inches from that microphone. You're just up, down, left, right. There you go. And just speak in a loud, clear voice. It'll pick up everything.
Thanks, sir. Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haag, H-A-A-G.
What type of work do you do, Mr. Haag?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a bachelor's of science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haag, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taking classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt, if you can spell it, Bundeskrim, ALAMT, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Toolmark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFSI is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Toolmark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haag, any forensic presentations of note?
I very regularly present, both at conferences as well as for organizations, on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which certification applies to an individual and accreditation applies to a laboratory, so those are terms you'll often hear mixed, but certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as toolmark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTE ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California and Texas and Rhode Island. And I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haag, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts. I worked cases from Iraq and many other places that I lose track of.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It can involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene. And then you move that system from one place to the next. So you can move around corners and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005. And since then, many departments have also seen the value of it, particularly with trajectories, in my opinion. And it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Haag, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course. And so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and then I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets?
Correct.
All right. And this information that was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand, in a way, where they'd been. This is sort of one of my main areas of interest, is the damage to projectiles. Sometimes, depending on their condition, when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down, and around. But it leaves you with a forward-facing area of the projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo or created through intense engineering by people at the companies such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't over-penetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see over-penetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haag, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take 1 of 4 off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable, tumbling. Before it got there, this is basically a nice stable bullet entry, and that bullet was recovered there. So that's 1 of 4. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which as I recall, this is bullet number 11 in the crime scene images, I believe. While it looks fairly mushroomed, it does not demonstrate soft damage. And the hole going into the bedroom wall is, again, a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's 2 of our 4 bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming in the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon class when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface. And those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable. It was going nose first to get that flat spot and be scratched directly from the nose to the base. It then continued on downrange and was stuck in the wall. That bullet gives us some idea of some trajectory, even though it's stuck in a wall just barely. You can, in the crime scene images, see it stuck in the soft drywall because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is. But that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area. So we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption, in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much because it's laying there just on the floor where it could have been kicked, could have been moved slightly. So we don't know where else it might have struck in that room. But the key thing about this bullet, and this is bullet number 5, as I recall, is that it does show soft damage. It is expanded. In the images, you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case, is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which, as I recall, enters on the interior left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have 2 things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to describe its validity. We make assumptions in science all the time that allows us to make further steps. So for example, we have two trajectories through the body. We have two trajectories into objects in the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway, and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom, and we look at those two trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those two shots. I can't tell you, with regard to sequencing, which one was first, but if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right, that's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those two trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body, but because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the two trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically two relatively opposing trajectories on an object that undeniably, in my work, objects, bodies, regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before with the two trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those two trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes.
Yes, please, Your Honor. Thank you.
Just mute you for a second. So let's look at the poll. Currently, we got 53 votes, 84% not guilty, 16% guilty. Obviously, that's a movement from last Friday, or Thursday night, Friday morning, when it was more like 45% guilty, 55% not guilty. So yeah, that's quite a significant shift. The majority of people think now it's not guilty, so, or undecided, which means not guilty. So yeah, that's good. Good little number there. So your vote would be not guilty. We could say, if you couldn't vote now, it would be not guilty. Yeah, we don't know what, how many shots there were, as in 1, 2, 3, 4. Still there, Bev. Still there, Bev. Well, there's 2 more witnesses to go.
Please.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Mr. Haag, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room. Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11, maybe. But if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there's an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that. And I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did two different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room. So the bottom wall, as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that, so green and blue. In the trajectory world with walls, this is decent agreement between these two methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5 degree cones, I talked about the error earlier, on both of these, we can see that those two cones look like that. That's actually a 10 degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
As to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, there, they'll fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
and that's another bullet, is that correct?
Correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct. But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that turf, just that plus or minus 5 degrees is an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haag, in preparation for your responsibilities in this case to interview Miss Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Miss Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
That's all, Your Honor. Thank you, Mr. Haag.
Cross?
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the two shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body straight.
Oh, this way?
Right. Can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes. I'd have no way of, yeah, correct, yeah.
Thank you. No further questions.
Redirect?
No, sir.
Can this witness be released?
Yes.
Yes.
Sir, you're releasing your subpoena. You're free to go.
Thanks, sir.
Thank you. It's going to take you a minute to put that away, and it's about 10 minutes after 3, so I'm going to give you your afternoon break.
Dennis.
10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. So no deliberations, don't talk with anybody about the case, and don't do any research. All right? Figured that'd be better than having you
hustle. Thanks, sir. Appreciate it.
All right, we'll stay in recess for 10 minutes.
There you go. Dennis was you were guilty on Thursday, Dan. She treated him with a lot more respect than she has other witnesses. What a great witness. Yeah, very good witness. I agree, Gary. Oh, we'll see. Whatever will be, will be. Dee-dee-dee-dee-dee-dee. Da, 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 da. What does our latest poll say? Terry, the poll says 157 votes, 17% guilty, 83 not guilty. So yeah. And someone was it LC was saying Melanie Littles was over 80% not guilty as well. And I think that to be quite honest, I've not looked at other streams, so I don't know. I've only gone by what LC said. 80% were not guilty on Melanie's as well. But hey, we'll see. I was at first. The prosecution sucked. Yeah, they did absolutely suck. Absolutely sucked. That's the worst prosecution team. That's the worst case I've ever seen put together. The how did they put this together for Murder 2? I do not know, but it is what it is. It does get chilly. You don't need a hoodie in Arizona, Stormcat. You say nothing, I agree. Zach, the defense is getting stronger, in my opinion. The prosecutor's very lacking. Why do they seem to always overcharge? I don't know. It's definitely overcharged. I agree with you. And yeah, I agree. Defense is just. But obviously, we don't know what jury's going to do, but the defense are knocking this out of the park, in my opinion. But there's other people with different views on that. Some people don't think so. So, from what I see, I agree with you, Zach. So true to learn. Let's go, Amy. Hello again, Bella. I'm good, thank you. Hope you're well as well, Bella. Consulted Lally. I mean, I'll be honest with you. I think these two prosecutors are worse than Lally. Because you could consider there's two of them, and they're super bad, super bad. Does get cold. Well, I go with my lovely mod Josie. Josie tends to buy t-shirts, and she's in Arizona, so I'd say that's probably your best bet. T-shirts, or one of each. Who last? I don't know. I don't remember what they said. They did name them. I just don't remember what they are. He might not use all two, mind you. He probably will, but we'll see. Mr. O, how are you? Hope you're well, fella. Hope everything's going well with you. Now, do you all remember? Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribed. Yeah, hopefully you've all liked and subscribed. I'm not gonna play the other one. Hey Jude. I'm not gonna play that one. Not from what I've seen. Lally outright lied about evidence he had misinterpreted intentionally. I would say that these prosecutors have done exactly the same. I think that this should even be a trial. So, and there's two of them. The two of them have done that. Dylan, I've had you on TV, and today has been another crazy day. I hope, yeah, it's going to be crazy for the next few days for you. With losing a dog, it's always not nice, is it, Chrissy? T's and P's, though, Chrissy. Did you have to go? Was today the day you had to go and pick up the ashes? You did say as well. I don't remember. Tony Taylor has done a great job considering it's only him and his paralegal. He has been a lawyer for 42 plus years in Saratoga. I think he's semi-retired. I think he's like 70 years old. I was like number 83 or 84. What's that for? Oh, for likes. Cool. No, that's good. Amy Lynch is like Amy Lynch is in California, so she's 8 hours behind us. So fair play to Amy for being here. You get the best ratio of guests to likes of anyone I've seen. Oh, yeah, we don't get the same numbers as everywhere else because some people don't like me or don't like my style. You got to be look. If you are here watching a trial with me, you've got to be a little bit weird. Do you know what I mean? I'm not going to go in depth about everything. You can have your opinions, and there's a lot of intelligent people here, and you can free to discuss it. I'm not here to educate you. I'm here to just learn the same as you guys. Every time I stream, I feel like I get more experienced with it. I like to give it as a viewer's perspective, and I don't think most of the channels do that. So I think you can go and watch it with Manny Little, which is great. She's fantastic. But then you get it from a lawyer's point of view rather than a juror's point of view. Where here, I think you get it from a juror point of view. But yeah, you definitely have to be weird to be here because I sing and stuff. So you got to be weird. No, my hub's friend hasn't been able to be reached. Made him call a welfare on his friend as his friend has no one. Yeah, he passed. Tomorrow is Ashes. Okay. Tomorrow's Ashes. Okay. I hope his friend, your husband's friend's okay. So sorry for your loss. T-shirt. There you go. Stormcut. This is Josie speaking, and hey, Stormcut. Just you and me speaking here, right? I've muted the whole chat, right? So it's just you and me, right? Piece of advice, right? If Josie says buy a T-shirt, just buy a T-shirt. You don't fuck about with Josie. I've learned that the hard way, right? She spanked me a few times now, so don't cross it, man. Right? I'm going to pull it all back now. Here we go.
I'm not
And
sure
we're
which
back.
one that was on. I
No
think it
chat.
was on
On the
young Mr. Galvano.
yes.
We are
Some of my
family.
music as
No, I'm in Wales.
well.
I'm in Wales. Yeah, we love it. Yeah, I like it as well. Everyone says that as well. Where are you going to get serenaded by the chat? Nowhere.
And who's this last witness going to be?
This is Dr. Emma Lew, Your Honor, LEW.
Well, don't bring her in yet. I was just asking.
Emma Lew. No judgment zone, no. Damn, I'll get 2 T-shirts and double up with the cold.
While we're on the
Told you.
subject, how long do you think she's going to be? More than an hour?
Probably not. I would say maybe 45 minutes, my best guess.
No problem. I just versus 4 hours.
Correct.
All right.
No problem.
State, have you already deposed her?
Yes.
All right. So
Yes.
you know she's going to say,
Yes.
presumably what your question is going to be.
Yes.
I only ask because that will take us, assuming we start in the next, 5 or 10 minutes, 5 minutes, to 4:20. And I guess at that point, probably let the jury go for the evening. Well, you can announce you rest. We can let the jury go for the evening. You guys can say if you're going to call any rebuttal or not, but then maybe one pass through the jury instructions. I'd appreciate that.
So would I.
Okay.
Judge, the last thing the state wants to bring up is that we didn't bring it up during the question, but I think that Your Honor had clearly told Mr. Taylor at the bench what he was allowed to ask Detective Warren. And that did not include, don't you find it odd that the state did not call you as a witness? And I think we had litigated close to that issue, if not directly on point, and then you directed him not to. And I know we're down to a few witnesses left, but it's been an ongoing attempt to subvert justice by Mr. Taylor to continue to do things like that, speaking when we've objected and continuing to speak. And as to the, don't you think it's odd, it was actually Mr. O'Keefe who told Mr. Taylor, hey, you need to object to this. So that's a whole different objection I have that Mr. O'Keefe continues to practice law in this courtroom. But I just think that at this point, the state is asking for you to sanction Mr. Taylor in some capacity about disregarding your continued rulings. And I understand that that may not be something we address right now, but it seems to be an ongoing issue in the state. That last one with Detective Warren was the most outrageous.
Okay. I'm not going to take that matter up right now.
Yes.
We got witnesses and other matters to deal with, so.
I just wanted to get it on the record before we move too far away from the witness. Thank you for letting me be heard.
Absolutely. All right, looks like we've got everybody back. Is Dr. Lew ready? Staten, you ready?
Yes, Judge. Thank you.
I hate these prosecutors. Unbelievable.
All right. We'll bring them in. Do you need the?
I don't think so, Judge.
These prosecutors told me everything I need to know about them when they didn't even put the lead detective up because he was so corrupt and he made a shoddy investigation. That tells me everything I need to know about these prosecutors. Motherfuckers, mofos. They know that there's no jurisdiction for this, but they still did it. Fucking shady. If you cannot put a lead detective on to a case, that means you're shady as fuck, and that's bad, in my opinion.
All right, you all can have a seat. Welcome back, everybody. Any deliberations, contact outside the jury about the case or research? Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Dr. Emma Lew.
Case in front of you, right in this morning.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon, Doctor. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone, just to get a loud, clear voice. It does adjust up, down, left, right if you need it.
Yes, thank you, Honor.
Good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Lew. Let's take a moment. Let me just run you through your undergraduate education. Where did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Lew?
I wanted to train in the best facility that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Lew, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Lines security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Lew, what is an autopsy?
An autopsy is the examination of a dead body. It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Lew, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Lew, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
And yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right fifth rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you a picture and have you explain to the ladies and gentlemen of the jury. You mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay. So how, Dr. Lew, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Lew could step down. I wonder if we could have the easel so I could set these up. Dr. Lew, here is a pointer that will help you.
State, feel free to reposition as you need so you can see what's going on.
Thank you, Judge.
With the court's permission,
Yes,
I
ma'am, you
ask
can
Dr.
step down.
Lew to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to start with? Okay, with this one. All right, would you tell us what that represents, Dr. Lew?
This is the grazed or superficial gunshot wound on the outside of the right upper arm. I know there's
Yes, a rod. We have three.
Now, the reason I know that this is a Graves gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here inside. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this V-shaped tag? And for simplicity, how I remember pathways of Graves wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back. Going from front to back and upward. And because it's on this part of the line, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because this back portion that's straight was an incision made by the doctors in the hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back. Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right fifth rib and the right lower lobe of the lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passes by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
All right. I think you can probably return to your seat if you like. Does it have some water in it?
It does. It's too complex for me.
Let me see if I can help.
Not too much. It's me. Probably the right orientation.
Dr. Lew, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
At the time that you observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Here's the
evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance.
I'll sustain.
One last question, Dr. Lew, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20 some times more after I retired.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Lew. Give me just a moment, Your Honor. Dr. Lew, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
Come on up, Will.
May I step down, Your Honor?
Yes, ma'am. Please do.
May Dr. Lew step down?
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield was coming towards her.
Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Lew. You just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusion.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
But she can give her opinion, just can't give what Ashley told her. If she believes that is, how? Cross her. You can ask her, how do you believe that? You know, you've got every opportunity to cross her and ask her, how? How do you know that? I don't know how she would know that, but she's got a reason. I think the judge likes her because she's very professional. You know, she said that she's testified over 500 times and 20 times since she retired. You know, No, she's allowed to speak with AB. She wasn't allowed to say anything that AB told her. If that's her opinion, I don't know how she would work that out, if I'm being honest with you. But because the experts can't figure out, so I don't know how she would. But that's what crosses this one.
Dr. Lew, without regard to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm grazed gunshot wound was the first shot.
Are you able to say why? What independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now you've told us, Dr. Lew, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
The right side facing the judge.
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
Judge, I'm confused as to what we're demonstrating.
We're demonstrating the shot to the leg.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand and reposition yourself.
Now, the entrance was on the right side of the entrance was on the right side of the back of the cab, and the exit was here. Now, you can see that the gun would be somewhere along here. So you can see how consistent this pathway would be from getting shot while it's on the ground, with the gun being in this position. So it's going in here and coming out here.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Lew, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
The evidence on the body, which consists of those gunshot wounds, is consistent with that.
All right. Thank you very much. Thank you, Will. I have one last question for you, Dr. Lew. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Lew. I have no further questions, Your Honor.
Ross.
I just want to ask you about the leg wound.
Yes.
For a moment. You're not saying that that is the only position that he could have been in, are you?
No, I am not saying that.
Okay. So there are other positions that maybe could have produced that wound path.
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked, maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly,
So,
yes.
So if he is walking towards someone, would he fall backwards with paralyzed legs?
Well, we weren't there, so I don't know exactly his body positioning and movements.
Okay. And you spoke about the abraded contusion on the head, and that can be consistent with falling.
Yes.
From a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head would be struck on something, because the contusion is a bruise, which requires blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of abraded contusion on the head?
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
Correct. One. Dr. Lew, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
No.
All right, can this witness be released? Can the witness be released?
Yes, sir.
State? Yes. Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much.
Well, that was a good ending.
Mr. Taylor?
We have this one issue left.
Okay. All right, members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back in a second. Okay, oh, you all can have a seat. The jury's out. And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Ladies.
Thank you.
Yeah.
Yes, sir.
The Lions suck as well, mighty. I'll get Mighty Meat all revved up. Dave, J Love, highest paid quarterback now in the league. That means Green Bay going to suck the next 4 years. I'll mute you for a second because they're not speaking. So once we see the judge speaking, oh, hang on. Do you know what I'll do? I'll put subtitles on. Once they start speaking, we'll be able to see it. Then I'll unmute. Well, blame the boss, Mighty Meat. Blame the boss. I heard your boss is a bit of an arsehole. He's a bit of an arsehole, I heard, Mighty Meat. The 2025-26 Super Bowl champions, Detroit. We got the title in hand. Dave. Oops. Oh, I thought I was supposed to say here. Dave, you have messed yourselves up with J Love, son. No pack, no. Tell him, you're fired. Mighty, you're fired. Oh. Who cares? You should. You fucked yourself over for 4 years. And probably more. Jabba's going to be insane this season, Dill. He's killing a camp. I don't know. Hello, Patricia. Hello, darling. Hope you're well. Toots, drink in hand. Just coughing. Skull. Hey, the Bears. The Bears. The Bears necessity. Turn into Mighty Meat. Look at the Chicago Bears, Mighty Meat. Let's go, son. Happy days, Patricia. My boss sucks really bad. Yeah, he's slightly crazy and a total ass. Yes, I would agree with that. Always so negative. Yes, agree. And harmful disinformation. I would agree as well. I am. Thank you, Patricia. You are. We got what we need. Youngest team in the league, and you don't, and you don't what? Don't what? You don't what? You are stuffed, David. You are stuffed. Judge both said not feeling well. Yeah, they said that this morning as well. Both of them got colds. They're both ill. Flu-y cold stuff. I want to go to the gym, but don't feel like it. This computer's draining me today. I know that's the trouble with sitting in front of the computer. It does drain you, doesn't it? Who that? The Bears. The Bears necessity. Vikings a bit will hold up the bottom. Nah, not this year. Joe, that is right. I forgot imaginary that. Imagine that. Hey, I believe the perfect worker for Mighty then. Bears suck. Caleb Williams the best. Nuh-uh. I tell you now, Green Bay is going to finish last in the league this year. Or the Vikings, one of the two. Depends on the Vikings. See how Sam Darnold turns out. Who does the DA want to fight about now? What? They talk about the DNA report. The defense would submit it. They don't. Prosecution don't. Sounds better than chatting with you all. Drink in the hand sounds better than chatting with you all. Uh-oh. Haxter's in there. Haxter's getting. Shut it, chappy. Here we go. She's getting cheeky now. I think the Houston Texans are the wild card and the team. I said that last year. I thought they were the best team last year. I didn't win anything significantly. I thought they were fantastic last year. Maybe probably the fly in the courtroom. I need to send you a message to join my fantasy league, Dale. Remind me if I don't say. Yeah, I've never done a fantasy league before, Mike D. Really. So I'll join you. I don't know anything about it, but yeah, I'll join. McCarthy still lives with his parents. Hey, good on him. Save some cash. Sensible. He lives in that area, so that's quite sensible of him to do that. But I'm not sure if he still lives with his parents, because they don't live there. I don't think. Don't think so. Anyway, I think they live a fair distance, not fair distance, but they live away from there. Planning on going to Canary standoff at our state house tomorrow. Oh yeah, Tuesday. Yes, that's a true one. Process these days, I'm trying to move back with my parents and they won't take me. He sucks. What? J Love. J Love. He sucks. Green Bay. The Green Bay sucks. What the hell? Why is this judge not doing anything? Come on, judge. And they have got a really good wide receiver in on the free agency. Oh, here we go. Oh, I thought it was. Oh, no, Amy. Stay safe, Amy. Quick, stay safe, Amy. Happy days. I'll take a shot. I don't.
All right. Go ahead, sir. I've had a chance to review shorter.
Okay, so this was a DNA report, precisely what the circumstances are here. The state initially wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the Shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Judge, I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, just that lab report in evidence. This is very confusing. It's DNA, and it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where the swabs came from, all those things. And I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation and that they're confusing.
Sure.
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Norbeck testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any. The chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these 2 sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It actually, it's a letter or a report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office And it is signed by Jerome Rem, R-E-M-M, Forensic DNA Analyst. It lists a number of items. $14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says that the testing was done. Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, 2 different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashley Benefield and 3 unknown persons.
So now I'm asking you that next sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and 3 unknown persons than if it originated from Ashley Benefield, John Sant, and 2 unknown persons. Therefore, there is extremely strong support that Ashley Benefield and 3 unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. And the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody a chance to argue.
Sorry.
So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next paragraph, the reason the fourth DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said two sentences. Yeah, these two sentences that are highlighted.
Correct.
But that's only one of the two sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
Can I make my record?
It would, if it would, So, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these two sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
It's 29, but this is the whole record.
Well, hold on. You're handing me a stack of paper that's about, what, an inch and a half tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those two sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. What is this in here? Or does this go in here?
Yeah, no, that I believe is in there.
No, those.
This comes back. Oh, I'm sorry, Ron, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
All right. Can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence. In this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
All right, thank you. Do you want that right after the first page?
You can put it right on top.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
so I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the 4th DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right. Well, there's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect. It was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
Mm-hmm. So do you have a...
We'll rest.
Okay. Let me bring the jury in. I will, we can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with a 9 o'clock start.
Yes, sir.
Yeah, the Walsh case is something I want to cover, Terry. Just not sure what's happening. Yeah, there is. Yeah, the Ricky, is it? But depends where they are right now with it. I might cover it a little bit of it in a quick way. Oops, hang on.
Requested copies of the proposed homicide charge, and we had submitted our version to you that we thought would be appropriate. And I did not save a copy of it, so I don't know if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
See you, Gary. See you later, Gary. What I'll do is, so they're on day 3 at the minute with that trial, so I'll see how long it's going to go on for, Lady Di. Because I might watch it whilst they're deliberating or something.
Welcome back, everybody. Y'all can have a seat. All right, did anybody do deliberations, talk with anybody outside the jury, or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor. Ms. Benefield has no further witnesses, and we rest on her behalf.
All right, sir. Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have the deputies come down and get you as soon as we're ready and bring you up and get started.
Yes, sir.
All right, remember the rules for tonight. Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening. Oh, you all can have a seat.
See you, Lady Di. Enjoy.
All right, I'm going to have to give you all, let me give you guys a 5-minute break. I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find.
Clip.
Yeah, it was. Yes.
And I have the state's proposed jury instructions and the standard for self-defense because it changed in May, and I just wanted to include it in case we need
So
to.
you got the new one.
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy so we could go through
And you
it.
have an extra copy for.
Yes.
So 5 minutes. I'll be right back down as soon as I check.
Thank you.
Let's see what happens here then. 7:59:30. So hopefully we find out how many witnesses there will be for rebuttal. Hopefully they tell us. I hope there won't be many. But we'll have to see. We don't know. Well, I'm waiting till they leave the court. Well, you'll be waiting a long time, Lady Di, because they are going through jury instructions now after this and talking about the rebuttal and stuff like that. So there's probably another hour to go tonight, people, just so you know. Probably another hour, I would say. So I'm intrigued to see the jury instructions because these are the important bits to see what self-defense, because as you just heard, self-defense has changed. The wording of it has changed since May in Florida. So this is going to be intriguing to see what is self-defense in Florida and what constitutes it and what did the DA office have to tick to ensure her that she is guilty? Well, what do they need to reach beyond a reasonable doubt to classify Ashley Benefield as guilty, basically? So after this, we might read it and go, "Oh fuck, they've done it. They've done it." You know, maybe some people will turn their from not guilty to guilty and vice versa. So Crafty Car, I watched most of day one of the firefighter trial, but it's not grabbing me. Ooh. After can't read, I'm listening a little closer to these people. I'll just say this to you, right? The most important part, people don't believe me when I say this, right? The most important part of a trial is the jury instructions. You cannot make a solid foundation. I know we put polls up about guilty, not guilty, but that's how you feel. You can only make a decision purely based on these instructions and whether they have ticked the boxes. The DA's ticked the boxes beyond reasonable doubt. So that's why this is super important. You should never make a decision about guilt, not guilty. Well, they should always be not guilty up until a certain point. This is the stage where you should say if they're guilty or not. That's crafty, you too, and I'm want to hear instructions myself. I know laws on DP changed. I don't know what else. DP, death penalty. I won't be able to watch the state closing if it's Steven Tyler. I don't think, seriously. I know it's tough, isn't it? Erin Haka, ole, 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 ole. Ole, 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 ole. Erin Haka, ole. Erin Haka, ole. It's a Boston trial, Joe. It's something Christine Ricky or something like that. She alleviated her husband. I think they're on day 3 or 4 today. What floors me is the jurors get copies of instructions in the deliberating room, reread them, because sometimes you have to understand, well, at least I have to reread at least. I'd have to reread everything before I make a thing. It'd have to be, right, do they take this? Ding, bing, 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 bing. Bing, 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 bing. Now, some states don't let you take them back with you, which is like, what? You what? Erin's dancing. Erin's dancing. Absolutely, you have to carry the instructions are beyond important. I always tell people you can't make a decision until you can have a feeling. I got a feeling tonight's gonna be a good night. Like tonight's gonna be a good night. And tonight's gonna be a good night. I got a feeling. Ooh. So beyond important, yes. They are very important. Multiple times, yes. I sent that, by the way. Yeah, I can't. I messaged you back. I can't join it. I've sent you screenshots. I can't join it. How do you join it? I logged up, subscribed, and it doesn't let me join any league. She's not guilty. Only my opinion. Yeah, Teresa, that's fine. But also make sure you listen to this jury instructions because this, once you read it or once you hear it, you might actually go, "Oh fuck!" Actually, they did do what they should have done. Not say they have. I don't think they have, but we'll see. What? I thought they had to at least. Not everywhere. Most people do. Most states do, but I think there's a few states that don't do that. But most modern states do it. Yes, I think Bev sent like 3 or 4 copies back and stuff like that. So they get the charges and stuff like that. Not always the. When I say that, like 95% of states do it. Look for it. Yeah, it's Boston one. It's in law and crime and stuff. I don't know. I'm probably not going to cover it. People say it's boring. There's no point. Love it. We love it. Hey, we love Dina. Hello, Dina, my darling. How are you? Hope you're well, my darling. I hope you enjoy tomorrow. Dina's out there tomorrow on the standout for, I'm not sure where it is, but shout out to you, Dina. We love it. Stormcat says, my mind has switched back and forth. Yeah, well, what I'd say is if it's back and forward, it's mostly not guilty. For me, once I watch a trial, if I reach guilty, I'm guilty. Do you know what I mean? Because that means no matter what, it's beyond a reasonable doubt. I can't change my mind. That's how I work it. So I always wait, listen to everything and go, did they meet it? Yes, no. After hearing this, so yeah, I could never say guilty and then come back type of thing. But we're all different. That's the beauty of it. Love it. Haha, love you, Amy. Thank you, darling. I'm here just for the singing. There we go. Hey, Dina, what charges will be on the table here now? Second degree murder. Hey, Dina, at least if the jury needs readback, they can have it in this case. Yes, they will have all of that. Yes. Bev's crying now. Hello. Tomorrow's a big day at the State House. There you go, Dina. Dina's out there. Dina's out there 3 till 6, I believe. We love Dina here. Dina's one of my favorite people in the world. So shout out to you, my darling. Everyone loves Dina here. Yeah, I tuned in and out of that Boston one. I just thought it was because I was going in and out. It was interesting, but I guess not. It wasn't interesting. Yeah, well, I mean, also it's day 4 now, so yeah, we'll find another trial. Patricia Vincent, hey. In my opinion, I'm not guilty. I'm not guilty at the minute because I don't think they've proven it unless they show me in these, unless they show us in these jury instructions something that we don't know. Because remember, self-defense means different things in different states. So, not guilty by thankful. There you go. Not guilty. Bev's crying now. Dina, hey Dina, good to see you from Lady Di. Yeah, 3 to 6 at the State House. We ain't got no quit. Let's fucking go, Dina. Love you too, Dylan. Love you, Dina. As always, make sure you send me some pictures. All right. Hello, Dina. Hello, Lady Di. Stormcat, I get it. I do not totally think she is innocent, but the state blew it. They blew it, Erin Haag says. 3-6 Boston. Governor Healy. Bev's crying now. These names, you people keep... Oh, fuck. Oops. You people keep changing your names. I always get lost, though. Greg's changed it to something ridiculous. Oh, shit. Oh, no. What have I done to my mic? Hang on. I think it's okay. Oh, no. Ah, motherfucker! I just fucking stabbed my thumb. You bitch. Oh, no, right. That did fucking hurt as well. Oh. I got blood. My nail came back. Oh, no. Oh, that hurt. That did hurt. I won't lie to you. That fucking hurt. My nail went back. Yeah, mother. Cheese and rice, people. Cheese and rice. Oh, I'm not touching anymore. Oh, I got blood. Not sure if you can see it. There you go. Can you see the blood? My nail went back. Oh. Oh, that. I just gone limp. Stop going limp on me. That's what she said. Hey. Oh, no. What can I do now? Why is this like this? I'm not sure what I've done. No. I think that's okay. Oh, we have 999. Oh, that I'm not happy with that. Right, hang on. Mighty Meat's messaging me, and if he's messaging me, Mighty Meat, I see that first box. No, bad request. Bad request I got from you. I'll sort it with you later. Oh, right. Anyway, it's warm. Do you know when it's warm? It's hot. It's hot. Zach, bit of sympathy, Zach. Fucking hell. Oh. Anyway, I'll man it. I'll man up. Cheese and rice. My husband and I a big office. British office, yes. American office, no. No, it's all good. I'll man up, as Zach says. Ah, cheapest creepers. I won't say what I was going to say. I won't say. But do you know what I mean when something's gone hot? Yeah, because Mike D, that what you sent me is what I got, but it's not where it ended up. Let me. Where's? Oh, darling, darling. Oh no, where's Mike D gone there? The first screenshot you sent me, right? I get that, and I put the password in, and I press the continue, but it takes me to where I. Oh, do you know what? Is it American League? Is it American League? I think that's what it is, Mighty. It's because it's America, isn't it? That's why. It must be. That's why. Baby, don't go. Baby, don't go. I know you hurt. You're throbbing. We'll kiss you better. We'll kiss you better. Oh, you're throbbing. You poor baby. You're throbbing. You throbbing. You're growing and throbbing. Whoa. Is there a doctor in the house? Not gonna lie, I'm laughing just a bit. Oh, you bastard. He wants a nursing uniform. Oh yeah, that'd be nice. That would be nice. Nursing uniform, chappy, call 1-800-Tinder. I know, I've not been on Tinder for ages. Not been on Tinder for ages. Suck your thumb. Oh, he wants the kiss of life. Yes, not kids of life. Yeah, it might be a USA thing. It is 100% because I with that.
This is you can have a seat, please.
I gave it to them, and this is the standard. I don't know if you need that, but I brought an extra copy. Okay, this is the state's proposed. If you have already a copy of ours, you can toss it because I made corrections. Okay.
And as we get started again, I was able to find the jury instructions the defense had handed up to me in the past, and I've had my judicial assistant run a copy and gave them back to the defense. And I think you had also given me this case, Gonzalez v. State.
The name alone.
Well, let me, it looks like the handwriting that's been on a couple of your other documents. And so let me give it back to you, and it might jog your memory as to why you gave it to me.
It's not my handwriting.
Oh, we'll wait. I didn't look over.
Yeah, so actually, I remember. I think Gonzalez was our consideration and debate about whether or not we could get a charge of self-defense based exclusively on the 9/11 tape. We're a long way away from that.
All right. Do we just toss that? Or you keep it? Okay, sure.
Ashley's not there, so actually Benefield's not in the court at the minute.
Just trying to see if I can write it.
I don't know. They did say they're going to put a rebuttal on, but they could change their mind. We'll see. They did say if Ashley does, they're going to call Eva up, but again, we'll see.
I just wanted to see if I had the right hat.
Well, let me show you. Yeah, let me show you what I gave to the judge.
I think it is, but me and my son used some of the highlights.
They've not said anything about rebuttal yet. They've not said anything. The judge will probably ask them in a bit. I obviously hope there's no rebuttal, but we'll see.
All right, Ms. Benefield is back. So we're going to take a look at jury instructions now. So make sure that All right, so defense, do you have a copy of the state's proposed jury instructions?
Yes, sir.
And state, do you have a copy of the defendant's proposed?
I believe we do.
And then I have mine that I did separately. If we could, I'd like to start with the state's version, and then when we get to an instruction defense that you have your own ideas or thoughts on, we'll see how we need to modify them or mesh them. So, Ms. Benefield, these jury instructions, as I've mentioned before, if I haven't, I will mention now, are very, very important. Too often, I think, people think of jury instructions kind of as an afterthought. But whenever we started this case, I mentioned to the jury, and I say this several times, they listen to the testimony and receive evidence. They listen to the argument of counsel, and they listen to the instructions on the law by me. So this is 1/3 of what they are supposed to look at and consider. So the way that it works is obviously the defense has prepared some proposed jury instructions. I've got some that I've worked on, and the state has theirs. The reason I'm working from the states is that's just how we've always done it, at least in this circuit. It's generally the state prepares jury instructions. We kind of work off those. So as we go through, some of the things that I've mentioned in the past or have talked about or will talk about become much more clear when you really see the jury instructions and this is what the law is. So, Mr. Taylor, the way I do it is I'm going to, again, work from the state's version, which you have, and I'm going to call out the number. I won't read the whole thing. And just let me know in this first pass as we go through, do you have any objections, additions, corrections, or deletions to the standards? And then we can, after we go through that first pass, then we can get into some specifics.
Okay, and would that include omissions?
Yes, absolutely.
All right.
So for example, the first one is 3.1, Introduction to Final Instructions. Any objection to that one?
No.
All right, so that's good. Looks standard. 3.2, Statement of the Charge. Any objection, correction, addition, deletions to that one?
No.
All right, looks fine. Now, 7.1, Introduction to Homicide. That is one of the ones that you provided to me.
And I think it's just the standard. Mr. Taylor, is it just the standard that you provided, or is there a difference?
No, I provided in my packet that I provided the court with, provided the standard.
Okay. So there's no, I just wanted to see if there was a disagreement because ours should be the standard as well.
Mm-hmm. So if you look at the.
But mine was not edited.
Understand? No, I see that. Yes, right. You just gave me, the actual printout that I look at from the Florida Supreme Court website. But so as you look at 7.1 as proposed by the state, do you have any objections to it?
Judge, the problem that I'm having with this is I haven't had time really to review this. So I can give the court an answer off the top of my head, but I don't know how I'm supposed to check for a misprint, a word that's been omitted.
I see what you're saying. This is why I call this my first pass. It's really a 30,000-foot overview. I mean, it's not uncommon right at the end. What you'll find is I have this thing about Oxford commas, and I think they need to be used. I don't understand not using them, but so there's quite a few places where we're adding commas and so forth. Yeah. Please don't worry about those kind of details. I'm just talking in general, and this is one, quite frankly, we can skip if you prefer. You want more time to take a look at it. That's absolutely fine.
No, with that explanation, then no objection.
Okay.
It's standard other than we added the charge and then
But if you see any typos or anything, overnight, just let us know.
Yeah.
All right, the next one is 7.4, murder in the second degree.
And the yellow were things I didn't know if they would be applicable, so just so we make sure we didn't.
I think as I look at this overall, it looks like you've got just the standard in there. It looks okay. The issue is going to be if you all want that highlighted portion, if you want the sudden provocation. And I don't need a final answer now. It's highlighted, so you'll be able to let us know if you want that or don't want that.
Okay.
It's in there for now. Possession of a firearm and discharge causing death, 3.3D should just be the standard 1020 life instruction. All right, 3.3D looks right to me. And in fact, the one that I have from the defense, page 7 of 28, except for typeface, looks exactly the same. 3.4 lessers. So this is page 8 of 28 on the defense.
I believe that that's the right statement as to the introduction of the lesser.
You don't have to stand. If you want to, that's fine, but
However, it's our position there should not be any lesser.
right. So are you prepared to make that argument now, or do you want to wait? It's up to you.
I think I can probably make it now, perhaps with the court giving me the consideration that if I think of something overnight, I might be able to supplement.
That's fine.
So we would cite the court to the Roberts decision, State of Florida versus Geraldo Roberts at 694, Southern 2nd, 825, second DCA case. It was a charge of attempted second-degree murder, aggravated assault, discharge of firearm from a vehicle, and carrying a concealed firearm. Reversed for the trial court's failure to give an instruction on attempted manslaughter and on definitions of justifiable and excusable homicide. But there is the statement made as follows. The trial court must instruct the jury completely on all necessarily included offenses, regardless of whether the facts of the case support the instruction. In this case, the trial court was required to give an instruction on attempted manslaughter and on the definitions of justifiable, excusable homicide. Trial court's failure to give the instructions is fundamental error and can be considered on appeal even though defense counsel did not object. And then they cite Rinaldi versus State, also a second DCA decision, 614, Southern 2nd, 1197. And parenthetical for what Rinaldi stands for is conviction for second-degree murder reversed because the trial court's failure to include definition of justifiable homicide as part of manslaughter instruction, even though defendant failed to object. they say this then at that point: the only exception to this rule is if defense counsel affirmatively agrees to the omission or alteration of the instruction. So, on behalf of Ashley Benefield, we request no lesser included offenses. We think this is an all or none. She either is guilty of second degree murder or she's not guilty.
State, do you want to be heard?
Just that we disagree. It's a category one lesser and the state's asking us to do it.
Okay. For right now, I'm going to tentatively say leave it in. But again, you want to look at some stuff? No, I'm familiar with the case though. Yes, sir. I'm very aware of those. You wanted some more time to look and see if you could find anything. So that's fine. Leave it in for now. And as I look at manslaughter, it does look correct.
It appears the manslaughter instruction appears correct to me. However, I'm just not sure about the applicability of the various subsections at this point.
All right, and then 3.3A, the next page is the aggravation for the, I'm sorry, did you say give you a minute?
Yeah.
Oh, yeah, of course.
Yeah, no, I think it's.
Oh, all right. Yeah, 3.3A looks like the standard. All right. Justifiable use of deadly force.
Excuse the boldness, Judge. I just don't think we got that far. Fixing it.
All right. I'm looking across 3 different pages here. Yes. All right, so here's, are you on 3.6F?
Yeah.
All right, so here's going to become the first issue. Right about the middle of the page, Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent, of course we know there's 2. I'm sure you want A, imminent death or great bodily harm to herself.
Yeah.
Are you also asking for an instruction on the forcible felony?
Absolutely.
And I saw that towards the end of your paperwork. And it looks like you're asking for, you see that state towards the back of their packet? Looks like you're asking for burglary, felony bat, ag bat, ag assault, false imprisonment, that looks like all of them.
Burglary.
Yes, yeah, I started with that one. I actually went from back to front, so.
Oh, okay.
Burglary, felony bat, ag assault, and false imprisonment.
I believe that's correct.
Sure. I'm maybe misunderstanding. Is counsel asking for all of those felonies to be included?
I think that's your starting point.
Yes.
All right, state, let's start off easy and ask, are there any of those forcible felonies that you agree with the court instructing the jury?
Before we get there, Judge, on the standard I gave you, can you read the sentence right before this paragraph? And it says the law on justifiable use of deadly force is as follows. And then it says, give if the defendant is relying on 776.0122 or 776.0312, but not relying on 776.0131. So it seems like now you're supposed to pick, because it is repetitive. Because that same language is in each section.
All right, 776.0122. It appears, I would say, that the defense is relying on 776.012, subsection 2. That's the self-defensive person.
It's the second part of that sentence. It says, but not relying on 776.013. And I believe they are relying on 776.013.
All right, that's protection in the home. All right, do you see what the state's saying?
Yes, I do. This is a rather unique factual situation. I'm not sure at this point I have an answer for the court.
All right, I'll outline it, and let me just say that having served on many rules committees in the past and currently serving on a rule committee, it is yeoman's work, what they do. And I can only imagine how many hours went into the criminal jury instruction committee putting 3.6F and 3.6G together. And I know sometimes we will fuss, or I will fuss, at the complicated nature of these jury instructions, but they really are good, and I appreciate the work of the committee. So to put it simply, on the standard jury instruction, from the part of give if defendant is relying on 776012 sub 2 or 776031 sub 2, but is not relying on 776013-1. Because 776013-1, as we know, gives even greater protections or establishes and explains the castle doctrine, from which Stand Your Ground expanded that castle doctrine out into other places. But I think what the jury instructions are saying in interpreting the case law is that if the defendant is relying in part on that home protection, 776013 subsection 1, a person who is in a dwelling or residence in which the person has a right to be, has no duty to retreat, and has the right to stand her ground and use or threaten to use, and then A, non-deadly, and B, deadly. And the reason that that distinction is made in these jury instructions is because if you're not, you automatically get those protections in the home, right? But 776012 is more of the general use or threatened use of force in defense of a person. And in that situation, the additional information that because it's not in the residence, the jury has to be instructed on the duty to retreat or the non-duty to retreat and a right to stand your ground if the person using or threatening to use deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. Obviously, because 776013 is in the home, which Miss Benefield was, would lend itself to the argument being made by the state that we would not have the first part of the standard, but we would skip down to give if defendant is relying on 776013 subsection 1, self-defense in the home, because it has all the same things, except now you're in your home, so the jury does not have to consider that you, whether or not you're engaged in criminal activity or whether or not you're in a place where you have a right to be, because you are.
Judge, what is 0312?
0132?
No, 7760312. It says, give it.
That's defensive property.
Property.
Yeah.
I remember putting the instructions together, but I didn't remember what the substance was.
So I think, and of course, it's imminent death or great bodily harm to herself or the imminent commission of the forcible felonies. And we still have to, once we determine which forcible felonies we're going to give. So
okay,
that's just me putting that on the record for future reference, posterity's sake. All right. The next one is.
So are we taking that first part out?
Well, I'm just putting what my interpretation is of these jury instructions and why I think ultimately we're going to give the second one, 776013 sub 1, as opposed to 776012 2.
Yes.
I don't think we've had any arguments about necessarily 782.02. Essentially, 782.02 is essentially a restatement of what we would cover under 776.013 sub 1. I think it's kind of duplicative. And I'm sure each side will have their own arguments.
And Judge, I think just for timing, I think we're gonna be closing early tomorrow. So I don't know that we're gonna have a lot of time to, you know what I mean?
I understand.
Okay.
I was going to ask the court, you already announced if we could close in the afternoon, so we'd be able to clean this up.
I'll just say that I was kind of leaning that way, that whatever rebuttal you want to do, cut them loose. And then whatever, we still got a end of the road JOA, if you want to make one.
Yeah.
And then I figure that's it. Now we know what evidence is in. We can put the final touches on everything. You'll have had this evening and tomorrow morning to look at these issues and get them finalized. Then you guys make the copies for us. I usually ask the state to make all the copies with and without verdict forms and so forth. And then come back in the afternoon, give them an early lunch. But if we send them away early, we can have them back at 1 o'clock, 12:30, whatever we want, to give you guys time to do your closings.
I don't anticipate rebuttal's gonna be very long.
How much time do you think you're going to want to ask for closing?
First and second together,
Yes, total.
probably an hour and a half to be safe.
Mr. Taylor?
I'll take that, but I doubt that I'll use that.
Yeah, I don't know that I will either.
So I'm glad you asked about timing. Yeah, I think you're right. That's probably what it's looking like. We'll be here first thing in the morning, any rebuttal, then rest, and then I'll let them go and tell them to be back, whatever makes sense, 12:30, 1 o'clock. Then we'll come back, then we'll stay, get all the jury instructions done. When they come back, we'll go.
Do we want to find out what the rebuttal is so we can make any argument if we have it before the jury comes in?
Yes, absolutely. Yeah, but let's cover that in the morning.
Okay.
All right, so we were on the 782.02. I'll let you guys argue, but I think that, that might be duplicative of what the instruction that's already going to be given from 776.013 sub 1. And then the next paragraph, in deciding, that certainly needs to be in there. Oh, that's where we left off. Were there any of those forcible felonies that you're prepared to agree with right now? That way it'll limit what I have to hear argument on.
And I just wanted to make sure I got them all. They were burglary, aggravated assault, aggravated battery,
Felony bat
felony bat.
and false imprisonment.
I thought I heard false imprisonment. I don't think I have that one, but okay.
Yeah, it should be in my package, Suzanne.
It might be, but I just couldn't find it. And Judge, to be honest with you, I've never had more than one felony read, so I don't quite know how to respond.
Yeah.
Typically, the defense will focus in on what they say the crime is and move forward from there, but.
Well, you guys both know, it's only the elements, right? The crime of burglary is the crime of felony battery, just the elements.
Well, we would need for this case in the burglary instruction to them that a remaining in burglary is the equivalent. Remaining in improperly.
Understood.
And Judge, I think remaining in improperly with the intent to commit a crime kind of covers a lot of the other crimes. So
I don't know if we can agree, because I don't think that I don't think that there is evidence that has come in of felony battery, aggravated assault. And then false imprisonment, I'd have to go back and read, but that one may have evidence of that. And then of the burglary, I'm not sure, because I don't know what the evidence came in that to commit a crime therein, stage to commit a crime therein, but I need to think through it. But I can say that I would almost guarantee we'll be objecting to ag assault, ag bat, and felony battery.
All right, so be prepared for that. I'm not saying you need to commit to it now. I want you both to be able to go back to your offices this evening. This is why I do this big overview. That way you guys can go back. You've already heard a little bit of each other's thoughts. Nobody's locked in, but then you can go back tomorrow loaded for bear. All right. Presumption of fear.
Presumption of fear.
Yeah, the 776013 sub 2.
I don't think this comes in because it's forcible entry into a dwelling, and I don't think there's any evidence of unlawful and forcible entry into a dwelling.
Yeah, I think I'm inclined to agree with that.
I think so. So that would be out.
And I think thereby the next section will be out too.
Yeah, which is the presumption does not apply if. So it's both ways. The presumption applies if and does not apply if. I think that can all be out. And then that last portion too, because it's all talking about by force.
And Judge, just so I'm sure that we're on the same page, that's the part that starts 776.0134.
Yes, ma'am.
Okay, thank you.
So the next part about 776041, there's certainly, it's only the one charge. There's no other forcible felonies.
And I think we can take vehicle out right above that too. The safety safe. But yes, I don't think any of this next part comes in.
Right, there's been, and I don't expect any evidence that the defendant was attempting to committing or escaping after the commission of some other forcible felony.
Correct.
So I think that's all out. State the next one regarding aggressor, and whenever the defendant, there's some evidence where the defendant was the main or initial aggressor, and then the force comes back when the defendant would be justified in using force when they were the aggressor.
I don't think there's any evidence.
I don't either.
I've already crossed it out, sorry.
Okay, is that all right? I don't recall any evidence that Ms. Benefield was the initial or main aggressor.
It's down at the bottom of the page. It says aggressor and then it says Gibbs v. State right above it.
Yes, okay.
All right, so that will be out. The next part is absolutely in.
Yes, I think
That's
the next two parts are.
the thrust of the defense. So prior threats is in. However, the reputation, I don't think there was any testimony regarding reputation of the victim.
Agreed.
So the next two would come out.
Yeah.
And then the physical abilities and all.
I'm sorry?
The last one's in everything. It's reading all cases, the physical abilities.
Yeah, physical abilities is in.
Absolutely.
And I will fix these tonight and probably email them tonight or tomorrow once they're all.
If you would, that would be great. I'd appreciate that. All right, so see, this is why I do this kind of general overview, so at least we can figure out where the touch points are for disagreement. All right, that's 3.6F. We're not giving 3.6G, right?
Sorry.
Use of non-deadly force. Everybody agrees.
Yes, yes.
Okay.
Sorry, I got confused.
No, I just want to make sure because there's some cases out there that talk about both of them. You give one, you give the other.
I think it says now in the new standard, it said at the bottom, unless evidence establishes force or threat was deadly and non-deadly as a matter of law. And then it goes on and says the discharge of a firearm, whether accidental or not, has been deemed to be deadly force.
I'm still going to belt and suspenders it and make sure everybody's agreeing we're not giving 3.6G.
I understand.
All right, so now this should be pretty quick the rest of the way. 3.7, plea of not guilty, reasonable doubt.
Yep.
All right. 3.9, weighing the evidence. Now, on this one, Ms. Benefield, of course, Mr. Taylor's has the copy right there. The 10 issues regarding credibility and factors for the jury to consider, 1 through 5 are given in virtually every case I've ever been involved in. We do 1 through 5. 6 through 10, however, really depend on the facts of the case and whether there's factual support for giving it. So 6, any evidence of 6?
No, the state doesn't believe so.
All right, 6 is out. 7, pressure or threat. State?
I don't think so, Judge. I think
Defense. Any argument you want to make about pressure or threat?
I don't believe so, Judge.
All right, 7 is out. 8, certainly 8 stays in because there's been some impeachment. So 8 becomes 6. 9, I haven't heard, there's been no conviction,
9
impeachment.
10 are out.
All right, don't expect any of that. And 10, we don't expect any reputation for truthfulness or honesty. All right. So it looks like 8 becomes 6, and that one will be good.
And then I just need to unhighlight the defendant. I always highlight that next part until we figure it out.
So yeah, page 2 of that is going to be unhighlighted, but needs to be given. The defendant has become a witness. And so, you already took out 3.9A?
I did.
Okay.
We fixed them last night.
All right. Mr. Taylor, because this is our first trial together, at 3.9, I stop. So for the initial instructions, I go all the way through 3.9, then I stop, and then I will explain the verdict form to the jury and go over it and explain how it works. That way you don't have to use your valuable closing time explaining how the jury verdict form works. You can just get right into it.
Okay.
When we come back, I'll touch on 3.10. And that looks fine. 3.11 cautionary. That looks fine. 3.12. All right, so 3.12, when then we come back and I give the final instructions, I of course read 3.12, but down at the bottom where it says it is as follows, I just tell the jury, I previously explained the jury form. All right, 3.13, submitting the case to the jury. Did you already take out the thing about questions?
Yeah, that's actually on, I think that's on rules for deliberation, which I already took it out. Is that what you took it from? But yes, I took it out.
Yeah, no, it's on 3.13.
Oh, okay, I'm sorry.
There's in 3.13, it's not in the state's version because they already took it out. There's the one paragraph in the standard that talks about questions that were asked during the trial by the jury but weren't answered. And I removed that because I don't allow jury questions. And then at the bottom, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. These exhibits will be sent into the jury room with you when you begin to deliberate. However, and it's up to you, we can craft this in here, but I usually ad lib at that point. For example, if it's a child pornography case, you got to come out and view it. If it's a CPT tape, you have to request to view it. In this situation, I would say we're going to send the firearm back with you. Is there live
There's
ammunition?
no live ammunition. We did not bring it.
Oh, okay. I thought there was.
Correct me if I'm wrong, clerk, but I believe it's all casings and expelled bullets.
So the testimony was that live rounds were found. There was a live round in the chamber and live rounds in the magazine, but those live rounds have not been introduced into evidence.
Correct. They were packaged separately by crime scene, and we did not bring them for that reason.
All right. So with that said, everything goes back,
And
unless you guys say something different.
No, I just wanted to wait because I know because it was a firearm, but I think it should be A, not B, and I'll just make it one paragraph.
Yeah. So usually if there's a firearm and magazines and live ammo, it's one or the other. Either you can have the firearm and the magazine, or you can have the live ammo, but I don't have that problem here. And then in closing, let me remind you, now the verdict form, aren't we going to need some special interrogatories?
Oh, yes. I'm sorry.
I was say mine is just,
It is. And I was looking at it thinking, wow, this is really short. Yes, sir. I'll fix it tonight and then we'll have to look at it tomorrow, but.
the one that we end up usually using, as you would imagine, the defendant is guilty of murder in the second degree as charged. And then underneath that are the special interrogatories for the 1020 life. Then you'll have B, the defendant is guilty of manslaughter, a lesser included offense, and there's the one interrogatory regarding actual possession of a firearm, and then C, the defendant is not guilty. So that's what it should look like. But obviously you've tried cases all over, so if there's that's the standard we use here in the 12th here in Manatee. If there's some other format that you used before you think is better, certainly willing to listen. All right, thank you very much for giving me that extra half hour and going over the jury instructions so we understand who's where. And if there's nothing else, Richardson, do you want to do that tonight or do you want to do that in the morning? Okay.
Judge, and I'm going to show them an exhibit I intend to introduce tomorrow, and they may have another. This did not become relevant until rebuttal. I mean, it's for rebuttal. It didn't become relevant until after the testimony.
Okay, so we have the two photographs for Richardson hearing.
Yes, sir.
And the rebuttal. Apparently, the state is going to recall Eva Benefield. The court may recall. It has been holding in abeyance my motion to strike her as a rebuttal witness.
Judge, and I can maybe simplify. I intend to ask her a question about this picture that I'm holding up. I intend to ask her a question about the pictures that were introduced by the defense of the gym pictures, just to ask her if she's familiar with those and when they were taken. And I also intend to ask her if her father was right or left-handed. And then that's all I intend to ask. So I don't know that sitting in would have tainted any of those answers.
All right, can I see the picture you're talking about? Is there an issue? What's that one marked? What number? State?
105. 105.
Was this one disclosed?
Yeah.
You got 105 or no?
Yeah, that's the photograph.
Right.
Just now because it was not relevant to rebuttal.
That's what I'm asking.
Yeah, it was not a discovery.
Okay, there we go. So we're going to include states 103, which we referred to as the modeling photo. 104 as the mugshot. And 105, I'm just going to call that one the boat picture or boat photo because they're on a boat. All right. Yes, sir.
What do you want to take up first?
How about the Richardson violation?
Yes. So they were never provided at all in discovery. Not only were they not provided, but let's be clear, because if I've learned nothing else, I've learned this. They weren't provided in a dump at any time. So we were completely unaware of those photographs.
And can I just ask, is that an argument for all three of the photographs?
Yes, we, to our knowledge, were never provided with that photograph either.
No, the reason I'm asking is because the mugshot photo was entered in the stand your ground. So I don't think that was.
Well, hold on. Let me keep some semblance of order, even though of the late hour. So, right.
I thought the mugshot's in already.
That's one of the two that we're talking about.
Yeah.
The mugshot.
So here's the three photos we're talking about for this Richardson hearing. States 103 is what we've been referring to as the modeling photo. Go ahead and pull them out. I'm so sorry, Madam Clerk. She asked if we wanted them, and I said no, and now it's probably better we do. That's 103. 104, been referring to that as mugshot, and 105 we're now referring to as the boat picture. And the mugshot, my notes are 103 and 104 were not admitted.
Correct, and that was just an oversight. They were published and we spoke about them, I just didn't say the words.
Correct. All right, so I have them up here if you want to review them.
And
I have them here if you want to review them.
would like to say the mugshot was disclosed in discovery. I can find the discovery page, the date stamp page if you needed to, but it was disclosed in discovery.
You can take those with you if you want.
Yeah, there was a companion photograph with this that they sought to introduce that we never got either.
No, it was that one.
So was this?
It was that one. Yeah. just
Oh,
those two.
okay, I could have sworn there were two. Okay. So, you want me to address the wedding photograph, the modeling photograph?
Yeah, all three of them. Yes, sir. You go through the Richardson factors with me on all three.
Okay. So, we believe it to be, I have no evidence to present to the court that it was intentional. We believe it to be inadvertent. However, the prejudice is substantial. And given the late hour of the introduction, we've never been advised and we've had no opportunity to meet it. And the trial is over.
All right, State.
Judge, speaking about them individually, and I apologize, I don't know which picture the mugshot is, but that was disclosed in discovery, so there is no violation. What we call modeling photo, I believe that's actually from the ballet pictures. That picture did not become relevant until the defense's case, and the defendant testified, and also Dr. Russell testified about seeing edema and swelling, and it became very important to show before this incident and after this incident what she looked like. And I don't know how that can be of any prejudice because it's a picture of the defendant. It's not like she didn't know it existed. And I don't know how the defense would have prepared differently. So I don't think it's a violation, first of all, because it didn't become relevant, and we introduced it at the time when it became relevant. And then as to the boat picture, I have the same argument that that did not become relevant until the defense's case. So therefore, we produced it as soon as it became relevant or very close thereafter. So it was no violation to begin with.
All right. Tell me about what is the relevance of the State's 105?
The relevance is that the defense put in pictures of the victim at the gym to show that he was all muscle bound and, to try and show. Those pictures were taken in 2018.
Which pictures?
The muscle bound pictures that the defense put in.
Okay.
That picture was taken a month before he died. He did not look like those pictures that the defense entered in 2018.
How do you know he's got a shirt on? I mean, if you look at his arm, the vein is bulging on
And
his
that goes
bicep.
to the weight, not the admissibility, Judge.
When did you become aware of State's 105?
Last night.
All right. Final thoughts to the objecting party.
Put in about Mr. Benefield, how he was billed were in May of 2020, not 18.
I don't recall that evidence coming in. The date of them?
I'm just informing the court. The representation was that they were taken in 2018, and we're telling the court they were taken in May of 2020.
All right. And just so you all know, and what I'm saying to that is, as someone who hasn't been involved in this case as long as you guys have been and don't know all the details of it, I don't recall that testimony when the photographs were put in. I don't think the date of them was established.
I'm just correcting the representation that they were from May of 2018. I'm telling the court they were from May of 2020.
All right, thank you both very much. So in a Richardson hearing, obviously we talked about it before. The issue is whether it's willful or inadvertent, trivial or substantial, and what prejudice is being suffered by the non-offending party. That is the one that's opposing the introduction or didn't have the information or exhibit. I'm going to start with 104. Actually, all three of these have a different analysis, unfortunately. And I'll just mean that because that means I have to go through it 3 different times as opposed to giving you just one simple analysis for all 3.
Judge, I'm sorry.
Yes.
I just want to make sure. We haven't yet discussed the Richardson analysis for the modeling photo, have we?
Yes.
Oh, then I do want to add something.
Oh, please, yes.
Yeah. The prejudice to us. So the court may recall in my testimony, I specifically pointed out the drooping eyelid and the space between the brow and the eyelid. And the prejudice to us is going to be substantial because they're going to now introduce this picture taken at a completely different time with makeup and everything else. And they're going to argue that she looked like that here. Therefore, you can't believe what they said about the photo that was introduced, that was taken by the sheriff and staged on that day. That's going to be substantial prejudice. Yeah, and one other thing, Your Honor, about the photo with the daughter and the father. No, there's a sympathy factor about calling the daughter to begin with, which was why we objected. So now this is a second bite of the apple. And if they want the photograph really just to show that Doug, by some crystal ball, they know he's not built like that underneath his shirt, then they should splice the photograph and remove Eva from the photograph if it's just to show Doug.
All right, thank you both very much. So 104 is an easy call. 104 is the mugshot, and that has been disclosed. It was used at the Stand Your Ground hearing, and in one of the more recent pretrial hearings, this in particular was one of the issues we talked about, and I was on my way to ruling that the state could not use it in its case in chief, but could use it in rebuttal, and that's where then one of the two of you jumped up and said that was your intent anyway, was to use it during rebuttal. So I don't find that there was a Richardson violation. That's been disclosed. It was discussed multiple times as this case is going on, so there is no prejudice there. As for 103 being the modeling photo, when did you get this picture?
It was I think it was the night. It was either the night before her, at lunch. It was at lunch during her testimony.
I found it on the internet while we were eating lunch and then turned it into an exhibit.
And tell me your prejudice for this again.
I had specifically pointed out when we put Ms. Benefield on the stand, where the slap was up inside the left side of her face, and asked her about whether her eyelid was, it reflected a droopy eyelid and swelling in the space from the eyelid to the eyebrow. And the state is now going to use that photograph to argue that that wasn't the case at all. There was no swelling, no damage, because here, take a look at the eye in this photograph. It's exactly the same.
Judge, I think that's.
And then they might just add, can I put this on the record ex parte? I don't want to help the state in their closing argument.
Okay.
Okay, not long to go now, people. They got to greet these photos, and then see if Eva's allowed to testify tomorrow. And yeah, we'll go from there. Oh, I don't know, people. Getting tired now from her on nearly 9.5 hours now. Whoop, here we go.
All right. Surprisingly, I find this to be a much closer call. It's difficult to say that it was willfully held by the state because they didn't get it until the lunch. Well, direct happened in the morning, then we took a lunch break, and then cross happened in the afternoon. Let me ask you this, State, and I hate to do this because I know I'm usually very specific about I want to hear all argument and then I rule. When you procured State 103, you come back over. Did you show it to the defense prior to beginning your cross?
I did. Both of those pictures.
I'm sorry?
I showed them both of them.
Both of them?
And Judge, I just want to also add, the defense saying that they would not have spoken about the swelling on the side of her face, that same argument goes for the mugshot. And they had every reason to know that I was going to try and put the mugshot in after she put it into evidence. So I don't know that argument necessarily holds because they were on notice that I was going to make this argument, just maybe not with that picture.
All right. I do want to give you the final shot, though, since you're the objecting party. Anything else?
Well, the mugshot is 6 weeks later, and you can't discern from the mugshot what you can discern from this photograph that we are discussing now. Again, the composition also of the photograph is different. This one is heavily with makeup.
I think that goes to the weight, not the admissibility. All right, so the state didn't have this until that day. They showed it to the defense prior to beginning their cross-examination. The purpose is not, I characterize it more as a rebuttal piece of evidence based upon the defendant's claim about the slap and so forth. And I understand why the state wants to use this, because they have 104 is coming in, which is the booking photo. But I look back at my notes just to see about 103. And on 103, when it was authenticated by the defendant, it was a modeling photo, and it was taken before she even met Doug, are my notes. So I have to find that there's some sort of prejudice and that the defense would have changed or been significantly different to meet that prejudice. And I just can't say that I find that, because the issue of the swelling above the left eye has been an issue since the stand your ground. And all 103 does is show the anatomical structure above the left eye at a time before she even met Doug. So I can't find that there's a Richardson violation. So 103, over the defendant's objection, is admitted. The predicate was laid. For 105, this is, again, it's difficult to say that it was willful because the state just obtained it yesterday or the day before. When's the first time you disclosed it? Today?
Today.
Well, I'm sorry, that's not 104. I apologize, Madam Clerk. 104, I found there was no Richardson. It is received.
Tomorrow.
No, I'll just do it now.
Okay.
103 and 104 received. 105. I don't think, first, so I can't find that it was willful. Trivial or substantial, I think it's certainly the relative size and physical abilities between the defendant and the victim is an issue. And the defendant has the photographs, whether they're from 2018 or 2020, the photographs of Mr. Benefield working out, where he is in, to put it mildly, extraordinary shape for a man his age. So I don't think it's unreasonable for the state to want to put in a photo of what he looked like a month before his death. I think it's goes to the weight, not the admissibility of the photograph. With the argument between the two parties, defense can argue, yeah, but this shirt doesn't show him ripped. These other ones show him with his shirt off. They can make that argument. The state can argue that he wasn't as ripped and strong as he was in those photographs. But I don't disagree, and I've done this before, where editing the photograph for the fact of having his daughter in, and it's going to come out that there was a month before a month before his death. They're both smiling on a boat, having a good time. I think there's some, not the prejudice as preparation prejudice, but no, this would need to be.
I didn't get to respond to that. Can I just respond?
Yeah, go ahead.
Judge, I think the relative size of the victim to his 15-year-old daughter is very important in that picture, because they know, the jury knows that his daughter was only 15 at the time that this picture was taken, and I think it helps gauge his size at the time of murder, very shortly before. And if you crop the daughter out, there's nothing to gauge.
All right, I appreciate that. Overruled.
She was 19 at that photo.
Either way. Now, the question for you is, do you want this in?
I can crop it and print it out on a big piece of paper.
It's already been done.
Well, I was,
It's already done.
okay.
Right.
Oh, were you asking if I wanted the other half?
Yeah, do you want the other half?
No, I'm sorry. I didn't understand what your question was. I'll take the other half.
Well, I didn't know if you'd want it in the record, because you're saying you want it in. Do you want it in?
Oh, we can just put it in the record then. Thank you.
Can I call that one 105A?
A, yeah.
That's going to be State's Exhibit 105A. It is not entered. So the only ruling I've made at this point is 105 is admissible as I have cropped it.
Okay.
But we still have the issue of you want to get it in through Eva,
Yes,
Benefield,
yes.
and you're objecting her being recalled. So we still got to get that issue.
Yes.
All right.
Object to being recalled on two bases. One, sympathy factor, especially balanced against the probative value of this photograph, which is anybody's guess because he's got a shirt on. And two, based upon the hearing that we had.
Did you do any additional research on I made the ruling about the interview, right, that happened in the hallway?
Yeah.
All right. You had started to bring up some other matters, and I don't know if anything ever happened with that. No?
Yeah, I left it alone, I think, because she said she took the posts down.
Took them down. All right. All right, be heard on whether Eva Benefield, now, the rule of sequestration was applied.
Yes.
She was not released from her subpoena,
Correct.
but she was allowed back in the courtroom pursuant to Marcy's law.
Yes.
As next of kin.
Yes.
All right.
And I think the entire reason for the rule of sequestration is to provide fairness. So witnesses can't hear what the other witnesses are going to say before they testify and where it may taint their testimony. I represented to the court like 4 questions I will have for her, and I don't think that any of those would have changed based on anything that she would have heard in the courtroom anyway. And even that being said, Marcy's law has shown that her right to be in the courtroom is more important than those types of issues anyway. So I'm not really understanding the defense's argument about her coming back in. And there are issues that are relevant to the state's case that the state wants to ask her. So I don't understand the sympathy argument.
All right, final thoughts, sir.
I think the sympathy argument is pretty obvious. And they already put her up there one time. So now we're going to put her back up there a second time. Marcy's law allows her in the courtroom. It doesn't allow her in the witness stand.
All right, thank you both very much. I made the findings the other day regarding what I understood to be about the brief interview that was given in the hallway. I believe there was an admonishment and she was allowed to remain in the courtroom, although I will say she was kind of in and out. I don't find that it's overly sympathetic to recall her as a rebuttal witness to authenticate a photograph. You said something about the gym photos?
Right. She was going to talk about the gym photos.
How so?
When they were taken.
All right. And then right or left-handed?
Yes.
That doesn't sound like anything that would necessarily pull at the heartstrings. I will say this, obviously on that boat photo, it doesn't need to be, was that the last time you went on a boat with your dad and, you missed those times? It needs to be, when was this photo taken? And then you can make your arguments however you want to interpret it during closing. because that could be overly sympathetic to kind of dredge up those sorts of emotions.
Understood.
And then right or left hand, I don't see anything that's overly sympathetic or I'm in my head, I'm doing a 403 analysis. So I think the probative value is not substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading of the jury. And I don't find it to be needless presentation of cumulative evidence. So you may recall her for those limited purposes.
And Judge, if I could just see the picture where you cut, I'm cropping, could you see a picture of the digital file? Oh, that's exactly where I am. Yeah.
All right, if that's everything we can handle tonight, you all are free to go and we'll get started tomorrow morning.
Okay, I think we're done. They did say it's going to be a short rebuttal. Short rebuttal tomorrow. Then they'll be sent away for lunch. And then what's going to happen then is closing arguments are going to happen in the afternoon, I believe. So they should be finished by 4 o'clock if they take the full 3 hours plus a break, probably. So I'm not sure if they're going to start deliberating straight away or not. They have to decide whether they're going to allow the manslaughter charge in or not. In my personal opinion, they shouldn't, but we'll see what the judge says tomorrow. So that's what they're going to do tomorrow after the rebuttal. Again, I don't think rebuttal is going to be that long, so we'll see. He is hoping to get closings started about 1 o'clock ish. So 1 o'clock sounds reasonable. Both sides requested an hour and a half each. Just remember, difference here to compare to Karen Reid and Judge Bev is that the state will be going first, then the defense, then the state again, and the state will have a total of an hour and a half. Oh, they finished, right? Okay. Yeah, so that's how it'll be there. So the state will have the last word, first word and last word, just so you remember that. That is the only difference, just in case that you don't watch trials. That was interesting right at the end there. That was interesting to watch that, about the evidence coming in. Hour and a half, Bev taking note. Yeah, what I liked about it, Stacey, was he asked them, how long do you need? And like they said, an hour and a half tops. Probably don't need an hour and a half. That's reasonable. I said that both sides should get 2 hours for Karen Reid because it's a 10-week trial. So, Stormcat, good night to you. Sarah Boone, yeah, I know. We'll be covering that. There's a few trials coming up. We'll see. I'm not sure when they're going to start deliberating, whether it's going to be tomorrow or whether they'll come back fresh on Wednesday. A part of me thinks they might come back fresh Wednesday, maybe. If they finish at 4 o'clock, will he send them? I don't know what they do in Florida. I don't know. I don't know if they'll send them back to deliberate on whether in Florida they allow them to carry on or whether they have to go home by a certain time. I don't know the Florida rules. The last one I watched in Florida was Travis Rudolph and Scott Peterson as well, and both of them were finishing like 5 o'clock. So, Lady Di, no, thank you, my darling, for being here. If my boss complains about non-production of work, I'll tell her to send you the bill. Okay, great. I'm just kidding. No, it's all good. Right, thank you, everybody. It's been, well, nearly now 45 minutes. So, pack your bags, Greg. Thank you, everybody. Right, I'm going to put the outro on. Good night, sleep tight. We meet again tomorrow. Yeah, 8:30 Eastern, 1:30 UK time. I'm looking forward to Alexi Treviso, and I hope she gets out under the jail and or prison. I don't know who that is. Alexi Treviso, I don't know who that is. But I'll look it up, Heather. Don't worry, I will look it up. Potty Mouth, catch you later. Jem, see you later. Joe, see you later. Yeah, see you later, Bev. Shit, I sat on the couch after work and fell asleep. Hackster, you lazy bitch. Thank you, Amy, as always. So, thank you, Jim, I think, similar. Lisa, thank you, my darling, as always. Lady Di, thank you. The baby one. Thank you, Stacey. Right, I'm gonna put the short version on for you as an outro. Right. Good night, everybody. Love you all. Thank you for being here. I do really appreciate the support. I do. Thank you very much. Take care of yourselves. Good night.